Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are continuing our deep dive in the Charles Jones, Julio Foolio murder trial coming up. And I'm glad my audio works. So welcome in everybody, get comfortable, settle in. We are going to be streaming for a good 7 hours today. Pretrial hearings in the murder trial of Charles Jones. So we'll see you in a little bit. All right, welcome in everybody, welcome in. Let's get settled in. Let's see who's with us today. Hope you guys had a good weekend. It is Monday, April 20th, 2026. Heidi, Wizard of Ezzy, good morning to you guys. Hope you guys are doing well. Radioactive, good to see you. Gimbers, Hector's mom, good morning to you. Shoshana, good to see you. YT Hazel, welcome in, welcome in. Good vibes only. Thank you for the cups of coffee. Appreciate that. Tammy, good to see you. Jackie, good morning to you. Kim Hastings, hope you had a nice weekend as well. We had a nice relaxing weekend. We did a lot of work, as you'll see in a second, but it was still relaxing. Hey, Linda, how are you? Good morning. Iowa Backyard Cam, I hope you have a little bit better weather today, not so violent as it was last week with the hurricanes, with the tornadoes. Richard in the kitchen, good to see you. Downey Lynn, good to see you. Bama Green Eyes, hello, welcome in. Steffi, good morning, good morning. Nana, good to see you. Jane, I think while I was sleeping last night, winter came back. It's 39. It was 90 on Saturday. Yeah, we hit 91. It's really nice outside right now. It's like 30% humidity, just really beautiful outside. Pamela, good morning to you. Thank you for joining us. Linda, good to see you. All right. Elaine, good to see you. Welcome in. All right, guys, get settled in. I worked on a timeline for you guys. So here, let's check this out. Now, the state is going to be introducing 6 key moments in their case, right? So their case in chief is going to include 6 moments in this ongoing feud between the two, ATK and KTA. So what I did, I added what Aaron and I thought were 6 more really huge moments. And to me, it really all kind of started out with Aiden McClendon, and 22-month-old little boy. He was erroneously shot, and unfortunately he died. But he was cousins with Reginald and Noah Williams, who that's Wappa with the Choppa and Spinabens, respectively. So I think to me that kind of started it. And then if you look at the timeline, so yellow is going to represent Ace, which is Yungeen Ace, Keontae Bullard. It's like his crew, so that's 1,200. So yellow is KTA, and then ATK, and then blue is KTA, which is Charles Jones or Julio Foolio, and that's the 6th block. That's the Hilltop Apartments. So you've got Aiden, unfortunately, getting shot. And actually, it was not meant for him. They were trying to get somebody else, but he just happened to be in the car. Then you've got, that's 2016, January 29th. And trust me, there's so much that goes on in between. These are just, to me, like, I hate to say it, but like the highlights, if you want to say the lowlights. These were the moments. These were like the huge moments in this history of this war between these two rap gangs. And again, there's tons more that happened, but this is what we thought were the highlights. All right, so then May 27th of 2017, you've got Zion Brown. He's cousins with Charles Jones. And the shooter there is DeAndre Thomas, or Trey Shorty. And then we go to 2018, and this was huge. This was the Wasabi restaurant. This was 23's birthday. They're going out for his birthday, and you've got Yungeen, you've got Quan, the brothers, you got Kobe, and you got 23. So 4 shot, 3 dead, as Julio sings in his song "When I See You." So that happened June 5th of 2018. Then you've got Corbin Johnson, and Corbin he goes missing on July 11th, and he's found July 11th of 2019. So he goes missing July 11th of 2018, and then his remains are found July 11th of 2019. And he was only 8. And you see, these guys are all like young, other than Aiden, who was 22 months. But 18 years old, Zion. Corbin's 18 years old. Then we go, now here's where the state's going to start to bring in there. So the state comes in at 2019. That's when the state comes in with Bibby. So Adrian Gaynor, that's when the state is going to say, because this feud started, as we saw, well before 2019, but this is where they're bringing in, this is where they're going to start their case as far as the timeline is concerned. So Bibby is huge. He appears in the Who I Smoke video, and he was 16 years old. And the shooter there is Queso, or Hakeem Robinson. We know Queso from, he was on trial. Remember, his dad testified against him, Blue. So Adrian Bibby, he's taken out February 25th. And these are all KTA guys. And then you've got Tiki, and Bibby was shot at the Hilltop apartment complex. Then you got Tiki Williams. He was 19. He's a close friend of Charles Jones. And his shooter is unknown, so we don't know what happened with him. And Bibby is going to be brought in on the state. Then we've got Gerard Adams, or Spaz. Now, state's going to bring this in August 25th of 2019. Again, he's 19 years old. He was shot and killed at a high school football game. And Robert Howard. Now, here's what's really interesting. Robert Howard, also known as Kenny Caps, he pled guilty, but he proffered that Bibby was the shooter, right? So I just kind of found that out like last week into the weekend, and we talked to Florida PI Sam about that. And here we thought Bibby, 16-year-old, wasn't really involved with this, but apparently, according to Robert Howard, he was the one that did the shooting. But Robert Howard took the rap for it. So that's going to come in as state's evidence. Then we have Denitri Mixon, also known as Lil Nine, and this is in 2020. Now, Bibby, Tiki, and Lil Nine, they all appear as a diss in Yungeen Ace's Who I Smoke. If you guys remember that video that we covered that quite extensively last week in a couple of our deep dives. So those three were prominently featured in the Who I Smoke video. So Lil 9, he was only 18. He's a close friend of Charles Jones, and that shooter is unknown. All right, so now here's really where the state's going to rely. So they're going to come in with Bibby, they're going to do Spaz, and then here's this is all state's evidence. So 2023, Jaquan Pickens, also known as Jake Jit, he gets shot August 16th, 2023. He was only 19. He was shot and he was driving on I-95. He gets shot, crashes into a semi-truck. Shooter there is unknown. Then we have Jacoby Beals, also known as Lil Kobe. Now he's the next day, right? You have August 16th of Jake, then you've got Kobe August 17th. So he was 19 years old. He's cousins with Darius and Maliki Beals. And this was a retaliation for Jake's shooting. And the shooter, again, is unknown. Then we go to Antonio Tilley, or otherwise known as Tilley. He's October 6th. He was only 19 years old. This is allegedly a $20,000 contract hit for dissing Adrian McKenzie, also known as BGYBZ. So he's the one where he was set up in the Uber driver. If you guys remember our deep dive last week, we talked about this, where Tilley took an Uber over to a house, and Jaquan Mills jumped him, shot him, and shot the Uber driver as well. And then we go to 2023 again, October 7th. So just like a day later, actually, I think it was like 5 or 6 hours later, Charles Jones is shot. This is where he's shot in the foot. Now, he's shot multiple times, right? He was shot in Houston. He was shot in Jacksonville. This is where he got shot in the foot. He was shot at coming out of a studio. Apparently no injuries there. And then, of course, his final shooting is where he passes away. So he was 25 at this point in time. He's shot in the foot, leaving his residence, and the shooter is unknown. So those 6 the state is going to bring out. So we'll play these again as we go through trial. But I just wanted you guys to get a handle on this timeline of ours. So, all right, let's get to our stream today. Let me come on over here. And we're going to continue on with pretrial hearings. And we're going to start with March. So we ended up last Friday, we stopped in 2026. We did February, a couple Februarys, and a March 1st. So we're going to do a March 3rd hearing. This is more to suppress evidence. All right, so this is going to be from March 3rd. Let me just pin this here. Hey, Hell Rider, hope you're having a good one. Let's see. So this is 03/03/26. Hearing to suppress evidence. Yes, Afroman is having a good day today. Afroman is having a good day today. All right, so this is from March 3rd, 2026, and it's a hearing to suppress evidence. Hey, Anthony, good morning to you. Good to see you. Tosh, good to see you. Just want to make sure I get everybody. It's great. How are you? Good to see you. Welcome in. Welcome in. All right, I think I got everybody. Jane Dixon, good to see you. All right. Kelsey, good to see you. All right, let's get to this.
Remain seated. Come to order. Court is now in session.
Good morning. Hey, good morning. All right, good morning, everybody. States here. Defendants Rashad Murphy, Davion Murphy, Sean Gathright, and Isaiah Chance are all here. Good morning. Defense counsel's present. Are we ready to proceed?
Judge, can I address the court just briefly on what's happening today, just so I can clarify it
Sure.
in mind? As I understand it, Judge, we are going to be arguing the motions to suppress.
Correct.
That were, testimony was taken last week.
Correct.
We're going to do all the capital and phase 2 motions.
Yes.
And then the balance of the motions in limine and those related to the gang history, they're going to be done in conjunction with each other on Friday.
That's my tentative plan.
Okay.
Does that work?
Yes, Judge, that would be my preference.
Okay. And, all right, very good. So, on the motions to suppress, do you all have a preferred lineup, or you just want me to pick? Anybody? Okay. All right, Mr. Gonzalez, you're closest to the podium. So, all right, let me just take a look here.
Motion to suppress statements, Your Honor?
Sure, we've got the motion to suppress the cell phone and the motion to suppress statements. So why don't we kick off with the motion to suppress statements? And I'm going to give each side 30 minutes total. So, okay?
Judge, as it relates to Defendant Rashad Murphy's motion to suppress statements, we are seeking to suppress statements made incident to an unlawful interrogation that took place on July 30th, 2024. If the court might remember, this began with the silver Chevy Cruze having been found in Gwinnett County. Mr. Murphy was driving the Chevy Cruze. After he fled from the Chevy Cruze, he was tased and taken into custody. And again, this was in Gwinnett County. At that particular time, as the court will remember, the Chevy Cruze was the evidentiary basis at that particular time. There had been no additional evidence that had been determined relating to Rashad Murphy. And after his being detained in that particular case and arrested for a misdemeanor in Gwinnett County, Detective Ramos and Detective Campbell traveled from Tampa to attempt to take a post-Miranda statement from Mr. Murphy. He was given Miranda advisements as testified to by Detective Ramos, and essentially he testified that there was no evidence at that particular time. They were in possession of no evidence at that particular time linking Mr. Murphy to the homicide. This was simply an alert on the car based on surveillance footage that had been obtained, as well as license plate reader information. During the course of that initial statement on June 26 of 2024, Mr. Murphy clearly and on multiple occasions invoked and requested to have a lawyer, went so far as to say, hey, look, when I get a lawyer later on, I'll reach out to you guys. But at that particular time, Detective Ramos ceased his questioning, and he and Detective Campbell left Jacksonville. It's important to note that during the course of the gathering of this evidence, Detective Drabick had assumed the role in Jacksonville of keeping in contact with Detective Ramos on a regular, I think they almost called it a live basis, updating each other on what was going on and what was happening as evidence was being developed. Detective Drabick also was made aware that Mr. Murphy had invoked in Gwinnett County. So move along to July 30th, which is approximately 30 some odd days later, and at 3 o'clock in the morning, Mr. Murphy was arrested on these charges, which had already been. I also want to note, Judge, that when Detective Ramos went to Gwinnett County, he made it very clear that he was speaking to Mr. Murphy about the homicide in Tampa. It wasn't as a result of the misdemeanor arrest that he had incurred when he was in Gwinnett County. So at 3 o'clock in the morning, and certainly in an interrogation not initiated by Mr. Murphy, Detective Drabick provided Mr. Murphy with acknowledgments or advisements as it relates to Miranda, and obviously at that time was fully aware that Mr. Murphy had previously invoked. And looking at Detective Drabick's deposition on 210, 211, I wanted certain times, I want to phrase exactly what Detective Drabick told Mr. Murphy. I asked in the deposition, is there any reason why you attempted to interview him after you already knew he had asked for counsel and invoked? And he said it was because it's a separate incident. And I asked the question, a separate incident or a separate interview? Because you were inquiring about the same thing that Tampa Police was inquiring to, right? And he said a separate interview for sure. The first incident, I do know he was under arrest for charges in Georgia. I wasn't present for that interview. So I can't really say for certain what he had actually invoked to. Well, Detective Ramos made it very clear in his testimony that he had indicated to Detective Drabick that he invoked as it related to questions being asked about the Tampa homicide. Essentially, moving forward, Judge, I note that Detective Drabick's posture at that stage of the game was essentially to tell him, and this is our quotes from the interview itself, that, listen, before I can speak to you about obviously whatever conversations we have, I just have to read you this first. If you have any questions at all about it, just let me know and I'll be happy to explain it. But directly after making that statement and the defendant saying, yes, sir, he doesn't, Detective Drabick that is, indicate or ask Mr. Murphy whether he is willing to waive those rights and speak to him. He goes directly into, okay, print your name here, print your first and last name, sign your name on the line, and then once you do that, I'm going to write my information. At that stage of the game, Mr. Murphy says, I'm shaking, I'm cold as hell, and Drabick says, well, you know, it's 3 o'clock in the morning, you know, I get it. Detective Drabick then, during the course of the interview, as set forth with particularity on page 6 of my motion, says he raises the Tampa detective's absence from this interrogation and states, and the defendant clearly states, look, I don't want to talk to them. I don't want to speak with those Tampa detectives. And there's a dialogue between he and Detective Drabick about why, and Mr. Murphy is clear about that. And that is found at page 13 and through 15 of Detective Drabick's deposition. Detective Drabick then distances himself even further from the investigation and emphasizes that, listen, Jacksonville's got a limited role here, stating that, we just were asked to step in. We didn't do any investigation in this case. I used to, work homicides, but I don't do that anymore. And I probably wouldn't even be able to call you out on anything because I don't really know anything about this case. And that also is set forth on page 17 of Mr. Murphy's interview. Mr. Murphy goes on then to deny any involvement in being in Tampa, and Detective Drabick starts to take another tact by suggesting he's the mastermind of this and describing what other people are saying about him, and going on to say this is going to be the most important conversation of your life, and that others in these kinds of rooms with their life on the line, who knows what they're going to say. And again, that portion of the interview is set forth on pages 63 and 64 as set forth word for word in the motion. Then Drabick goes on to talk about the strength of the Tampa investigation in detail, talking about it being a fucking full meal deal, and that this is Tampa's investigation, not Jacksonville's. I'm not bluffing you because you've never seen an investigation and an interview being done in Tampa. I mean, you've never seen one of those. You've never been a party to one of those interviews. That Tampa has this thing and has done things that I don't even know existed with investigations. They're big wigs, and that, it's like in the fucking movie. So he goes on to, again, distance himself from the Tampa detectives, distance himself from the interview. Mr. Murphy at that time thereafter admits that he was in Tampa, but arrived after the shooting and essentially states that he has no involvement in the shooting itself. Judge, suppression is required under the totality of the circumstances based on four independent but interrelated reasons. Number one, law enforcement's minimization of the significance of Miranda, diluting what Miranda provides to a defendant when it's being administered. Number two, when officers fail to secure an express and affirmative waiver. Number three, when law enforcement employs a coordinated, like a multi-agency type of strategy that leverages the defendant and plays upon his mistrust of the agency doing the investigation. And finally, independently dispositive, but certainly I'm discussing these issues in an interrelated fashion, is that when the defendant previously unequivocally invoked his right to remain silent, before substantive questioning happened on July 30th, that needs to be honored. And in this particular case, in addition to it not being honored, it actually was leveraged in order to get Mr. Murphy to talk. Judge Edwards versus Arizona, United States Supreme Court case, talks about the two-part test to determine the admissibility of post-invocation statements. And those two-part test is, first, that the defendant must reinitiate with the police, which did not occur in this particular circumstance. And second, there must be a valid waiver of Miranda rights already invoked. And certainly that waiver can only be found if the individual is the one responsible for reinitiating, which is not the case in this circumstances. There's no question that Mr. Murphy previously invoked. There's no question that Detective Dravick was aware of that, and that Detective Ramos had indicated that that happened. Understanding, Judge, and I can't say I'm oblivious to the fact that the Supreme Court has also talked about whether and when there's a sufficient break in custody that could permit a reapproach of the defendant if he has the opportunity to shake off the coercive effects of either a prior interrogation or the fact that there was an invocation. Here, there was about a 30-day period in the interim. Regardless of whether or not case law permits that renewed contact, the state still bears a really heavy burden to prove by the preponderance that the defendant's waiver was made voluntarily, it was made knowingly, and it was made intelligently. And I cite Hall at 248 Southern 3rd, 1227, which is a First District case, 2018. In this particular case, what occurs is that the interrogation shouldn't be considered as separate interrogations. They don't exist in a vacuum, especially in these circumstances. When we talk about what voluntariness there was in the waiver on the July 30th incident with Detective Drabeck, it's my belief, and I think that the evidence would support, that Detective Drabeck employed a coordinated multi-agency effort to distance himself and create a misconception in Mr. Murphy's mind that speaking with these Jacksonville officers was distinct and was distant from any cooperation or anything related to the Hillsborough County homicide, undermining his ability to make a free and deliberate choice. In this instant, Judge, there's a number of areas that I think need independent scrutiny. Number one, Miranda was minimized and phrased as a formality. As you look at the manner in which the the transcript of the interview would suggest, Drabick didn't introduce Miranda as a constitutional decision type point. He minimized the entire process and essentially said, look, whatever conversations we may have, I just got to read this to you first. And once he did read the advisements, and I'm not suggesting he didn't read Miranda. He did read Miranda. But essentially, he says, look, I'm going to make this short and sweet. As soon as the Miranda advisements were made, he quickly says, hey, look, do you understand that? Yeah, here, sign this paper, put your first name, put your last name. Never asked whether or not Mr. Murphy wanted to exercise those rights, whether he was in a position to fully understand those rights, and then instructed him pretty much to sign his name and let's move on. He did as he was instructed, and at that particular time, Drabick also noted that Mr. Murphy appeared to be fatigued, even offered him a Red Bull. He was covered in a blanket from head to toe, including his face and his head, and you can see that in the video portion of the interview, which has been admitted into evidence, and asked him whether he was doing okay, and at that particular time continued the interview process. And I believe that under Ross versus State at 45 Southern 3rd, Florida Supreme Court case in 2010, the court concluded that detectives improperly minimized and downplayed the significance of Miranda in almost an identical circumstance. In Ross, the defendant introduced the advisement by saying, there's a couple things I need to go over with you real quick. There's a couple things I discovered, and before we go any further, I want to cover this with you. It's just a matter of procedure based on everything we're talking about. The court held that that language conveyed the impression that the warnings were clearly bureaucratic and a formality. And significantly, even though the detective in Ross requested an affirmative waiver of that right from the defendant, the court in Ross said that's still insufficient. We didn't even get that in this particular circumstance, which Ross got, and the court still ruled that in fact Miranda was undermined.
Well, the Ross case was pretty egregious, right? As far as the conduct of law enforcement. I mean, in that case specifically, the detective admitted that they violated their own policy at the direction of the sheriff.
And I agree, Judge, but I don't think it makes it more egregious, because I think regardless of the underlying reason why law enforcement did it, the pronouncements and the interaction between the defendant and law enforcement were the same, or in fact worse here than in Ross. I think clearly Ross confirms it, where law enforcement conveys that Miranda's a routine procedural step rather than a substantial safeguard, that any ensuing waiver is constitutionally infirm and should in fact result in suppression. I did cite for the court, because I do acknowledge it, the Thomas case, which is at 351 Southern 3rd, 197, where in that case the court rejected a Miranda minimization claim, but the court there emphasized that the detective repeatedly referred to Miranda as a constitutional right, and he expressly informed Thomas that he was signing a form, meaning that means you're choosing to speak with law enforcement and ensure that he understood the gravity of those rights, and he was waiving them in exchange for conversation with the detective. The court also relied on the absence of any deception, any distancing between two agencies, any suggestion that Jacksonville's different from Tampa and we're not the same and it's not really our investigation, we don't have much to do with this. And in this particular case, those circumstances that are set forth in Thomas are different. Drabick didn't describe Miranda as a safeguard. He didn't explain that signing the form constituted a choice to speak. And instead, what he did was he treated it simply as just a bing, bang, boom, let's get by this and move on. Secondly, Judge, and next, It's my belief that law enforcement, again, as I testified, or excuse me, argued earlier, he used this multi-agency interrogation strategy that exploited the trust that, or lack thereof, that Mr. Murphy had with Tampa, and attempted to utilize it in an attempt to gain trust without constitutional safeguards as it relates to Jacksonville. Before the substantive questioning and after getting the signature on the waiver, he starts, that's Drabick, deliberately distancing himself from the homicide detectives and telling Mr. Murphy that they're the decision makers here. You know, they're the ones, and it's their process and their case, and essentially pressing the defendant to cooperate after he initially denied being in Tampa. So I would suggest to the court that because the defendant had unequivocally expressed that he didn't want to talk to the Tampa agents as it relates to this homicide, that's critical in the court's assessment as to the voluntariness of his statements.
But doesn't it cut both ways for your client? If he is understanding enough of his Miranda rights to waive them the first go-around, then doesn't that mean in the second go-around that I can conclude that he understood what Miranda meant and what his rights were?
Under different circumstances. When Detective Ramos read advisements, he just didn't say, here you go, sign this. He told him, this is your constitutional right. Are you going to waive it? Are you going to waive it in order to continue to speak to me? Verbatim. Right? It wasn't simply bing, bang, boom, here you go, sign it, let's go. Whatever we're going to talk about, we're going to just start now. That is the distinct difference between the way Detective Ramos handled the advisements and the way Detective Drabick, with purpose, in my estimation, handled his portion of the interview. So no, I don't believe it cuts both ways, because I think it was done drastically differently. And not only, there was no underlying method of distancing that Detective Ramos used. He certainly wasn't talking about Jacksonville. He certainly wasn't talking about Gwinnett. It was very clear to him what was going on, and it was done, in my estimation, the right way. Without getting further into this
Just so you know, you're at 21 minutes.
That's fine,
So if you
Judge.
want any rebuttal time, then I'm just going to advise you.
That's fine, Judge. Your at the onset of the July 30th interrogation, when he told Drabick that he didn't want to talk to the detectives in Tampa, rather than honoring and clarifying the legal significance of continuing to speak, essentially what Drabick did was he exploited kind of this perceived division between Tampa and Jacksonville and distorted the defendant's understanding of the risks and the consequences of continuing to speak. And I believe if the court reviews the interview on pages 13 and 14, you'll see this dialogue clearly play out, and it is set forth with particularity in the motion. And I'll say again, Judge, because I think it's important. Drabick warned during the course of the interview, this is Tampa's investigation, not Jacksonville. I'm not bluffing you because you never seen a Tampa interview, and there's a reason for that. He then emphasized the superior resources that Tampa has, that they are big wigs, they're like in the movies, and essentially to suggest that the cooperation through Jacksonville offered some safer or more advantageous alternative to Mr. Murphy at that time. And I believe that those coercive tactics parallel those types of circumstances that are condemned in the second district case of Bussey, which is at 184 Southern 3rd, 1138, a 2015 second DCA case. In Bussey's, the officers repeatedly minimized the seriousness of the defendant's conduct, contrasting the outcomes to suggest that cooperation would avert harsher consequences and foster the belief that you could be saved from the worst case scenario, and that is being interviewed by Tampa, or going with the bigwigs, or the movie guys, or the guys that you don't even understand how investigations go over there. Law enforcement distorted the defendant's understanding of the risk in order to overcome any resistance and secure a statement, which in this particular case is more important than Bussey because there had been a previous invocation, and Detective Dravik was aware of that. And again, suggesting that talking to Jacksonville was safer and more advantageous than dealing with the big Tampa machine, for lack of a better word. Judge, there's no dispute that Detective Dravik failed to honor the invocation because the substantive questioning commenced without interruption. We went straight full blast, 100 miles an hour, from an advisement without the proper after statements by Detective Dravik that would ensure that Mr. Murphy fully understood and voluntarily and with knowledge waived his Miranda rights. Detective Dravik exploited it. He leveraged that refusal, and essentially he fostered trust in a subversive manner. I'm sure the state's going to suggest, and certainly the court has heard in the past, well, the government or police officers, detective, can use lies. They can use methods in order to seek a statement. But in this particular case, it rises to the level of egregiousness based on the prior invocation, based on the differences and the way that Mr. Murphy perceived the advisements and the statements given to him by Detective Ramos versus the type of atmosphere that Detective Dravik fostered, knowing that there was a prior invocation. Under the totality of the circumstances, Judge, I don't believe the state can meet its burden to prove a voluntary, knowing, and intelligent waiver as it relates to the July 30th statement. Again, and in finality, Miranda was minimized, and it was framed as merely procedural. Number two, Detective Dravik failed to secure an affirmative waiver of those rights, which I believe incumbent on him to do, as Detective Ramos did during his interaction with Mr. Murphy. Third, that he exploited this artificial Jacksonville-Tampa divide in order to specifically distort Mr. Murphy's understanding of the consequences of speaking to him. And finally, he ignored and then leveraged a prior invocation to remain silent. And because those resulting statements were not freely and voluntarily given, we would suggest to the court that the July 30th statements must be suppressed.
Okay, thank you very much, Mr. Gonzalez. And State, did you provide me any case law ahead of time?
I did, Judge.
No, you did. I'm talking to the state.
Judge, we did not. We're relying on the same case law that Mr. Gonzalez relied on. We do not dispute that on June 26th of 2024, that first interview that occurred in Georgia, that Detective Ramos was there specifically to question him about the homicide, but is also undisputable that he was not arrested for the homicide in Tampa, that he did invoke for his right to request an attorney, and that was honored. That interview was immediately terminated. You heard the audio recording.
I'm sorry, I'm going to interrupt you for 1 second. Mr. Sonardi, you have a very deep voice, and I can hear you talking to Mr. Hernandez, so I don't know if
Apologize, Judge.
it's okay. I don't know if you're capable of whispering, but if you are, please.
I'm trying.
Okay, all right, very good. All right, continue.
Yes, Your Honor. It is also undisputable that that right was honored by Detective Ramos, that he terminated that interview. And what is also undisputed and what is fact is that he was arrested on Georgia-related charges and he was let go. So he was released, and that occurred in June 26th of 2024, and there was a break of over a month. And so I know that Mr. Gonzalez mentioned U.S. v. Edwards. That is a exception when a person has invoked his right to an attorney that is carved out by the U.S. Supreme Court. The other exception that is also carved out, which is applicable in this case, is Maryland v. Schatzer. And it is very clear in Maryland v. Schatzer, who a defendant who was in custody and was imprisoned was questioned, invoked his right to counsel, and the detectives in their investigation left the prison, and there was a break of 14 days. And after 14 days, those detectives reinitiated contact with the defendant. And the court, the U.S. Supreme Court and Maryland v. Schatzer found that that was a significant break, that 14-day, that 2-week period, that the defendant at that point could shake off the coercive nature of being imprisoned, could acclimate. That is a valid exception to when law enforcement can reinitiate contact. And that is what we have here, Judge. But we have a less coercive situation than Maryland v. Schatzer, where the defendant was serving a prison sentence. In this particular case, the defendant was arrested on Georgia charges. He then was released, and a month went by, over 4 weeks, not the 2-week period that was acceptable in Maryland v. Schatzer, but 4 weeks went by before law enforcement arrested him and developed probable cause to arrest him in this homicide related to Tampa. So that is what is significant, and that is what the law requires when somebody who has invoked their right to an attorney. So we have that break. And when we're talking about the totality of circumstances, and that proving the defendant knowingly and voluntarily waived his rights to Miranda, certainly the first reading of Miranda that happened within a 2-month period, which was recorded on audio recording, that where his rights were fully read to him, we all heard it, and he acknowledged and he understood those rights, and so much so that he understood them, that he actually exercised those rights by invoking an attorney. We have no reason to believe within a 2-month period that all of a sudden he no longer understands his constitutional Miranda rights. He definitely exercised them on June 26th of 2004. And so when we're looking at the Miranda on July 30th of 2024 with Detective Drabeck, and looking at those totality of circumstances, all of the factors for the court to consider, Detective Drabeck, again, we have not just an audio version, we have an audio and recorded version. So they recorded their interaction with the defendant. There is a written form that was used, and clearly the detective, again, read all of the Miranda rights to the defendant. He made the defendant read the first sentence of the form to make sure the defendant could understand what he was reading. And then the defendant, again, acknowledged and signed off on his Miranda rights and continued to talk to the detective. There was no deception to the defendant trying to say that this wasn't related to the Tampa case. That was made clear to him that they were there to interview him for those specific purpose was to talk to him about the Tampa homicide. He never invoked his right to remain silent. He never asked for an attorney. He made one statement about not wanting to talk to Tampa detectives, and he clarified to the detectives why that was. It wasn't because he didn't want to talk about the Tampa case. He said because they don't know me. So there is nothing improper about Detective Drabeck trying to build a rapport and using strategic tactics to get the defendant to talk to him. So certainly if he wanted to play up that whatever and distinguish himself from Tampa, he still made it clear and was honest about what he was there to talk to the defendant about. And the defendant at that point never exercised his rights and never invoked his right to remain silent. That was a willing, knowingly, and voluntary waiver of Miranda that is recorded for all of us to hear. And it is definitely distinguishable against Ross, where they were looking at bad faith and bad actions by law enforcement. You do not have that here. That is a far distinction. You can't just qualify Detective Drabeck's interaction with the defendant and try to put it in a bad way. There was no promises that were made. There was nothing coercive about that interview that is on video. You could see there the manner in which it was taken. It was professional, and he was cold. They were the ones that provided him with the blanket. So when you're looking at the totality of circumstances and what the law requires, there is nothing that needs to be suppressed in this particular case. There was enough of a break that occurred. He was no longer under the coercive nature of being in custody. He had been released from the Georgia authorities, and he had never been arrested for this Tampa homicide. 30 days had passed. That was sufficient of a break. And according to Marilyn V. Schatzer, that was sufficient for law enforcement to be able to reinitiate contact with the defendant and reread him his Miranda rights. And so we would ask that you deny the defendant's motion to suppress the statements and the recorded interview that he provided to Detective Drabeck on July 30th of 2024.
Okay.
Judge, I would only add that, as the court knows, the video interview is in evidence, and I would urge the court to review it in order to make determinations that would be consistent with my argument.
Okay, very good. I'm going
And
to
I
take
have
it.
no objection to that, Judge.
I'll take it under advisement. Okay, I'm going to do a written order on this one. Okay. All right, so Mr. Gonzalez, you want to move on to your motion, Defendant Rashad Murphy's motion to suppress cell phone?
Judge, I am moving to suppress all evidence seized from the defendant's cell phone incident to an unlawful search warrant. Very quickly, court's aware, Gwinnett County, the LPR readers locate the silver Chevy Cruze, which is the subject, the vehicle is the subject of an alert put out by Detective Ramos based on surveillance video that was developed from various areas and specifically the scene of this particular crime. When Mr. Murphy is taken into custody, again, the court's aware that the cell phone was located in the vehicle, and it was open to show GPS directions back to the hotel. It was determined what the phone number was of that cell phone, and also that it was registered to Charmaine Steiger, who is Mr. Murphy's girlfriend, but that it was clear and unequivocal that both individuals utilized that phone. Detective Ramos authored an affidavit for a search warrant for that phone because he was aware of the evidence that had come to light at that particular time in the investigation, which was early on, within days. And certainly I have listed, or I have made that cell phone affidavit, Exhibit A, in the motion, and I would urge the court to read its probable cause. What happened in conjunction with that is that Detective Carter, who took upon herself the lead investigator in Gwinnett County based on the arrest, the subsequent statement of Ms. Steiger, and also all things forensics that occur in Gwinnett County, she included at the back end of that affidavit her additional statements or evidence as it relates to probable cause for that search warrant. And she and Detective Ramos are co-affiants to that search warrant. Judge, I have set forth in page 3 of my motion a synopsis of all of the evidence that provided alleged probable cause for this warrant. I would note to the court in subsection J, essentially the only thing that has any relationship, direct or indirect, well, certainly not direct, but indirect, is that Tampa police had initially contacted Jacksonville because of the vehicle being a Duval County plate. And at that particular time, I'm not even sure Detective Ramos, pursuant to his testimony, even had an owner, registered owner, certainly had not contacted a registered owner, had no idea that Mr. Murphy had anything to do with that vehicle other than he was the driver of it in Gwinnett County when it was stopped. And essentially, that general information was that there was intelligence, and this, again, Judge, runs kind of dovetail into a lot of what we're talking about over the past week and now, where the Jacksonville detectives tell Ramos, hey, listen, we got intelligence which says that 2 out of the 3 shooters might be Isaiah Chance and Rashad Murphy. There are no witnesses to confirm this. There is no direct evidence of it. There is no forensics to support it. There are no videos to support it. There is no fingerprints to support it. There is no eyewitness or other direct witness testimony to support it whatsoever. It is a rogue statement by Jacksonville based on hearsay. And I think that's unequivocal. And I don't think anybody, inclusive of when Detective Ramos testified and then discussing it with Detective Drabeck, ever suggested it was anything more than rank hearsay. So at this point in time, the only thing that is determined by that statement as probable cause in this affidavit is that Mr. Murphy might be a person of interest. So moving on, what ends up happening is Detective Carter, in her deposition on page 14, states that she had no idea who Rashad Murphy was. She wasn't provided any information with regard to Rashad Murphy. She wasn't told that Mr. Murphy had any connection or had any potential part in this particular murder. She thought, and she was told, it was the vehicle. It's the vehicle at issue here. So that is the premise under which Gwinnett County detectives are operating under, and it's the premise under which she's operating when she executes that probable cause affidavit for the cell phone search warrant. Detective Ramos, in turn, both in testimony last week and in his January 15th deposition on page 14, said, my original probable cause was for the car. So if the phone's in the car, then the phone becomes an extension of the car. Well, we all know that is not what the law is. That phone is not an extension of the car, and the only thing that Detective Ramos is operating under at that particular time is that there's an alert for this car and it's now in custody. And he goes on to testify in page 14 and 15 of his deposition that where Rashad Murphy was, that's where the phone was. It's a totality. So all of that information gets included. So again, that is what in his mind premised the probable cause for this affidavit. He goes on to testify on January 15th, and again last week, that he had not identified Rashad Murphy, that all he knew was based on Jacksonville intelligence, nothing more than that, the intelligence coming from Jacksonville. And then my question was, which was, we believe that for one reason or another, Rashad Murphy was involved? Answer, correct. And that's really as general as it got. There were no other additional information with any specificity about how, why, and what. His response, correct. So, although Ramos identified the owner of the cruise, he admitted that he had done no further investigation on that cruise, Chevy Cruise whatsoever, and certainly could not connect it to Rashad Murphy as it relates to a crime, as it relates to a murder. Simply that days after the murder, he was in contact with it or he was the driver of it. Without having any context as to why that would even be the case, later to learn, obviously, it was a relative's vehicle, but certainly not being privy to that information at the time of the search warrant, at the time of the affidavit. So, Judge, in discussing those underlying facts, cellular phones are recognized as having very, very unique characteristics because of both the breadth and the depth of personal information that they have in them. And certainly that's buttressed by a number of federal court cases and Supreme Court cases, essentially saying that a cell phone collects in one place very distinct types of information that reveal much more in combination than any other isolated record. So to that extent, there is significant scrutiny when it comes to cell phones and what they contain. When determining the legality of a warrant, of course, the court's well aware that you look at the four corners of that affidavit. And I will not get into the four corners of the affidavit. They are set forth in the case law and in the motion with specificity. But I will say that certainly mere speculation as to whether or not there may be some evidence of criminal activity that might be found is wholly insufficient to support the issuance of a warrant. Additionally, Judge, even if that warrant on its face appears to have probable cause, I would suggest to the court that the case law is clear that the omission of material facts obviously render that warrant unlawful. And we'll talk about that. In this particular case, Judge, and with particularity as it relates to this particular case, the warrant lacked probable cause because the affidavit failed to establish that Mr. Murphy committed a crime, and it failed to establish a nexus between that cell phone and the evidence of any criminality. There is no nexus sufficient to authorize a search warrant in this case with regard to that cell phone based on the totality of circumstances. In particular with the cell phone, in order to search a digital device, it requires more than the possibility that that phone might have evidence of a crime. And when you talk about those things, as I set forth in the motion, you talk about the dichotomy between two particular cases that I would reference. Jefferson versus State, which is a second district case, a 6th district case, and also Torres-Carmona, which is a second district case. In Torres-Carmona, the second district upheld a warrant that was supported by a detailed multi-agency investigation establishing an evidentiary chain linking the defendant, linking his co-defendant, linking the victim, and linking the use of the cellular devices prior to and during the commission of the crime. None of that exists in this particular case. No mobile phones were located on Mr. Murphy's person. His phone does not travel to Tampa. Those are just a few of the things that certainly would not give rise to the same factual scenario in Torres-Carmona. In that particular case, the victim's girlfriend told investigators that she provided those phone numbers. Detectives received cell tower information and call detail information on that phone. And critically, in Torres-Carmona, the investigation demonstrated a coordinated pattern of travel for that phone. In short, essentially, the phone and the evidence of that phone was not speculative. When you contrast that with Jefferson, the court held there that officers lacked probable cause to search a defendant's phone where they assumed that the defendant's phone would contain incriminating communications, but they didn't importantly establish a factual links between the device and the crime, which is a critical distinction in this particular case. The defendant in Jefferson, it was a first-degree murder case of the death of a female acquaintance, and Although they could place the defendant near the victim, which can't be done here, they can connect him to the crime scene through physical evidence, which is not the case here. The affidavit relied on conjecture that communications likely existed on the defendant's phone. And the court noted that the facts which were known to the officers when they seized it is that there was a blood trail from the victim's body to the defendant's apartment. And this is where the court found a lack of probable cause.
You talking about the Jefferson case?
Jefferson case, Judge, at 363 Southern 2nd.
But there was not a warrant, excuse me, there was not a warrant in that case, right?
No, Judge. The defendant was previously acquainted with the victim, and that 2 days before her body was located, they were seen together, and that the defendant had been less than forthcoming in prior interviews. So all of those things considered, the court still found that regardless of that circumstantial evidence, law enforcement did not establish probable cause to search the defendant's phone. It's not buttressed with anything of specificity that Mr. Murphy might be a person of interest. That is it. That is what is utilized in the entirety. If you look at the entirety of this 4 or 5 page probable cause affidavit, none of it would be something that a magistrate should be would find compelling to provide probable cause for this warrant. And the only time that Mr. Murphy is mentioned in that affidavit is when we talk about the fact that Jacksonville said, "Hey, look, he might be one of our guys." Mere association with that vehicle that was subject to involvement, without evidence linking the defendant to that vehicle during the course and scope of the crime, cannot support the issuance of this warrant, Judge. Third, the affidavit fails to establish a nexus between the cell phones and any evidence of criminality, and we've discussed that, but I go into it in more sufficient detail in the motion on page 10 and 11. And I would point out to the court again that Detective Ramos is under the impression that simply because the phone was found in the vehicle, that makes the phone an extension of the vehicle. And the vehicle was the subject of the evidentiary inquiry, not the phone. None of which had a direct relationship to Mr. Murphy and the crime. Not Mr. Murphy at the time the phone was found, Mr. Murphy and the crime, which is required under the law in order to seek and get this warrant. Judge, as it relates to omissions, I think the fact that the affidavit contained omissions would, had they been included, defeated probable cause is also an issue in this case. Detective Ramos admitted and testified that there was no evidence linking the defendant to the homicide. The affidavit, in a sense, misrepresented the intelligence that was received from Jacksonville. And if you look at the way that it's postured in the affidavit, compared to under oath, what Detective Ramos says, Detective Ramos had in-depth knowledge of the victim, the gang he affiliated with, and the gang rivalry he is feuding with, and Detective Drabick identified the defendant as a suspect. That is the premise by which Detective Drabick suggests that there should be some nexus or some linkage to this phone. And specifically, in Detective Ramos's deposition, I again asked, had you at this time identified Murphy? I knew the name based on the intelligence, but I had nothing more than that. You know, intel from Jacksonville. Question, which was, we believe for one reason or another that Rashad Murphy was involved? Correct. And that really is as general as it got. Correct. I highlighted that before, I'm going to highlight it again, because that is what Detective Ramos is operating under in truth, but that is not, in fact, the way that the affidavit is suggested when it's written. Despite admissions in sworn testimony by both Detective Carter in her deposition as set forth in the motion and Detective Ramos both in testimony before the court and in his deposition, that they had no evidentiary basis to connect Mr. Murphy with the homicide, or even to place him in Tampa at that time. That fact is omitted from the affidavit. The affidavit also suggests that the homicide was motivated by ongoing gang activity, and it doesn't contain anything that would suggest at the time that the affidavit was written, the defendant was not a documented gang member when the warrant was issued. The defendant was never identified as a suspect in any ongoing gang investigations referenced in the affidavit. And the defendant and law enforcement had no evidence connecting defendant to any gang rivalry. What we had was that general statement given by Detective Draven, none of which was suggested to the magistrate in terms of specificity. Because if they had provided specificity, it would have indicated to the magistrate that there was no nexus that could be developed at that time, at the time in which the warrant was sought. Disclosure that they possessed no evidence linking Mr. Murphy to the homicide, and they believed that the probable cause was only extended to the cell phone from the vehicle itself, I believe would have defeated the application. Judge, at the end of the day, we always talk about good faith exceptions, and certainly when officers omit material facts or when they have no reasonable ground for believing that the warrant was properly issued, the good faith exception does not apply, and it doesn't apply here. At the end of the day, Judge, the affidavit does not link Rashad Murphy to the commission of any crime, does not establish a nexus between the cell phone and any evidence of criminality at all. And moreover, because there are omissions, as I've discussed, and have with more particularity citing deposition transcripts in the motion itself, those omissions could have altered a magistrate's finding of probable cause. And in that light, Judge, the evidence should be suppressed.
Okay, thank you. Story.
Yes, Your Honor. Judge, it's the state's position that law enforcement relied upon a properly executed search warrant, and what we want to make clear and make a proper distinction is there is a distinction between probable cause to arrest a defendant and probable cause to search a item of evidence that probable cause has been developed to search. I know that Mr. Gonzalez said that there was no evidence that defendant Murphy had committed the crime at that time. Judge, what is laid out in this search warrant is that a homicide had occurred in Tampa that involved 3 shooters, and all of the facts of the homicide have been laid out. So the crime that we are talking about is homicide, and there is PC that suggests that 3 shooters committed this homicide. There is nothing that requires or limits the state or law enforcement to only search items of evidence that belong to the suspects. We have to provide probable cause to search an item that may have evidence of the homicide. And so what is laid out in the search warrant, and we know that we are stuck by the 4 corners of this affidavit, and the reason that we provided testimony from Detective Ramos is to establish that there was no deception in the search warrant and there was no material omission. And we relied upon a properly exercised search warrant that was executed up in Duval County in Jacksonville. And there, when we talk about the probable cause for that phone, there was an executed search warrant for the car, and nobody searched that cell phone once it was located in the car. Nobody opened up that cell phone or searched it until there was a properly executed search warrant for that specific phone. And so when you're talking about the probable cause that is laid out by both the detectives who needed a co-affiant because this was done in a jurisdiction outside of Tampa, the detective is clearly laying out the probable cause to believe why there is evidence of the homicide in that phone. It includes all of the facts in Tampa that led to the crime and the murder of Charles Jones, but it also lays out and details the evidence of what occurs. This defendant is in the suspect vehicle within 3 days of this homicide occurring, and he immediately flees from law enforcement when he is apprehended in the very vehicle that they used to shoot and kill Charles Jones, the victim in this case. And when Mr. Gonzalez specifically refers to the statements that were provided by Jacksonville in the investigation where this defendant's name came up, they are using the exact accurate and honest depiction of what is going on. They label it as exactly what it is. It is just intel. And then they go beyond that and they tell the court, the magistrate, what that intel is. And then what is added about this particular phone is a part that Detective Carter with Gwinnett County Police Department in Georgia adds, that she actually had an interview with Charmaine Steiger, the defendant's girlfriend, and that involved the phone, and that Ms. Steiger let them look at the phone, withdrew consent, but she also gave a detailed interview after being confronted with the fact of this suspect vehicle and the whereabouts of her and the defendant during the time of the crime, and that she gave inconsistent statements. So all of that is woven into the probable cause. And so when we make a distinction about probable cause to arrest the defendant versus probable cause to search that particular phone because it has evidence related to a homicide case, that is clearly laid out in this search warrant. And based on Detective Ramos, there wasn't anything deceptive, there wasn't any omission that was given. He never tried to suggest that there was any evidence more than other than the defendant at that time was a person of interest, that they had an interview that of the girlfriend that claimed to be with the defendant the entire weekend and then changed her story once she was confronted, that the detectives absolutely knew that that car wasn't in Jacksonville when the homicide occurred, but was in Tampa. She then changed her story and said she didn't really know where he was. All of that is laid out in the search warrant. And so there is PC that a homicide had occurred in Tampa, that 3 shooters had participated in that shooting, and that there was evidence directly now related to a joint phone belonging to Charmaine Steiger and the victim in this case. And so there is no omission, there is no denial, and there's no sort of any additional facts to make it more suggestive than the defendant was involved that was actually in place at the time when the search warrant was executed. And so based on that, we would ask that you deny the defendant's motion to suppress. This was a good faith reliance upon a properly executed search warrant for that phone. That case law, that Jefferson case law is clearly, that was cited by defense, is clearly distinguishable. That's when they just went into the phone. That is not what happened here.
That was a warrantless search.
Correct, Judge. We have a warrant. We in good faith relied upon it, and there was nothing deceptive by either detective, and there was no material omission in that search warrant. Nobody suggested that there was PC to arrest the defendant at that time. Certainly, there were facts even at this time when this search warrant was executed that he certainly was a person of interest, but they accurately noted in that search warrant that they just had intel, and that hearsay that the defense attorney is suggesting that that intel is based on, that is laid out in the search warrant. They're not saying that this was provided by a reliable CI, or they're not trying to suggest they had any additional evidence. It is spelled out exactly with the sort of intel that they had from Jacksonville. And there is sufficient facts in there to believe that there is evidence related to the homicide that occurred in Tampa based on the interviews that were done prior to the execution of this search warrant.
Briefly,
Yep.
Your Honor, The fact that the phone was not searched before a warrant was sought does not cure its illegality. Good for the police that they just didn't jump into the phone and start looking at it. That's not the issue. The issue is, did they have a sufficient nexus between the defendant and any act of criminality that would allow them to usurp the rights of privacy that he had in that phone when, and in fact, they knew that it was co-owned or belonged to him.
I understand the argument you're making regarding the nexus. I do.
Nothing further.
Okay, all right, very good. I'm gonna take the matter under advisement. I will do a written order. Okay, so we've got two motions by Mr. Gathright and one by Davion Murphy. Davion Murphy, you wanna go ahead, Ms. Toomey? On your motion to suppress? Okay, very good.
Judge, this is a motion to suppress the search and seizure of Davion Murphy. There was, so let me just back up. Mr. Murphy was actually, Davion Murphy was arrested on January 6th of 2025. There was originally an arrest warrant that was put out on Mr. Murphy, Davion Murphy, on July 27th of 2024. That was recalled when an indictment was issued, and the capias was issued on August 15th of 2024. So after Mr. Murphy, Davion Murphy, was arrested by the Jackson County Sheriff's Office, he was initially read Miranda. He was brought into a room, he was handcuffed, he was still in street clothes, he had a red tank top on, a jacket, if I recall the weather during that time, I'm sure it was cold. The interview went on for a variety of hours. Mr. Davion Murphy cooperated with law enforcement, but then there was at the end, and I might note, and this is Defense Exhibit 1 during that motion, that during that time frame, Davion Murphy had his jacket zipped up, all the way past, up to his chest, almost up to his neck. Just for the record. I know I didn't play that portion, but it is on that interrogation video. Now, as I see it, without a warrant, there's about 3 exceptions that potentially the state could potentially argue. 1, the photographs were taken incident to arrest. 2, Mr. Davion Murphy consented to being photographed. And then 3, we've got the plain view doctrine. Whatever tattoos that were in plain view of law enforcement. So I just want to kind of briefly go through each one of those.
What about inevitable discovery?
Inevitable discovery, yes, which in my mind goes into the incident to arrest, because, and I guess I'll take that one first. Incident to arrest, you have the purpose of that exception to the search warrant is for not only officer safety, well, one of the primary reasons is for officer safety, but when someone's arrested and they're booked into county jail, what have you, again, officer safety, inmate safety, to make sure that individual's not bringing any contraband into the jail. There's a booking photo. They do not take photographs of any portions of your body other than to take a booking photo of you to document the identification of who they've been arrested. They take fingerprints, they ask you a myriad of questions, background information. These are purely administrative procedures, and they're routine when someone is booked into county jail. So I don't think that inevitable discovery without a warrant, if the Jacksonville or TPD, as indicated by Jacksonville Detective Drayback, who said, we're just trying to speed things along, so that when you get to Tampa, things will go smoothly for you. And I quote
So
that.
let me ask you this question, and I don't
Yes,
know
Judge.
if you know the answer, but the DOC records, would the DOC photographs have ultimately shown these tattoos on the body or person of Davion Murphy?
My experience is no. Now, I can tell the court that I have photographs, not photographs, excuse me. I have records from a variety of clients of their DOC records. The only thing, just as a booking photo and the questions that are asked during the booking process at the jail is, do you have any tattoos? They give maybe like a general description. If they have numerous tattoos, the booking officer will just put numerous tattoos, may go a little bit further, but.
What about
maybe get a
photos, though? Are photos taken by DOC?
I have not seen photographs. I've
Okay.
seen where they've maybe described certain tattoos, but I haven't seen photographs. I have not.
Yeah, I
Perhaps
don't know.
it's-
That's why I'm just asking the question.
Yes, Judge. So just because Mr. Davion Murphy was in custody, obviously, he was brought in under that arrest warrant, he was shackled and brought in an interrogation room in Jacksonville. Just because he was in custody and just because he was arrested does not give law enforcement full blanche to photograph any and every area of his body that they think is going to provide them what? Evidence, right? Because oddly enough, well, I'll get to that. So we have the incident to arrest. Also, part of the incident to arrest would be, well, potentially the individual is, the evidence might be lost in some fashion or another. We're talking about tattoos, so that's not applicable here. The second potential exception would be consent. And when determining consent, the court has to consider the totality of the circumstances. And I would submit to the court that Mr. Murphy, because he was in custody, he had just been interrogated by Jacksonville Sheriff's Office, that he not only was he wasn't, in my opinion, was not asked. The officer told him that he wanted, but and I'm going to quote, what I wanted to do is I'm going to take some pictures of your tattoos. That's what he told Davion Murphy. It's not a question. It's not asking him for consent. It's telling him what he is going to do. And mere acquiescence of authority is not enough. And the state has the burden to prove that there wasn't a mere acquiescence to the show of authority. In order to show that Davion Murphy consented, the state has the burden to show that his consent was free and unrestrained. It was an unrestrained choice that he had made. I haven't been provided anything wherein it was explained to Mr. Murphy that he's consenting, that he's signing, that he's got a right to not consent, right? That was never explained to Davion Murphy. So I think in the totality of the circumstances, there is no consent by Davion Murphy to the photographs, which, by the way, were personal in nature in that he lifted up his shirt. These are not portions of one's body that are in plain view. And again, these are not photographs that are taken when someone is arrested. Yes, someone who is detained, a detainee in a jail, has less privacy rights than the average individual, and they do. But does that mean that the state and law enforcement get to trample on his constitutional rights as well? when they could have simply got a search warrant. I have other cases where they want to see my guy's tattoos. They obtained a search warrant and went and took photographs of the individual's tattoo that they thought had a nexus or were related to the crime involved. So, looking at the totality of the circumstances, I don't believe that Mr. Davion Murphy gave consent. Now, plain view, obviously the stomach is not in plain view. One of those photographs, the detective admitted, and you can see in the photograph where he actually pulled back the back of his neck, the tank top pulled it down. So obviously, those areas are not in plain view.
So you're saying the back of his neck is not in plain view?
No, that tattoo, specifically that tattoo, where he had a tank top on, right, after he took his jacket off.
It says, I think, 1,200, right, on the back?
Yes, Your Honor.
Okay.
But that was not in plain view because the officer, or the detective, actually had to pull his shirt down from his back in order to observe that and take photographs of it. And because there was no search warrant obtained by the state, the burden is on the state to prove that one of these exceptions apply. These motions, defense 2A through L, should be excluded, as well as the portion of the videotape where those pictures are being taken. And inevitable discovery, that's, yes, potentially. If the state had gone in the correct manner and getting a search warrant to begin with. Because, that's the whole idea of the exclusionary rule, right? Is not to reward misconduct or bad behavior by detectives and the police department, right? So it would have been, they got all these other search warrants, it would have been that quick to get potentially, if they had probable cause, to get a search warrant for these tattoos that are on Davion Murphy's body, which they so desperately wanted to utilize in this case as evidence that he is part of this 1200 or the 187 gang or no hospital gang or what have you. I might also note that the state, in providing the different groups, associates, members of ATK, members of 1200, one of the photographs that was used was from the interrogation room. And we'll get, I guess that's probably a subject of another motion, so I'll leave it at that. But I would request that those photographs be suppressed.
Okay,
Thank you, Judge.
thank you. Ms. Murr?
Good morning, Your Honor.
Morning.
I will address the specific exceptions. The state's position that a search warrant was not required in this case. If we are looking specifically first to the search incident to arrest, the defendant was lawfully arrested on a warrant. Law enforcement has the wide breadth in conducting a search of the defendant. By law, Florida statutes 901.21 conflict with the defense's argument that this was some kind of intimate or private search. The only description that's provided in that statute as going so far as to be a strip or cavity search, something that's outside of the scope of the search of a person arrested lawfully, would mean the chest or breast of a female arrestee. So the defendant does not qualify. This is not some personal search or strip search or cavity search, nonetheless. That being said, the jail and law enforcement also have the ability to do so when the defendant has been lawfully arrested. So a strip search or cavity search, again, is conducted by the jail or law enforcement as long as it's done so in a manner and location that is reasonable. The defense would argue that the defendant had a right to privacy in the areas that were depicted, but as the defendant entered the interrogation room, his jacket was already off of his shoulders. The 1200 on the back of his neck was exposed. The block, so 1200 block is what the full tattoo is on the back, was not exposed, and that is what was covered. So the word block on the neck and the tattoo on the chest or stomach area are what really appeared to be at issue. Other tattoos tattoos include those on the defendant's hands, which were obviously in plain view, and the side of the defendant's neck, as well as the upper chest area, also all in plain view, applying or meeting the standard for a plain view exception. Additionally, as it relates to the defendant's consent, when it comes to those areas, I think the question asked of the defendant was, what's that belly looking like? At the time that the defendant lifted his shirt, obviously not necessarily needing to establish consent to prove that the law enforcement officers did not need a search warrant in order to obtain these photographs. The state would argue that that was consent to at least obtain the photographs on the stomach, but most importantly is inevitable discovery. The jail does in fact document the description of the tattoos, their location on each of these defendants' persons, but also these law enforcement officers are acting in a manner that is an extension of the jail. They are permitted to take photographs even if they were roadside of an arrestee when they see, for example, on someone who's been arrested for murder with a gang enhancement, tattoos indicative of being a gang member. That said, the Department of Corrections does in fact photograph gang members. So the records that Ms. Toomey may have been referencing for Department of Corrections records received for her by other cases or with other defendants referenced may be what's called a penitentiary pack or referred to as a penitentiary pack. That commonly includes a photograph of the defendant or the most recent photograph of the defendant that's been taken by the Florida Department of Corrections, their classifications and locations over the term of their time in the corrections department or prisons that they've been sent to, transfers, incidents, and fingerprints. That is the standard penitentiary pack. This particular defendant, though, has a designation, which means that he is on notice and noticing law enforcement agencies that he is in fact a gang member. That is a different document from the Department of Corrections. But each time the defendant would be transported, each time that the prison that he is located in would see additional tattoos or gang evidence, including his interactions or incident reports for having contact with the guards for gang activity, it's all documented. But thoroughly documented, as confirmed by the defendant in his interview, are his tattoos. So he specifically says to the detective, you already have those, the prison takes those, etc. Because in fact, what's called a STAR report from the Department of Corrections is specifically the Department of Corrections log of each inmate and every tattoo on that inmate's person. It's not only to keep track of the gang activity, involvement, developments, etc., but also to ensure that they are cracking down on the illegal tattooing in custody. There are several reasons for it, but they certainly monitor each defendant, not only at the time that they notice new tattoos, injuries, that type of thing, but also at the time each of the defendants are transported. It would, I can only assume, appear from the defendant's interview that he acknowledges and admits to that because he repeatedly says to the detective, oh, the prison already took them, those are the most updated ones, and I received them all in prison.
I'm just curious, does every inmate get a STAR report in DOC or just those that are suspected of gang affiliation?
Only those that are documented as having some involvement with a gang. So everyone gets a penitentiary pack, that's the basic information, and then if there's a gang attachment, that's a STAR report, that's the gang report essentially.
Okay.
So at this time, Your Honor, the state's going to request that the court deny the defendant's motion as it relates to the defendant's tattoos having been taken by Detective Nieder. The Fourth Amendment certainly protects, just at a basic level, the search that was conducted. There was the scope of the intrusion that should be considered, the manner in which the search was conducted, the justification for initiating that, which of course is the charges in this case and the facts surrounding it, paired with Detective Nieder's knowledge of these gangs, and the place that it occurred, which of course is in the privacy of a law enforcement district room, not on the roadside or something along those lines. So starting first with a Fourth Amendment analysis, law enforcement didn't violate any of the defendant's rights, but also in the event that the court believes that a search warrant would have been appropriate, the exceptions that the state would be relying upon are a search incident to arrest, plain view, consent, and obviously, most notably, the inevitable discovery of those records, which would have already been documented.
Okay, very good.
Thank you, Your Honor.
Okay, let's just go ahead and take our morning recess. It's 10:33. I'll be back at 10:45, and then we will proceed with Mr. Gathwright's motions.
Court to recess.
Under advisement.
All right, just want to welcome you guys in. So apparently, Davion has tattoos from Cutthroat Committee, which is a gang in jail. So that's why they were kind of, I don't know if we've heard that yet, or we're going to hear that. They're trying to put, gang-related tattoos on Davion, and he did get tattoos in jail, but it was specific to ones in jail. That being said, he does also have tattoos from some of his fallen friends that are part of this, part of this whole thing. So that's what they're talking about now. They're trying to suppress the evidence for statements that were made by Rashad, and then also the cell phone coming in from Charmaine Steiger, who was his girlfriend. All right, let me get to the next one. So ultimately, the judge, pretty sure. Let me see. Yeah, I don't think she suppressed any of that. If I remember correctly, I don't think she suppressed any of that. Oh, hold on. Let me get you to the next. Trying to do too many things here at once. All right. And cats walking by don't help. All right.
Not intend to, and this is.
Oh, this is a new lawyer. Not sure who this is. All right. This is somebody we haven't seen before. All right. So this is from the following day. So this is from March 4th. That was from, we just heard pretrial hearings from March 3rd. Now this is March 4th. So let's see. And then more motions. Let's see. Hearings for motions. I'm not sure which ones these are, but we'll check it out. All right, so this is from March 4th.
I have communicated several times in the last few days, so I can go quickly as to the motion in limine regarding penalty phase, regarding a lingering doubt. I have no objection to that.
Okay,
I know I cannot argue that. However, I did want to point out that certainly that does not mean that I cannot tell the jury that despite all the weighing of aggravating and mitigating circumstances, they ultimately can vote to what they believe is the correct thing to do. But
And we're talking about, just for the record, so it's clear, the state's first penalty phase.
You know what? I actually think this is the same day because I see similar outfits. I think this is from the same day. We have it as 2 different days. I think this is from the same day. It's either from the 3rd or the 4th. I have this as the 4th. The other one was from the 3rd. I think it's the same day. I do think it's the same day. So we'll just leave it as the 4th for now.
Motion for order in limine, right?
yes, ma'am.
Okay, I just want to make sure, because there were a number of states' motions, so. Correct. That doesn't impede your right to argue the balancing of aggravating and mitigating evidence. It just means no one can get it. Once, if the jury finds the defendants guilty of capital murder, then during the penalty phase, the parties may not relitigate that.
I agree.
Okay. All right. So I will, as to Mr. Rashad Murphy, that motion will be granted. Okay?
As to the state's second penalty motion, we do not object. I would not get into anything dealing with the details of the actual method of execution.
Okay. So as to Rashad Murphy, that's granted. State's third penalty phase motion.
The third one, Your Honor, the same, with no objection. I would not be getting into religious beliefs.
Okay. All right. As to Rashad Murphy, grant the state's third penalty phase motion for order in limine.
As to number 4, and tell me if I'm going too fast.
No.
A description of death on television shows, etc. No objection to that.
Okay. As to Rashad Murphy, be granted.
As to number the 5th motion, I I would not intend to, and this is something that I know the state's going to object because Mr. Harmon already told me he would, but I would not plan to get into details of other types of cases, such as mentioned Charles Manson, Ted Bundy, etc. However, when the state files a motion seeking, or a notice seeking the death penalty, they are in effect telling the jury that they believe that this case qualifies as the worst of the worst because it deserves the death penalty. And I think that opens the door for me to be able to argue that this is not the worst of the worst if in fact we were in that situation. And I should be able to talk about comparing it to other capital cases to the extent that the death penalty, this case does not mean worst of the worst. I should be able to talk about torture and serial killing and things of that nature because I would need to separate the facts of this case from other cases that I would argue would be the worst of the worst.
So are you talking about just making a general argument at penalty phase as opposed to saying things like, this is not Granville Ritchie, where a 9-year-old girl was raped and murdered. This is not Angel Kuzchok, where a 4-year-old girl was stabbed to death. Is that what you're talking about?
Yes, ma'am. I wouldn't be even mentioning other names, but I think that if the facts of this case do not have torture, if the facts of this case do not say serial killing, I should be able to make those distinctions.
Sure, just generally speaking, that
Speaking.
this is not the worst of the worst that would warrant a sentence of death, right?
Yes, ma'am.
Any objection to that, just that general argument at penalty phase, assuming we get there?
Judge, I do object to that. And if you look at the state's motion, and I cite the Rocket v. Ohio, Rocket holds that not only the sentences in other cases, but the circumstances of other cases, which would include torture or serial killers, there are many types of serial killers. There are many types of circumstances. There was a Timothy McVeigh bombing in Oklahoma that killed over 100 people. There was Hal Donaldson, who recently killed 4 people here in Seminole Heights in Tampa. Ted Bundy, Oscar Ray Bowen, who was responsible for 3 young women here in the Tampa Bay area. They're all different. They're all distinct. All the defendants were of different ages. They have different circumstances. To simply say this isn't torturous or this isn't a serial killer, it's even worse because you're leaving it up to the imagination of the jurors, and that's not what they're supposed to be doing. They're supposed to be assessing and conducting an individualized sentencing proceeding for this defendant to give him his due process rights. They're not supposed to be speculating about other cases and the relative proportional culpability or whether this is the worst of the least mitigated. That term is dicta from U.S. and Florida Supreme Court cases. That's not in the jury instructions. That's not for the jury's consideration. So we would object to that, Your Honor.
And my response, Your Honor, is in the end, they're instructed about weighing aggravating factors versus mitigating circumstances. But in the end, they have to decide what they feel is appropriate. And what I'm proposing, I would submit is valid argument, and it would be in a general term. It wouldn't be trying to identify specific cases.
Okay. So as the state's motion is drafted, specifically the state requests that the defense not be able, during penalty phase, be able to discuss actual sentences in unrelated cases. So as to just the strict wording of the motion, it's granted. However, that does not preclude any of the defendants from arguing that the facts of this case, combined with their own mitigators, that does not rise to the level of worst of the worst, mandating the imposition of a death sentence. So generally speaking, you can argue that why it is your client should not be sentenced to death.
Thank you, Your Honor. As to the 6th penalty phase motion, I would have no objection. Would not talk to the jury about prior statutes regarding the death penalty.
Okay, so Without
Your Honor,
objection.
as to the state's fifth motion, you're granting the motion as to the defense comparing or regarding the facts or sentences of others specifically?
Correct.
Okay.
So there's not going to be specificity, but generally speaking, all of the defendants, if we get there, will be able to argue, generally speaking, why the death penalty is not appropriate for their particular circumstance. Okay, moving on, then grant the state's sixth motion for order in limine during penalty phase.
And Your Honor, the state also filed in each of the defendant's cases a motion to compel the defendant to provide penalty phase witnesses and evidence.
Right, and I issued an order setting a deadline for that. Has
That was met.
Okay. So the motion is granted, and Mr. Hernandez has indicated that he has complied with all deadlines established by the court for Mr. Murphy.
Thank you.
Okay.
I think the language of my response was that I reserve the right to be able to make amendments if so needed, but I don't have it in front of me, but I can tell the court that it was timely responded to.
Judge, I believe that did the court's order anticipate witnesses and expert witnesses penalty phase?
I believe it did. Let me pull it up.
And
That's my understanding.
we did provide
Yeah.
that.
Okay. So the state's motion to compel also contemplates in paragraph 4 reciprocal discovery as far as records, because I find typically in these cases, as we're progressing through guilt phase, at some point, the state's provided thousands of pages of records. That puts us in a very untenable position to allow our experts to have time to digest that information before they conduct evaluations of the defendant. That's the type of information I'm asking for also in the motion to compel.
Right, and in my scheduling order, I gave a deadline for the defendants to all identify any expert witnesses that they intend to call at penalty phase, including the provision of any and all supporting reports, documentation, anything that the experts relied upon.
Our doctor has been listed. He has not provided a report yet. In fact, I think he wants to see him one more time. And Mr. Harmon and I have talked about scheduling his deposition later this month.
Okay, well, I granted the motion, so there's an ongoing obligation for defense counsel to provide reciprocal discovery.
You know, I have 14 motions that I think I can go quickly through, if the court would allow me, because I have them numbered a certain way. The first one is motion to declare sections 921.141 and/or 921.141 subsection 6, subsection H, Florida statutes. It's basically the hack motion.
Okay.
We're declaring that be declared unconstitutional facially and as applied, and I would rely on my memorandum of law.
Okay, that's fine, and just so, Mr. Hernandez, it will make my life simpler, when I was given a list of the pending motions by the state, and they were broken down as far as numbers and when we were going to hear them. So I have them broken down by the dates that we originally scheduled to hear the motion. So, for example, it would be helpful to me, I'm looking at the motions that were initially scheduled to be heard February 26th. And as to Rashad Murphy, the motion to preclude the imposition of the death penalty.
Your Honor, I have them numbered my way. I didn't have them, but I can get to whichever one you want to get to.
Okay.
Which one is it?
It's the motion to preclude the imposition of the death penalty, and specifically that the retroactive application of a death penalty statute enacted in 2016 or 2017 violates Article 10, Section 9 of the Florida Constitution.
Judge, I guess I am having difficulty finding it.
Okay. All right, okay. So, hold on, let's do this. Murphy. Chance. going to pull out all of Mr. Rashad Murphy's motions that I have, and we'll go through those.
I apologize.
It's all right.
I did not have your numbering, and I just numbered them
worries.
separately myself. The first one was the heinous, atrocious, or cruel aggravator motion that I just referred to.
All right, give me just a moment.
And, Your Honor, before I forget, I would request to move orally to adopt any death penalty motions that were filed by co-defendants.
Okay, granted. We have about 60 motions, so just give me a moment. Okay, I think I have pulled out all of the penalty phase motions that were filed on behalf of Mr. Rashad Murphy. So tell me, Mr. Hernandez, which one you want to start off with again?
The first one that I mentioned, Your Honor, was a motion to declare, it's the heinous, atrocious, or cruel aggravator motion, asking that those sections of the Florida statute be declared unconstitutional.
What's the
facially
actual, oh,
and
here it is,
applied.
okay. Just making sure, so you're arguing motion to declare sections 921.141 and/or 921.141-6H, Florida statutes heinous, atrocious, or cruel aggravator, and/or the current 6H interim instruction unconstitutional facially and as applied, correct?
Your Honor, and I'm relying on my memorandum of law that I've attached, so I don't have any further argument.
Okay, and state, you filed a response to that as well?
We did, Your Honor.
You're relying upon that?
Yes, Your Honor.
Okay, I will deny the motion. Okay, what's
Your Honor,
next?
the next one on my list is titled Motion in Limine Precluding Improper Penalty Phase Argument. And Mr. Harmon has indicated that he does not object to it.
Okay,
No objection, Your Honor. We don't plan on making any of the arguments in that delineated.
okay, that motion is granted.
Your Honor, number 3, I have motion in limine regarding reference to non-enumerated mitigating circumstances, and I believe the state does not object.
We do not object to that motion.
Okay, that one is granted. Okay,
Your Honor, my next one is, number 4, is motion to allow testimony of the impact of defendant's execution on family members. The state, I believe, objects to this one. I think they object to the rest of mine. My argument, Your Honor, to this is the fact that mitigation can be anything. And the fact that he is greatly loved by family members should be something that I should be able to present to the jury. And I would rely on the Lugo case that's in the motion 845 Southern 2nd 74. It's a Florida Supreme Court case, 2003.
okay, Mr. Hartman.
Your Honor, we filed a written response objecting to this. I can make additional argument if the court wishes, but
Well, what is it specifically, Mr. Harmon, are you concerned? I mean, you would concede that obviously, the defendant can call witnesses to testify as to the, why it is that Rashad Murphy should not be executed, and that, if he's a good brother or son or provider, or whatever it may be, right?
I
And-
do.
And so, but I guess where we're having an issue was whether or not those same family members would be able to testify as to their feelings should Mr. Rashad Murphy be executed, correct?
The impact of the defendant's execution, this was a future event that has not occurred. We don't know when it will occur. We don't know if the defendant would even ever be executed or if he would die naturally in the Florida State Prison. We don't know if the family members would still be alive when he was executed. It is such an unknowable fact for them to testify about. We believe that's improper. I have no objection to family members taking the stand to express to the jury why they believe his life should be spared.
Okay, let me look at Lugo, and I'm going to take that one under advisement, so,
Yes, Your Honor.
okay? Let you know.
Your Honor, the next one is titled Motion to Declare Florida's Death Penalty Unconstitutional, and in parentheses, it states unreliability. We believe that the argument, Your Honor, is that the fact-finding process cannot be deemed sufficiently reliable to justify imposition of the death penalty, and I would rely on the cases that are cited.
And just to make sure I'm on the same page, motion to declare Florida's death penalty unconstitutional as to unreliability. That's the motion
Yes,
we're
ma'am.
discussing. Okay, and state you filed a reply, which I have reviewed. Anything further?
No, Your Honor.
Okay, I will deny that motion. Okay,
Your Honor, the next one is the, it reads, motion to declare sections 921, 141, 6I of Florida statute. It's the cold, calculated, and premeditated motion. I'm relying on the memorandum law that I've listed. I'm arguing that the statute is unconstitutionally vague, overbroad, and it is applied in an arbitrary and capricious manner in violation of the 5th, 6th, 8th, and 14th Amendment to the U.S. Constitution, as well as Article 1, Sections 2, 9, and 16 of the Florida Constitution. And I would rely on the cases that are included in the motion.
okay, state filed a reply, which I have reviewed. Anything further?
No, Your Honor.
Okay, I will deny the motion.
The next one, Your Honor, is titled Motion to Declare Sections 921, 141, subsection 8 of the Constitution unconstitutional as requested for proffer of impact testimony and pretrial ruling on whether the danger of unfair prejudice of that evidence outweighs its probative value and or otherwise denies a fair sentencing proceeding. I am basically, I'm objecting to the use of victim impact evidence.
All right, and state you filed a response.
Yes, Your Honor.
Okay.
We rely upon that.
All right, so I will deny the motion as far as it's phrased that the statute is unconstitutional. Obviously, the case law controls how victim impact evidence actually comes in, which we will comply with, but just as to this motion that it's unconstitutional, the provision of victim impact evidence, I will deny that motion.
Thank you, Your Honor. The next one, which is my number 8, motion to declare sections 921.141 and or 921.141(6)(b) of the Florida statutes and to be declared unconstitutional. It basically, the argument in this motion is the prior violent felony aggravating factor of this section should be declared unconstitutional as vague and overbroad and has been applied arbitrarily and in an inconsistent manner, and I would rely on the cases cited.
Okay? Anything further from the state?
No, Your Honor.
Okay, I'll deny the motion. next up.
Number 9 is a motion to exclude evidence or argument designed to create sympathy for the deceased. I think I believe Mr. Harmon can correct me if I'm wrong. He agrees to paragraphs 1 through 4. I will not be, or that he would not be arguing the victim impact for the purpose of seeking sympathy for the deceased or in support of any aggravating factor.
Okay, Mr. Harmon, anything further?
Your Honor, we agree to paragraph 1 through 4 of the defendant's motion. The evidence designed to create sympathy for the deceased is inadmissible in the guilt innocence phase, and we certainly don't intend on getting into any type of sympathy evidence or argument in the guilt phase. Paragraph 5, we disagree with. The admission of evidence concerning the deceased or the circumstances is inadmissible under Florida law in the penalty phase. Well, that's clearly law. Circumstances of the case to support multiple aggravators in this case will be argued in the penalty phase. Evidence concerning the deceased would be victim impact. However, Mr. Hernandez did state as to what I told him that we would not argue victim impact to support any aggravating factor.
That's correct.
Okay. All right. Anything further?
No, Your Honor.
All right. So as to this particular motion, the motion is granted as to items in the motion identified in numbered paragraphs 1, 2, 3, and 4, and it's denied as to paragraph 5. Again, the state is entitled to present victim impact evidence in conformity with the case law.
Your Honor, yes, number 10, there's some repetition here, but it's a motion to limit victim impact evidence, and A through F are the very paragraph or the areas that we're asking for limitations, and we would rely on the case law that's in the motion.
Okay. State what your...
I'm sorry, Your Honor. What is that?
We're on motion to limit victim impact evidence, and specifically, they're requesting only one witness may testify. The witness must be an adult. The state must proffer a proposed victim impact statement in writing. The court must hold a hearing on the admissibility of the evidence prior to its admission, and the court must consider relevant case law. The testimony must be limited to the prepared statement. No witness may testify if the witness is unable to control his or her emotions.
So, Judge, we object to the remainder of the motion, including that portion. Limits on victim impact of one witness, that's not supported in the case law. There are cases where up to 12 witnesses have been allowed, 12 impact witnesses, even more in some cases. In this case, I'm not sure how many we would call. I know the court is aware we normally try to proffer impact through written statements by the family members, but there have been cases, I have presented the impact statements in the past from the community, to include friends, family, in-laws, things like that. So I don't believe that these limitations are...
Okay, so you object to only one witness, correct?
I do, and I object to limiting age, that type of thing.
So you object to the witness must be an adult?
I've never called anyone other than an adult in impact. I don't believe in this case that's an issue.
Okay. What about the state must proffer a proposed victim impact statement in writing?
We normally do that, Your Honor, just I believe it works better that way.
Okay.
The pretrial rulings on the admissibility, so I have no objection to that, I guess.
Okay, the testimony must be limited to the prepared statement, right?
Yes.
Okay?
Yes.
And you agree no witness, either for the state or the defense in penalty phase, can testify if they cannot control their emotions, right?
I do agree, Your Honor.
Okay. So as to Rashad Murphy's motion to limit victim impact evidence, it is denied as to paragraph A, and that only one witness may testify. However, if we get to penalty phase, Mr. Hernandez, if you want to renew an objection, if the state, you think, is intending to call too many witnesses for victim impact, then you can renew your objection at that point in time, once we get down to the actual evidence that's coming in. But generally speaking, paragraph A is denied. At this point, I'm going to grant paragraph B, that the witness must be an adult. Again, if for some reason we actually get to penalty phase and the state intends to call a minor, we just need to talk about it before you do it, Mr. Harmon.
Yes, Your Honor.
C, the state must proffer a proposed victim impact statement in writing. That's granted, and that victim impact statement needs to be provided at least 24 hours before the witness testifies. So that way, if there's a problem, we can discuss it. All right? I will agree to hold a hearing on the admissibility of the evidence if there's a dispute. Okay, so that's granted. Paragraph D. E, the court must consider relevant case law. I concur, I must, so that's granted. And the testimony must be limited to the prepared statement. That's granted. That's paragraph F. And paragraph G, no witness may testify if the witness is unable to control his or her emotions. So that's granted. Okay?
Your Honor, the next one, number 11, is a motion to preclude application of the most recent amendments to Florida Statute 921.141. In this case, such application would violate Florida Statute 775.022, where our position is, Your Honor, that for the death penalty to be imposed, there should be a unanimous 12-0, and as opposed to an 8-4.
Okay. State, you filed a response. You relying upon that?
Yes, Your Honor.
All right. I will deny the motion.
Your Honor, number 12 is motion to preclude imposition of capital punishment on the ground that the death penalty is presently administered is per se cruel and unusual punishment. And I would rely on the memorandum of law that is attached.
Okay. And state, let's see, you filed a response. Are you relying upon that?
Yes, Your Honor.
Okay. I'll deny the motion.
The next one, Your Honor, number 13, is a motion to preclude the imposition of the death penalty. And again, I would rely on the memorandum of law that is attached.
All right. State, you filed a response. Are you relying upon that?
Yes, Your Honor.
Okay. Deny the motion.
And then finally, Your Honor, a request for jury instruction. It is our position that in order for an aggravating factor to be considered by a jury, it should be beyond all doubt, not just reasonable doubt, and we're asking for that jury instruction, and I would rely on the case law submitted.
Okay. State, you filed a response. You relying upon that?
Yes.
Okay. I will deny the motion. That's all I have for you, Mr. Hernandez, for Rashad Murphy. Is that all you have?
Yes, Your Honor. Thank you. That's all I have.
Okay, very good. Okay, so let's go back to Mr. Gathrights' motion to suppress. Mr. Wise.
And Your Honor, which would you like to
You pick.
address first? Okay.
You tell me.
Well, I have looks like the traffic stop first on the pile, or the, not really a traffic stop. This is really a multi-layered
Right.
motion, of course. But this is a motion to suppress all the evidence that comes following the traffic stop of Mr. Gathright. And, you know, our first layer is that the stop itself was illegal. Obviously, everyone pretty much recognizes it was a pretextual stop. I recognize, of course, that pretextual stops are legal as long as there's an objectively reasonable basis for the stop. The problem here is that there was not. The two officers who conduct the stop testify that it's based on speed and intent. Now, they clearly have every intention to stop Mr. Gathwright's car. Detective Barry is actually in the criminal apprehension unit, which apparently his main job is to conduct stops like this. Despite all of that, neither one have a dash cam in their car. No one has a radar gun or any kind of way of clocking the speed. They both testify as to the speeding, that they estimate the speed, but they've only seen the car for a quarter of a mile, approximately. Neither one of them, even today, can testify as to what the speed was on the road where they conducted the stop. They said 35 to 45, but neither one of them even knows what the speed was. And just the same, neither one of them knows what they thought Mr. Gathright was going at the time. So under the circumstances, Your Honor, particularly given that this was a plan all along to make the stop, this is not an objective, reasonable basis for the stop. And even though estimating speed can be a basis under Florida law, the Allen case that I discuss in the memorandum says the estimate has to be reasonable and credible. And in this case, under these circumstances, it's not a credible estimation of the stop. The second basis for the stop, the tent violation, is also not an objectively reasonable basis. And I have a couple of statutes I had not cited in the memorandum, but I can provide. If you'd like me to approach, I can cite them.
Sure.
But it's really just two traffic statutes that pertain to tent violations.
And for the record, you've handed me 316.2954 and 316.2951.
Yes, sir. And here, again, at least Officer Baer, I can't recall if Detective Griffin claims he sees a tent violation as well. I think he may have. But neither one of them end up measuring the car. Someone else does. They don't know what the reading was. But in any event, Detective Barry issues a citation for a tent violation at some point. But he issues it, as he testified, for the tent being less than 15%. The problem with that, Your Honor, looking at 316.2954, it states, for most cars, I guess you could say, that is the law. If it's less than 15% in the visible range, that's a tent violation. And that's what apparently Detective Barry relied on. But it makes an exception for what are clearly SUVs, and the officers testified, and I think everyone knows a 4Runner is an SUV, but one of them testified to that fact, that something that qualifies as a multi-purpose passenger vehicle is allowed to have rear windows that have a light transmittance of at least 6%, so substantially lower threshold than the 15% that's most applicable. And then looking at the other statute, 316.2951, it defines what a multi-purpose passenger vehicle is, and I think that clearly is a sport utility vehicle.
Well, it says 10 persons or fewer.
Yes.
Does that include a?
The way I interpret it, Your Honor, it can be, it's 10 or fewer if it's constructed on either a truck chassis or has special features for occasional off-road operation. The statutes do not, as I see, define sport utility vehicle. I think that definition clearly would encompass a sport utility vehicle.
A 4Runner, a Toyota 4Runner can carry 10 people legally?
Well, 10 or fewer. I don't think that it has to be, if it were 10 or more, I think that'd be problematic, but it's 10 or fewer constructed on either a truck chassis or for special features for occasional off-road operation.
Okay.
So in any event, I think that encompasses what a 4Runner would be, and that pertains to, when you read in conjunction with 316.2954, it allows for tent to be 6% or higher. So clearly, I think the officers, well, I quite frankly think it was a pretext. It was a case of stop the car and figure out a reason later, but in any event, it wasn't objectively reasonable because I believe they were relying on the wrong statute regarding the tent violation. Next layer, though, would be the search of the car, of course. And I believe there really are two issues with regards to this search. Number one, Detective Griffin is the only one who allegedly smells the scent of marijuana. I don't believe that his testimony in that regard is credible at all, based on what you saw last week. So he stops the car, is talking to Mr. Gathright at the car window for quite some time. Detective Barry also comes to the car window to get the license. Detective Barry never smells marijuana. Detective Griffin, after some time talking with Mr. Gathright, claims to have smelled the scent of marijuana. He says, in his own words, it was a faint smell. You can't distinguish between whether it's fresh or burned, but he claims he smells marijuana. When the car is actually searched, there is a small amount of residue in a sealed mason jar. The quantity is too low to even be able to try to weigh it. There's no presumptive test performed on it, probably because it's of the small amount. It's in a sealed mason jar in a sealed backpack inside the car. There is no way that could be giving off any kind of odor of marijuana that be detectable from outside the car. And there's no indication, he testified he doesn't see any signs of impairment on Mr. Gathright. You can't say that it's a smell of burned marijuana that might have taken place, you know, if someone smokes in the car sometime earlier and then drives. He says it's a faint smell of marijuana. The facts just don't support his claim that he smells that from outside the car. But number two, even if he did, the law has changed considerably in the last several years, and the Williams case in particular that was issued back in the fall recognizes that there are numerous forms of marijuana or of the cannabis plant that are legal to possess under state law and federal law. Anything basically that qualifies as hemp under state or federal law looks like illegal marijuana, smells just like it, and no one can determine which it might be just based on the smell. Aside from that, of course, under state law, medical marijuana can be lawful in certain circumstances, and for a time it appears this Delta-9 marijuana was lawful to possess. But in any event, the hemp is lawful under both federal and state law, and no one can really distinguish between the two. And that's why the Williams case has now held, similar to Baxter in the 5th District, I think the year before, that the odor alone is not enough to support stopping. Now, what happened in Williams, and I'm sure the state's going to argue that, is that in Williams they found that even though that's the law now, when the search was conducted, we had a different precedent. So they said that the officers acting on good faith reliance could do that. Here, the problem again, aside, just for the record, I would argue, saying that good faith reliance is okay really doesn't make a lot of sense in this situation because the laws that the DCA has recognized changed, happened long before this search was conducted. So I don't believe that it actually is reasonable to say officers should have been able to rely on prior precedent when the laws that legalize forms of marijuana were in existence. But the other problem in this particular situation is I don't believe officers were acting in good faith. We know very well they were looking for any reason to conduct a search of that car. I would suggest to you this is a classic case of we'll search first and we'll figure out justification later. I guess you could say luckily, but there was some little form of marijuana found in the car that they could rely on. But clearly, under the totality of the circumstances, this search is being conducted because they want to find evidence from this case, and they're going to find a reason later. And they find that little bit of residue to justify it. It's not good faith reliance on prior case law. The next level, Your Honor, of this motion is assuming, hypothetically, that the smell of marijuana would give the reason to search the car. Law enforcement goes far beyond searching for potential marijuana and more importantly, in what they seize from the car. Law enforcement seizes these casings from the car. They're not unlawful to possess, just like the rifles. Now, there's a claim that handguns could not be possessed because of Mr. Gathwright's age, but there's no prohibition on possessing fired casings. There's no prohibition on, even if they're for a handgun. There's no prohibition on rifles. There's certainly nothing illegal about the laptop and iPads he possessed, but all of that is seized from the car based solely on this scent of marijuana. Now, we know very well why everything was seized, but there has to be an objective reason to do it, and there wasn't here, especially for fired casings. I mean, he's not a convicted felon. There's no reason he couldn't possess those to begin with. Last layer of the search, or of the motion rather, is all of this evidence is then used to get the search warrant for Mr. Gathwright's house. I think everyone who testified about that agreed that search warrant would never be saw it even. It certainly would not have been approved, but for the evidence that's found in the car. I recognize, and I'm sure the state will point out, that that search is being conducted by Jacksonville officers regarding really, it would appear, I don't even think it was the earlier Charles Jones shooting. It was another shooting they linked to casings that were found. But what's significant is they still seize substantial evidence that they're trying to use now in this case. And that would never have happened but for the illegalities that occurred during the traffic stop. And I believe even though it's conducted by Jacksonville and the warrant is sought in connection with a different case, it's clearly a fruit of the poisonous tree, because but for the illegal stop, the illegal searches, there would never have been a search of the house. And I believe those cover all of the bases that I'd be relying on for this motion.
And you mentioned it, and I just want to make sure we're on the same page. You concede that the second DCA in Williams, they actually affirmed the trial court finding specifically that the law in our district at the time of Mr. Williams' arrest, and Owens was the law in the second DCA at the time of Mr. Williams' arrest, and it expressly permitted the search based solely on the odor of cannabis. Thus, by following Owens, law enforcement was acting in objectively reasonable reliance on binding appellate precedent. We therefore affirm.
I certainly agree that that's what the second DCA
Okay,
concluded.
and that the arrest in this case and the search of Mr. Gathraight's car occurred prior to the Williams opinion being issued, correct?
That's correct. Yes.
Okay. Okay, Mr. Wise, thank you.
I see you guys asking a lot of questions. So the defense is saying Sean's car was searched because the law enforcement smelled marijuana. Once they did that search, they found all kinds of incriminating evidence, including casings found at a previous shooting of Charles Jones, along with weapons and firearms and stuff. So defense is saying if law enforcement hadn't smelled marijuana, they would have never searched Sean's car. That's why they're bringing in the smell of marijuana. So I hope that clears things up. But if you have more questions, just go ahead and ask.
And Your Honor, the state is relying on Williams v. Florida, that second DCA case as well. It is clear that there was a objective legal basis to stop that Toyota 4Runner in Jacksonville. You heard from two law enforcement officers from Jacksonville who were in separate vehicles, who both are trained and certified in estimating the speed of a vehicle. They both obtained that week-long class where they were able to demonstrate that they were able to accurately estimate vehicles within 5 miles, tested against a radar gun. They both had that training. They both passed that training. And with regards to Detective Griffin, he says that he still utilizes that training and makes that type of estimation 1 or 2 times a week as part of his duties in his present job. And they both estimated that the defendant was speeding. They chose to just give him a warning in that instance, so that there were 2 bases to believe that the defendant should be stopped. The other one was that tint, and you heard that he was actually given a citation for that based on another detective coming out there. They actually came and they measured the tint, and that was within the range that was not valid, so that he was issued a traffic citation stop based on the illegal tint that SUV had at the time. So there was a reasonable basis to do that. And you heard from Detective Griffin that he smelled the faint odor of marijuana when he was standing at that vehicle. Officer Berry had already taken the license at that point and had walked away. And based on a search of the vehicle, based on the smell or odor of marijuana, they indeed found marijuana, which again goes to support that that was a credible observation by Detective Griffin, that he actually did smell the marijuana and was able to conduct a legal search of that vehicle. In searching that vehicle, any place where you could find marijuana, he found a handgun. and the defendant was 21, under the age of 21 at the time, and the defendant was arrested for 2 bases, based on possessing the marijuana and drug paraphernalia, as well as a person under the age of 21 possessing a handgun. Those were bases to arrest the defendant and conduct a inventory search of all of the vehicle. And you heard that it is protocol whenever not just a firearm, but any sort of ammunition or parts related to firearms, when they are found in a vehicle, regardless whether it's a search warrant or an inventory search, all of that gets put into NIBIN as part of their procedure. And it is the NIBIN results that lead to the search warrant, a properly executed search warrant of that house in an unrelated homicide investigation, which provides for all of the evidence then that is related in this case. It really does turn on the traffic stop, and there was a reasonable basis for law enforcement to stop that vehicle and then conduct the search that they were able to find all of the other evidence in the case. So, Judge, if there is a reasonable basis to stop, and we rely on the Williams v. Florida case, which was decided in October of 2025, where they said that no longer would you be able to use the smell to justify a search of the vehicle, but good faith reliance on binding precedent at the time, which was October of 2025, they're not going to suppress any evidence based on a search based on smell. And this search happened the year before. So we would ask that as well, Judge, that good faith reliance, that was binding precedent, that was the law at the time of. Law enforcement was able to conduct a vehicle search of Mr. Gathwright's Toyota SUV based on that odor and smell of marijuana. He went into his credentials, his familiarity with that smell, and that search did in fact lead to marijuana within the vehicle. So based on all of that, we'd ask you to deny the defendant's motion to suppress.
Okay, Mr. Wise, any rebuttal?
Just briefly. With respect, I recognize at least one of the detectives, I think they both talked about this, the class that they'd taken. And they may be qualified at times to make traffic estimations as far as the speed someone's going. But the problem is, it has to be reasonable and credible. That's what the case law says. You can estimate, but it's got to be reasonable and credible. And that's the problem here. It's observing for a quarter of a mile, can't even say what the speed limit is, even to this day. Can't remember how fast they thought Mr. Gathwright was going. So I would suggest, even though maybe they're qualified under some circumstances to make the estimate, we don't have the evidence here to support that, to show that it's reasonable and credible. Again, as to the temp violation, it's measured, but no one last week had even testified what the measurements came out to. And I believe, as I pointed out, I think they were relying on the wrong statute quite clearly when they were reasonably, in their minds, objectively determining that the temp was not lawful. Williams, again, before obviously reaching the point where Williams would come into play, there has to be finding that the smell, that the testimony you heard was credible, that the officer actually smelled the marijuana. I don't believe that finding can be made given the testimony from last week. But even if it could be, I obviously don't agree with Williams and their conclusion that they should rely on it. But this isn't a situation, even recognizing that holding, where the officers are relying in good faith on Williams. They're trying to find any reason they can to justify the search, and they clearly, obviously it's a pretextual search, no one's really disputing that, but it makes no sense for them to come back and rely on Williams after finding this little bit of residue. With regards to the casings being placed in the NIBIN and the various other firearm evidence being collected, that's a seizure. And I don't believe that there was a lawful basis, given Mr. Gathwright is not a convicted felon, to seize casings from the car and put them into NIBIN. That goes beyond searching for marijuana. It goes beyond even an inventory search. That is a seizure.
What's your position on whether or not there was probable cause to arrest Mr. Gathwright for the for the gun that was found in his car and he being under the age of 21?
Well, they don't do that, I don't believe. And under the circumstances, I can't agree that would give probable cause alone to arrest him for that. We don't know, sorry, to arrest him for that. The car, for what it's worth, is registered in his mother's name. His mother is a retired Marine. The handgun is not in plain sight. It's deeply concealed within the car, so I don't believe there was probable cause for that. But again, even then, the Nibin hits, the last argument I think the state was making, the Nibin hits didn't provide a lawful basis to search the house because there would never have been Nibin hits if it weren't for all these illegalities that led to the Nibin hits.
Okay, I understand, thank you. Okay, I'm going to take it under advisement, I'm going to do a written order. All right, so then we have Mr. Gathwright's motion to suppress evidence illegally obtained from the defendant's iCloud accounts.
So this is a much different motion, obviously, Your Honor. It probably became apparent last week that I was a little surprised by some of Detective Ramos' testimony. That may not have been apparent, but I set out in the motion, and I was intending to argue that what I believed was a date range, a temporal limitation in the warrant, was overbroad. And from Detective Ramos' deposition, in all fairness to him, he couldn't really remember every search he conducted because he conducted many searches, but it was that if there was a temporal limitation, I would have stayed within it. Clearly, he did not. He testified last week he had no intention at any point of limiting what he was going to search from the iCloud, and he clearly did not. He searched the entire thing. That's what he testified to last week. That, Judge, I don't even know that it can be questioned that would not violate the particularity requirement of the Fourth Amendment. This is an evolving body of law, but the cases that have addressed this, several 11th Circuit cases, and then I think the Demons case is probably the most on point state of Florida case, they recognize you going in and searching someone's iCloud account is the equivalent of a general warrant. It's just rummaging through basically their life. In this case, it was rummaging through almost 4 years of Mr. Gathwright's life. That's why a lot of this goes back to the McCall case from the 11th Circuit, and Demons relies on that, but there have to be temporal limitations on what is being searched when a warrant is being sought for something like an iCloud account. In reading the warrant and the affidavit that Detective Ramos drafted, it could appear that there is a date range of June 1st, 24 to July 12th, 24, which I believe even that would be substantially overbroad under the current case law. But Detective Ramos stated he was not limiting the search to that date range, and he had no intention to do it. It sounds like it's somehow auto-populated that he did the affidavit. And when he submitted the request, and in the warrant that was actually signed, it basically provided free reign to review the equivalent of everything that was in the iCloud account. All emails, all instant messages, all iCloud data associated with backups, all contacts, all records and information regarding locations, all data stored in location services, all records pertaining to the type of service used, records of games, videos, other remotely accessible data, and the associated IP addresses, all files, keys, basically anything you could think of that could be in an iCloud, he includes in this affidavit and in the warrant that he drafts. Even if that's problematic in itself, even if we have a temporal limitation of a month and a half, but there was no limitation whatsoever. It essentially went back to March of 2021.
Well, didn't he testify that Apple just gave him everything?
They did, and I think in the deposition that's what he thought happened. And even if that's the case, Apple clearly did give him everything, and it's addressed in a couple of other cases I'll get into, but even if that was the case, then he would have a reason to limit it to whatever dates were in the warrant. So even if arguably this could be read in the warrant as a temporal limitation, which he apparently did not read it as, then he has a duty to confine what he searches to that. And I asked him about how, wouldn't it be easy to just click on the last access date and it organizes everything by that date? You can search only things within that date range. But he had no intention of doing that. He looked at the entirety of the life of the account, almost 4 years worth of material, at least 3.5. So even if that was a limitation, and even if Apple ignored it, he made no effort whatsoever to limit what he actually searched. That, Your Honor, I think clearly violates the holdings in Blake, which I think is the probably the main 11th Circuit case that addresses this. In Blake, they addressed two different warrants. There was one to, I think it was Yahoo. There was one that they found was not problematic, although it appears in reading Blake that they were that was even a close call. But then there was a Facebook warrant in Blake that they found far exceeded the particularly requirements of the Fourth Amendment. This one is just like that. It really had no temporal limitations, and it had no categorical limitations. It was what they found to be the equivalent of a general rummaging warrant. I don't know if the state, really can even argue that did not violate the Fourth Amendment, especially the way the warrant was executed. But I think a big issue now that's addressed in the Demons case that I cite is, according to Demons, there can be an attempt to try to, I think, basically parcel out what was unlawful, what went outside the temporal limitations, and focus on what may have been reasonable. They did that in Demons, but they also said that it's not always going to be appropriate and not always going to be feasible. In that case, and unfortunately, Demons, they don't really say, they don't talk about why that warrant was overbroad. It appears the state agreed it was overbroad, but then they made an attempt to limit it to information from the time of a shooting that was being investigated and a few hours before and after. But in reaching that point, they noted, relying on a couple of federal cases from other circuits, one being Gulp and the other being Pilling, which I have a copy of, but they said that even when parts of a warrant may be valid and distinguishable, severance may be appropriate if the sufficiently particularized portion is only a relatively insignificant part of a sweeping search, or where the warrant is generally invalid but has some tangential item that meets the requirements of probable cause. The problem here, Your Honor, is it's far from a relatively insignificant portion of the warrant, whatever might have arguably been relevant, because we have, again, 3.5 years worth of Mr. Gathwright's life that is collected in this iCloud. And really, based on Detective Ramos' testimony, there was no significant limitation that he could establish that might have been lawful. And even if there had been, he completely ignored it and went far outside of whatever limitation it might have been. I had been prepared to argue that June 1st to July 12th was substantially overbroad because it encompassed far more time than this conspiracy could have even arguably existed. And we went back and asked when was this first advertised that there would be a Charles Jones show in Tampa, and that was June 14th. So anything before June 14th could not have impacted this, could not have been evidence of the conspiracy, because there could have been no conspiracy. Nobody knew Charles Jones was going to be coming here until June 14th. The evidence or the facts set out in the affidavit are really pertained to actions that occurred from June 22nd to June 28th. In any event, nothing before June 14th could have been relevant. Yet, this goes 2 weeks before that and then goes substantially beyond the time the conspiracy was alleged to have existed. Under the circumstances, Your Honor, and I would provide, I cite to most of the cases I'm relying on, but the one that I didn't cite is Pilling, which I have a copy of.
Okay.
It's referenced in Demons.
Okay?
It's a district court case from Idaho, so obviously not binding on us, but it's a very, very similar circumstance that they dealt with. And that one, and Demons, I believe I said, also relies on that. But in that one, basically it's the same thing. They get an entire Apple iCloud dump. Apparently there's some discussion about, there may have been some attempts to purge the information that would have gone outside the relevant limitations, but it states, and this is on, I believe it's the third page of the printout, that the government realized it inadvertently failed to purge the data, and essentially everything ended up being looked at. It appears that was done accidentally. Here it was done intentionally. But in any event, they go forward, find that the warrant was substantially overbroad, just as we have here. And then at the end of the case, the last 2 pages, they discuss why severance can't apply in that situation. And similar to what the court found in Demons, they're saying that you can't sever this because of the relative size of the valid and invalid portions of the warrants. And the portion that might arguably have had some relevance was relatively insignificant given the substantial size of the information that they had. Then they go on to conclude the opinion by finding additionally that the suppression was also justified because the government did not filter any of the unresponsive data before reviewing the defendant's entire iCloud account. And that's exactly what happened here. Even if in Pilling there was some attempt, there was no attempt whatsoever here. As Detective Ramos' testimony established, he had no intention of limiting anything. He was looking at everything that was going to be in that iCloud. And he did so. And I think the substantial portions of what he took out of that he finds to be relevant would have been far outside even the date range in this search warrant. But he didn't confine himself to that in any event. Good faith exception is obviously something that may be brought up. I don't see any way the good faith exception can apply here when the detective drafts a search warrant affidavit that he himself says he has no intention of limiting to any kind of temporal limitation. So even if the court arguably saw this to be a temporal limitation, it was essentially Detective Ramos deceiving the court because he said in his own words he had no intention of limiting what he was going to look at. And then even if the court did, issue what it believed to be a good faith warrant, Detective Ramos had no intention of following the limitation, and he didn't. He went far outside of it. I would suggest, Your Honor, even the date range of 6/1 to 7/12, in light of Blake and the other cases that we rely on, that's a facially deficient warrant. But regardless, Detective Ramos, number one, had no intention of the court limiting it to that date, and he had no intention of abiding by those dates. So I don't see any way the good faith exception could apply.
Okay, thank you, Mr. Wise. Ms. Ismer, why should the state not be limited to the dates of June 1, 2024 through July 12, 2024?
Number one, because the return was accurately complied with by Apple and Detective Ramos, but also because in the months leading up to the incident, several of the items of evidence that were discovered within the time frame that's listed in the original warrant date back to or in some way connected to evidence that's also located on the device in the months before. There were several representations by the defense that Detective Ramos nor Apple abided by the warrant, and I believe there was some insinuation that there was misconduct or an ill intention by Detective Ramos. But if Mr. Wise has read the content of the search warrant, including the probable cause affidavit, what Detective Ramos requested was included in his request were the iCloud backups from both of these accounts from Mr. Gathrigh's devices. And that is exactly what Apple provided. When he backed up those devices between June 1st and July 12th, the information from the months prior were included in that backup. So yes, that is what was provided to Detective Ramos. There was also the reason for requesting such information also testified to by Detective Ramos, because oftentimes those items are either mislabeled, not labeled, and now with Apple's ability to actually change the date and time on photos and videos in devices, they make requests that specifically cover that type of occurrence happening. So it's not an overbroad warrant, but more specifically, the time frame from before the offense itself has several links to the temporal timeline that was provided of June 1st to July 12th. The specific example that we gave, or at least I asked Detective Ramos about, was in particular a photograph that depicted two separate rifles or assault rifles on the ground. The photograph, as it was discovered in the device of Rashad Murphy that had been previously discussed, was sent to Rashad Murphy's device from Sean Gathrigh's device within the temporal time frame that was listed in the warrant. But that photograph actually originated when you selected it or clicked on it in Mr. Gathrigh's device, having been received at a time in March of 2024. And so when you actually open the file and look to created by modified date, you could see the trail of where that photograph came from, and it would certainly be relevant to this case. neither Apple nor Detective Ramos actually violated what was requested in the search warrant or what was actually disclosed or provided in the data that he received. So in looking through the data or the backup that occurred between the temporal timeframes that were listed in the search warrant, which again is also not overly broad given what's been stated and the evidence that they had at the time of the premeditation leading up to the offense itself, and then ultimately the flight from and attempt to conceal their identities thereafter. It's an appropriate timeline of evidence that they were seeking. Several of the Jacksonville detectives also testified about their having seen visually several of the defendants or the defendants getting into it with the victim in this case in advance of his homicide. And so having a time frame which spans before the offense itself and thereafter not only provides a full picture of all of the data that's relevant to the case, but also the relationship of that device and if there are changes. Does this device typically stay in Jacksonville? Did it travel to Tampa on this weekend? You're not only establishing direct evidence from the date of the offense itself, but also the pattern activity for that device as well.
Okay, so if I'm understanding you correctly, so the photo of these firearms that was on Mr. Gathwright's phone, it was originally received on his phone in March of 2024?
Yes, March 27th of 2024 from Isaiah Chance's cell phone.
Okay, so Isaiah Chance sends a photo of So Isaiah Chance sends a photo of Mr. Murphy or Mr. Gathwright?
Isaiah Chance sends a photo of two firearms on the ground, rifles on the ground, to Sean Gathwright.
Okay.
That photo is then sent from Sean Gathwright's device to Rashad Murphy's device in June.
June what?
June 20th of 2024 at 3:02 a.m.
Okay. Okay, and so if I'm understanding you correctly, so in the temporal time limit of June 1, 2024 to July 12th of 2024, so the subpoena goes out to Apple, and then they send in everything that was on the phone during that time period, or that account during that time period, plus any backup. So anything that was backed up during that time frame also gets produced, correct?
Yes, they would not have what's on the physical device. They would only have the backups.
Okay.
Because it wasn't a search warrant for the physical phone itself. Only whatever went to the cloud,
Right.
this, storage location. They would only have, if the device was backed up, whatever that file was and the dates of the backups. So they could
Okay.
only provide or produce backups in the timeline that they were given in the search warrant.
Okay, but that then kind of becomes a dragnet that brings in, even though you're putting a temporal time limit on this application for the warrant, and that's what the judge signs, and that's what the warrant says, nonetheless, because if the device or if the iCloud accounts are backed up during this temporal time frame, then everything that was in the accounts now gets brought back in, correct?
Correct.
Okay. Okay.
The reason it becomes relevant, Your Honor, is for several points. If a file is deleted or altered in some way, it would not have a time frame linked to it. So that would come with the backup. We would often be able to see it if it's deleted and not overwritten. But if it is, sometimes you can't see the file, or sometimes you can say where it says deleted and can't open it. But those actions are also relevant if files are deleted at or near the time of the offense itself. Then the files that link back to the prior incidents, if they are linked to the data that's provided to the offense in some way, that photo I'm talking about from device to device between the defendants, being one of the relevant examples, that is an argument as it relates to weight and relevance for the defense to make. The fact that we can trace that photo back from before this temporal time frame doesn't make it inadmissible evidence as a result of what was disclosed to us. When you open the file, if created date, modified date, and last access date, because you received the photo of guns 3 months ago but sent them 3 days before the murder, certainly those are relevant to the case. So selecting that image, just because the data is dated before the time frame included in the warrant, it's also relevant and related directly to the time frame that we have.
Right, now I understand why the evidence would be relevant. I understand that argument. I guess the question I have is, if the state has the ability to acquire all of the evidence in someone's iCloud account because a backup occurred during the time frame, then it kind of makes the time frame meaningless. There is no time frame, because then if the backup occurred, now law enforcement gets everything just by virtue of the fact that the backup occurred during the time frame, and so then, which makes the temporal requirement then really irrelevant.
If the court is presented with those items that the defense seeks to exclude. So had the state presented to you photographs which we could establish based on the electronic data that dates had been changed on to before the offense, or that had been deleted, the court would have to look to those items to determine whether they were within this time frame, whether there was something in those photographs which allowed us to date it, or there was some evidence of them having been modified, which is why we would not exclude all of the evidence, but instead the defense would have to at least specify which items they are indicating are outside of that.
Okay, are you prepared to do that, Mr. Wise? Are you prepared to make the argument that specific items of evidence are outside of the time frame on the subpoena and therefore shouldn't come in?
I certainly would have been, Your Honor. One of the things I asked Detective Ramos came up in his depo was, he claimed there were photos where Mr. Gathright is making what he believes are gang signs. In my review, I don't think any such photos would have been within this time frame. So I asked him again last week, which ones are you talking about? Because I'd like to try to identify. This has almost 14,000 photographs in it. So it's not something I can do easily, but I've parceled out the ones that I think might have a gang sign. None of them are in that date range. So short answer is yes, Your Honor. Again, I don't think this is severable. I think the entire thing should be suppressed, but even if
I understand.
Even if it's limited, yes. I mean, I'm gonna ask the state to establish a basis for every piece of evidence from that iCloud to show that it came from whatever the court finds to be the appropriate date range.
Yeah, okay.
I can add my rebuttal, but
Yeah, no, I hear you, and I'm probably asking the wrong person. So shouldn't it be your responsibility to identify what items of evidence, assuming I find the time frame of June 1 through July 12th to be appropriate? Just assume for the sake of argument I do. Wouldn't it be your responsibility then to identify what items of evidence the state would intend to admit at trial, and then I would hear argument on whether or not that would be admissible? Would that be your job to do?
Well, at this time, Your Honor, the state's position is that the items that have been received in the response are admissible items. If the court is limiting the state's date range, then the state would obviously assert that the dates that are provided in the warrant are more than satisfactory based on the probable cause that's stated in the warrant. The issue then becomes the images that can be connected to or dated back to the other evidence in the case. So there are ways that the state can articulately provide those items, meaning we just have an evidence view of those items sooner rather than later, and certainly we can do that as it relates to the iCloud account for Mr. Gathright, if that would be beneficial to Mr. Wise, but nothing about that type of evidence view would change the state's position specifically as it relates to the time frame that's listed.
Okay, all right. Mr. Wise, any rebuttal?
yes, I think it would be. One, I certainly disagree that Detective Ramos and Apple did not violate this warrant. I think Detective Ramos' testimony last week, he more or less admitted. I mean, he did admit it. he said this basically auto-populated, and even if that was, which I think it's reasonable to read that as a date limitation, and I think Judge Smith likely did.
Right.
But Detective Ramos sure didn't, because he said himself, he went far outside that. And with respect to the backups, if an account is backed up, it may be relevant to see evidence that it was backed up during that range, but that doesn't just open the door to look at everything that was on the backup. Because if we're doing that, I mean, what's the point of putting any limitations in this warrant?
That's my question.
Right, so I don't see how, again, the fact that it's backed up, sure, that's relevant, if you find that the warrant's severable. But that doesn't open the door to just look at everything in there, and that's what happened. In looking at the hard drive that I have, it doesn't distinguish that I can tell, and I'm far from a tech expert, what was the backup and what was not. It just gives two accounts, which are the two that are in the warrant, and I don't see how it distinguishes between what was backed up and what wasn't. It's just everything. And that includes almost 14,000 photos, 400 and something live photos. I can't remember how many videos. I believe a few hundred, if I recall. It's his life for 3.5 years.
Yeah,
I'm
no,
not
I hear you.
exaggerating. One thing I would add, and I recognize if the court finds, some temporal range to be appropriate. I agree that if there's a photo maybe that's older that is sent during that range, that may be lawful under the warrant. But the problem is, and it's very easy, by the way, to do that, as Detective Ramos testified. You've got categories. You can click last access, date created, last modified. You can sort them all that way. It takes a long time because of the data for it to populate, but it's as simple as clicking a button. So it's pretty easy, I believe, to determine what would have been at least accessed during that range. But that doesn't open the door to going down trails that take it far outside. I mean, if a photo is from 2021 and it's sent during, June 24th of 2024, and the court finds that appropriate, I agree that would be within the range, but you can't keep going down rabbit holes and going far outside the range, and I think that's the problem. One thing I would point out, because I know it was brought up that, there may have been something that Jacksonville detectives knew. Obviously, the search warrant affidavit is confined to what's in the four corners of the affidavit, so I don't believe that, if there's other evidence Jacksonville knows would give a reason to go outside the warrant if that's not something that's included in the affidavit. I've given my reasons why I don't believe this is severable at all, but I think even if it is found to be severable, this date range, and this is what I was prepared to argue before last week, is overbroad as it is. Again, anything before June 14th I think could not be relevant. This has a month-and-a-half range, far beyond what they found in Demons to be appropriate, which was just a few hours before and after a shooting. So in no way am I conceding that this warrant is severable at all, but even if it is, the date range we have is substantially overbroad, and I believe would be a violation of Blake in the many cases that it addresses.
Okay, interesting. All right, I'm going to take this one under advisement as well, but State, if I were you, I would start looking at the items of evidence that you would specifically intend to introduce. And if it was outside of the date range that was in the warrant application, which would be June 1 through July 12th of 2024, and the only reason law enforcement gets a hold of it is because the account was backed up, that's the only way they get it, you all need to start looking at what items of evidence you would actually intend to introduce, and you need to have an argument as to why. Okay? If I were you, I'd start doing that. Okay? All right, very good. I think that's it on the motions to suppress, correct?
Yes, Your Honor.
Okay. All right, it's 12:06, so let's go ahead and take our lunch recess, and we will reconvene, let's say 1:40, and we will continue on with the penalty phase motions.
Monday the 9th.
Because, initially, because they do that, you have to go to state court.
I don't argue that motion.
Right.
Well, what about that? I don't argue that either, I got number 9 here, State my object, but I don't. Well, hold on, Daddy. Hold on, can we do all of it?
They have to read those on next.
But you're doing that in the hospital.
Why can't he go to?
I need him to say about it. Get in the house right now, sit with me. Get the leg propped up. He's hurt this morning. My boy. Judge, hold on, let me catch up. He was almost 13, young. My 13. Yeah, he was all over. I was all over the place looking for him. In order.
I guess back to the penalty phase motions. And I did take a look at the scheduling order that I entered. And the defendants were supposed to have disclosed all penalty phase witnesses, including expert witnesses, by November 17th of 2025. For any expert witnesses, the defense must also disclose any and all records relied upon by the experts in reaching their opinions, as well as any reports issued by the same expert witnesses. And the state had until December 15th of 2025 to disclose all penalty phase rebuttal witnesses, including expert witnesses, with the same requirement to disclose any and all records relied upon by the experts. So I'm assuming everyone's complied with the court order.
Judge, we did list a witness, an expert, and I believe we've drawn his name since we listed him. Does that sound right? Dr. Myers. Yeah, we have been working on trying to replace him. He had to jump off because of volume of other cases. So we're searching right now. We've been searching, so.
Okay? Is he what type of expert is he? Mental health, rebuttal?
Yes, he was a forensic psychiatrist.
Okay. And,
That's for potential rebuttal testimony.
okay. And then, have any of the defendants listed a mental health mitigation expert for penalty
Judge,
phase?
if I could just ask a question regarding Mr. Harmon's statement. I assume that was Dr. Myers as it relates to a particular defendant, Mr. Murphy, or?
Oh, no, it was Dr. Myers. I listed him and I believe all defendants.
Okay,
cases.
okay.
Yes.
Okay. So have the defendants identified mental health mitigation experts in their penalty phase witness list?
Judge, Jenna Finkelstein on behalf of Sean Gathright. I did list a doctor, and I indicated on there it was for mental mitigation. We are working on scheduling her deposition. I provided a couple of dates. I do not have a report yet, so I'm hoping she gets that over to me. I spoke with her yesterday. That way I can get it to the state before the deposition. As far as records, there really isn't much, so I shouldn't have anything voluminous to send over.
Is the depot scheduled?
We talked about 2 dates. I sent over 2 dates yesterday. We don't have it yet scheduled, but we were looking at March, I think I said 25th and 27th.
Okay. What about Mr. Chance?
We listed 2 doctors, we had to remove one, but the other doctor we have scheduled for Monday.
For depot?
For deposition.
Okay.
She didn't do a report, and I'll verify that. I don't believe she has any record for this also.
Okay, that's fine. Well, at a minimum, at her deposition, she needs to be prepared to answer if she relied upon any records and to bring them with her, so they can be disclosed. Okay, what about Mr. Davion Murphy?
Yes, sir. He listed one expert. He has been disclosed. The report has been disclosed. The documents have been disclosed. There might be a potential for listing another expert because we're waiting on an order, and I advise Mr. Harmon of this. We're waiting on an order, perhaps the court may have it, for funding for a neurologist. And then funds to expend for potential brain scans. Brain scans.
Okay, and what type of doctor is the expert that you have listed?
He is a neuropsychologist.
Okay. This would be a different type of expert?
This is a neurologist, we would need a neurologist, and then a neuropsychiatrist.
But you have the person lined up, correct?
Yeah, we're just waiting on the orders.
Let me take a
I
look.
didn't file these motions, but I was in trial, but,
Let me just take a look. There's nothing in my queue. I think I signed some orders a couple days ago
okay.
that were,
Oh, order on neurologist, okay. Okay, so let's continue.
yep, I signed both those orders on yesterday.
Yes, sir, so the neurologist, and then the funding for the reading and scans.
Yeah, I'm not looking at the orders, I'm just looking at the title, but I signed 2 orders yesterday for your client, so I'm assuming that's what they are. So the fund's been authorized, so how quickly can you get this expert witness listed in discovery?
I would first have to get this, my client, potentially, well, first I need a script, then I have to potentially get my client to the facility to get scanned, then I have to get those discs, then I have to send them to the other individual, and so it'll take a little bit.
Okay.
Part of the issue will be also working with the facility to get a date
Okay.
and transport.
All right, so Mr. Davion Murphy still needs to identify his second expert that he intends to call. Mr. Chance and Mr. Gathright have identified their potential mental health expert witnesses. And then what's going on with Mr. Rashad Murphy?
Judge, don't quote me, but I believe the court might have had a colloquy with Mr. Hernandez this morning, and Mr. Harmon maybe can correct me, conversations with Mr. Hernandez about deposing his expert?
Yes.
But he's listed him.
Yes, he said he had listed him. I'm not sure what type of documentation
Sure, that's fine.
followed. But yes, he's been listed.
At this point, I'm just trying to make sure all of the witnesses have been identified.
Judge, although I can't tell the court I was 1,000% listening, that's what I recall happening this morning, is that Mr. Harmon acknowledged that Mr. Hernandez had provided him the name of an expert.
Yeah, so Judge, just to put on the record, all penalty phase counsel has been communicating, we've all been communicating by email about these experts, setting them for deposition, and it's been going very well. All of them have been in communication with me, trying to provide dates and get dates from their experts. Mr. Hernandez emailed me on the 25th of February about Dr. Collins, I believe. Is that correct? Brian, does that sound right?
Scott, I can't tell you.
Okay, so Dr. Collins, he emailed, is planning on visiting Mr. Murphy one more time. I proposed deposing him in mid to late March if that works, and that does work for me as long as I can, have time to get him deposed and get the transcripts back. So,
Okay. So let me just take a look at the calendar here. So, Mr. Harmon, for all of the experts that have been identified, the defense experts, has a deposition date been scheduled?
Not for all of them. I believe the only one I have scheduled right now is with Mr. Pretrial. Is that correct, counsel?
We are scheduled for Monday, yes.
For Monday, yes. Ms. Finkelstein's already indicated she provided dates, and hopefully we'll have that set up by hopefully the end of the day. Ms. Toomey has provided dates, is that correct?
That's correct.
Yeah. So I was out yesterday. I know they both sent emails to me, so I haven't had a chance to review them.
Okay. So you guys have until, today's Wednesday, close of business this Friday. I want you all to at least have dates agreed to, okay? For any outstanding witnesses, specifically the expert witnesses. And then as to the potential new expert for Davion Murphy, the neurologist, how much time do you need?
Judge, I'm gonna have to get with the doctor and see how quickly he can go out and see him so that I can get the script and then I
Okay.
can contact the facility. So I can email him now during this
Yeah.
afternoon and see when's the earliest he can.
And it needs to be rapido, not, because we gotta start, I want this done before we start picking our jury, okay? So my preference would be on or before, at least gets identified on or before March the 20th.
Judge, back to the setting of depositions for all witnesses, including experts. I'm responsible for doing the penalty phase lay witnesses, and there are numerous ones, and I have not started to coordinate. Could I have by the end of the week?
Yeah,
Thank you.
by 5 PM, March the 6th.
Thank you.
All depositions need to be on the books, okay? And then state, how much time do you need to get your rebuttal, penalty phase rebuttal expert identified?
I would ask for at least till the end of this week. I've been speaking with Ms. Toomey about her potential anticipated expert. I've already started looking for a rebuttal witness for that anticipated testimony, depending on if the PET scans or brain scans lead to what I'm believing it may or what they may present. So.
Okay. So are you telling me that you've got to, for sure, hear from Ms. Toomey regarding this neurologist before you can identify your potential penalty phase rebuttal
Well,
expert?
she had mentioned Dr. Wu, and I've dealt with Dr. Wu before. You may recall Dr. Holder from the, I want to say the Ritchie case. He has now become medically incapacitated, so I'm trying to find another radiologist, neurologist to rebut.
Okay.
But I started, she had brought that to my attention last week when we were all having discussions about where we're at in penalty phase with our preparation, and I started looking. So.
Okay. So, Ms. Toomey, see if you can make contact with your potential expert this afternoon, and then we'll discuss this again. Okay?
Yes.
Okay. All right, so let's start off with the state's motions in limine. You all were present, so state's first penalty phase motion for order in limine. Is there any objection to that being granted? Okay, for Mr. Chance? What about Mr. Gathright?
No, Your Honor.
Okay, and Mr. Davion Murphy?
No, Your Honor.
Okay, so that motion will be granted as to all defendants. Moving on to state's second penalty phase motion for order in limine, having to do with regards to any argument or evidence concerning the actual method of execution or any description of an execution or the method of execution. Any objection by Mr. Chance for this motion being granted?
No, Your Honor.
Any objection from Mr. Gathright?
No, Your Honor.
Any objection from Mr. Davion Murphy?
No, Your Honor.
Okay, this motion will be granted as to all defendants. All right, next up, state's third penalty phase motion for order in limine regarding the individual beliefs of any person, organization, or religion on the death penalty. Mr. Chance, Mr. Petratus, on behalf of Mr. Chance, any objection to this motion?
No, Your Honor.
Any objection by Mr. Gathright?
Your Honor, I don't have an objection. What I did advise Mr. Harmon, and I believe it's not stated in the motion, so it shouldn't be an issue. He said argument or evidence. Obviously, this comes up in jury selection. I just wanted to make sure it wasn't.
Yeah, no, we're just
included in
talking
that.
about penalty phase evidence. Okay.
No.
All right, and then Davion Murphy, any objection?
No, Your Honor.
Okay, this motion will be granted as to all defendants. State's fourth penalty phase motion for order in limine. This has to do with any description of death, including any deaths depicted in any novel, motion picture, or television show. Mr. Petratus, on behalf of Mr. Chance, any objection to this motion? Mr. Gathright, any objection?
No, Your Honor.
Excuse me, on behalf of Mr. Gathright.
No, Your Honor.
And on behalf of Mr. Davion Murphy, any objection?
No, Your Honor.
Okay, this motion will be granted as to all defendants. State's fifth penalty phase motion regarding comparing the facts of this case specifically to any other capital case. Any objection to me granting this motion? Mr. Petratus, on behalf of Mr. Chance. As to Mr. Gathright, any objection?
No, Your Honor.
And Mr. Davion Murphy, any objection?
No, Your Honor.
No, Your Honor.
Okay,
No, Your Honor. I was just making sure I didn't.
sure. This motion will be granted as to all defendants. State sixth penalty phase motion having to do with the changing the laws regarding the death penalty in the state of Florida. Any objection, Mr. Petratus, on behalf of Mr. Chance, to this motion? On behalf of Mr. Gathright, any objection?
No, Your Honor.
On behalf of Mr. Davion Murphy, any objection?
No, no, Your Honor.
Okay, this motion will be granted as to all defendants. And as to all defendants, the state filed the state's motion to compel that the defendant provide penalty phase witnesses and evidence. And this motion will be granted as to all. And again, I have a scheduling order, and we will continue to discuss this. And as always, if there's an issue, just let me know. The sooner you let me know, the quicker I can deal with it. Okay, I think that's it for the state's motions. So let me just break down. Let's see. We're going to start with Mr. Chance. Hold on 1 second, let me get all of Mr. Chance's motions in front of me.
Yes, Your Honor.
Okay, very good. I have them. Where would you like to begin, Mr. Petratus?
Whatever the courts, I know you have them in order.
I just will go in the order I have them right now.
Yes, Your Honor.
So, okay, very good. Okay, let's start with the motion to declare section 921.141L, I believe, Florida statutes unconstitutional and to bar state's use of hearsay evidence in penalty phase proceedings. Right, any,
Judge, I'm going to rely on the motion and the case law contained therein and have no further argument.
okay. And Mr. Harmon?
Judge, we filed responses to all of Mr. Chance's motions, and we'll rely upon our written response.
Okay. All right, I will deny the motion to declare statute 921.141, I believe that's L, unconstitutional, and I will also deny the request to bar the state's use of hearsay evidence. Hearsay evidence is admissible at a penalty phase proceeding, assuming that the defense is given a chance to rebut that evidence. So
Yes, Your Honor.
that motion will be denied. All right, next up, motion for findings of fact by the jury.
Yes, Your Honor, we would, Mr. Chance, we would rely on the argument and case law contained therein, have no further argument here today.
Okay. State?
Your Honor, we filed a written response. I'll rely upon the state's response.
Okay. And just for the record, this motion would, is asking that I say that the jury's got to find additional findings of fact other than what the jury instructions require them to do in a capital case. So I will deny the motion. All right, a motion to declare 921.141 6N unconstitutional.
Judge, we would rely on the motion, argument, and case law contained therein.
Okay, and this is the criminal gang member aggravator, correct?
Correct, Your Honor.
Okay. Mr. Harmon?
Judge, we filed a written response. We would rely upon that in the argument that the aggravator is constitutional, especially in light of the heavy amount of evidence of showing a nexus between the facts and the aggravator.
Okay. That motion will be denied. All right. Motion to declare cold calculated and premeditated aggravator unconstitutional.
The same, Judge. We would rely on the motion and the case law therein.
State, you rely upon your response?
Yes, Your Honor.
Okay, I will deny that motion. Motion to declare 921.141 2 and 3 Florida statutes unconstitutional. Mitigation must outweigh aggravation.
Same, Your Honor. We rely on the motion, the argument, and the case law contained therein.
Okay. Mr. Harmon?
Your Honor, we'll rely upon our written response.
Okay. We're going to stick with what is required currently under the law for the jury, so I'm going to deny that motion. Motion to declare Florida's death penalty unconstitutional based on violations of Article 1, Section 4 of the Florida Constitution and the First and 14th Amendments to the United States Constitution. Mr. Petraeus?
No further argument, Judge. We rely on the motion, the cases and statutes contained therein.
Okay. Mr. Harmon, you rely upon your response?
Yes, Your Honor.
Okay. I will deny that motion. Motion to declare 921.141 Florida statute unconstitutional and for pretrial determination of admissibility of all victim impact evidence. As to the, let me see, unconstitutionality of victim impact evidence, any additional argument, Mr. Petraeus?
The only thing additional I'd say is I know the court had a specific ruling as to when Mr. Hernandez was up here. I believe you said it to all defendants, so
Yeah.
other than I
So, yes, so any victim impact evidence has got to be in written form, and the state has to provide that letter, that written form to you all at least 24 hours before any person would testify. And at this point, it's got to be an adult. And at this point, the state's not limited to the number of individuals. However, at some point, they may be. So you can always renew an objection if you feel that there are too many individuals that they intend to call for victim impact.
Yes, Your Honor. No further argument other than that, Your Honor.
Okay, so I will deny the motion as to the unconstitutionality of Section 921.141 subsection 7, and I will grant the motion with regards to pretrial determination of admissibility of all victim impact evidence, in that the state's got to disclose what they intend to have read to the jury, and then if there's a dispute or a challenge, I'll hear it.
Yes, Your Honor.
Okay?
Thank you.
So denied in part, granted in part. Okay. Defendant's motion to preclude imposition of capital punishment.
Judge, I'll just rely on the motion and the case law as cited in the motion.
At this point, well, any response, Mr. Harmon?
No, Your Honor, other than our written response, no.
Okay. So at this point, I read this as a wholesale motion to preclude imposition of capital punishment. So I'm going to deny the motion. However, you're not prevented in the future from, particularly assuming we get there, at a Spencer hearing, any arguments that are available to you legally.
Yes, Your Honor. Thank you.
But that motion will be denied. All right. Do you have any others?
I have one more.
Okay.
I believe objection to death qualification of the jury.
All right. I don't see that, but it may be here somewhere. And tell me what the motion is.
I should have it here, Your Honor. That's a long
Oh, wait,
one.
hold on.
If I could have.
It was 14 on the list, if that helps.
Well, it was when everything was in line, but I took it all out, so now it's, good luck, okay? Good luck putting that, okay, oh, here I've got it. Good luck putting that genie back in the bottle. All right, let me just take a look. Okay. State, any further response?
No, Your Honor, we filed a written response. There are multiple grounds raised in the motion other than death qualification. We addressed each in our written response.
All right, the motion will be denied.
Thank you, Your Honor. I believe that's the last one I filed.
Okay. All right, so moving on, Mr. Gathright, on behalf of Mr. Gathright. Okay. Do you have a particular preference as to order?
You can tell me.
Okay, all right. I'll just
Whatever you
go-
have there, I'll go with you.
Okay, I'll just go in the order I currently have them. Okay. So, motion for victim impact statements to be read by a neutral party. State what's your response to that.
Is this the motion of the general procedure?
No, this would be Gathright, motion for victim impact statement to be read by a neutral party. I guess they don't want an actual,
I believe I filed a response.
yeah, you did.
And we object, obviously, to that.
Right. I mean, family members can read their statements, correct? Under the law?
Yes, Your Honor.
Can and they do.
And Your Honor, we would just ask for the same ruling or indication from the court as you did earlier, as far as if there's any minors.
Right. So same situation, any victim impact evidence, if there's going to be a written statement that's read, it has to be provided to defense at least 24 hours before the victim reads the statement. And at this point, it cannot be a minor unless we talk about it. And if there's any dispute, then I'll take a look at it and I will resolve the issue. So as to the specific request that the victim impact statements be read by a neutral party, I'm going to deny that motion. Motion to declare Florida Statute 921.1418 victim impact evidence unconstitutional.
Yes, Your Honor, we'd rely on our motion.
Okay, state you rely upon your response.
Yes, Your Honor.
Okay, that motion will be denied. Motion to preclude any potential death penalty proceedings based on violations of the constitutional right to a grand jury indictment.
We would rely on our motion, Your Honor, indicating aggravating circumstances or elements of a capital homicide which must be pled by the state attorney and unanimously found by a jury.
Okay, Mr. Harmon, you rely upon your response.
Yes, Your Honor.
Okay, that motion will be denied. Motion to strike proposed aggravating factor number 1 from the state's notice.
And Your Honor, I think based on a conversation we had last week, we can withdraw that motion. My understanding is the state's solely relying on the facts of this case that would be
Right.
heard in guilt phase.
A contemporaneous conviction, not anything prior.
Right.
All right, so that motion is withdrawn. Next up, motion to declare Section 91.1416C unconstitutional on its face and as applied. This is the risk of harm
Yes.
aggravator.
Great risk of harm aggravator, finding it vague and overly broad. We'd rely on the memo in our motion.
Okay. Mr. Harmon, you rely upon your response?
Yes, Your Honor.
Okay, that motion will be denied. And motion to bar imposition of death sentence on grounds that Florida's capital sentencing procedure is unconstitutional.
Yes, Your Honor, we have indicated in that motion that the procedure is currently unconstitutional, permitting a verdict of death on a non-unanimous vote of the jury, and would rely on the memo contained in our motion.
Okay. State you rely upon your response.
Yes, Your Honor.
All right, that motion will be denied. Do you have any others?
We had, it looks like, motion to declare 921-1416I unconstitutional. Let's see, and that's for CCP.
Okay.
Do you see that?
And I've
one?
been saying I. Is it I or one? I don't know. Okay.
And we'd rely on our motion.
Okay.
If you have it. Do you have it?
No, but the motion is filed as to declare the CCP aggravator unconstitutional.
Correct.
Okay, that motion will be denied.
Let me just double check. We did have a few motions in limine. I think we can agree on most of them, but
Did you
just,
cover the victim impact?
we did.
Yeah.
Both were denied.
There's a motion in limine as to general procedures, I believe.
Yes. Oh, and I'm sorry, Your Honor, there is one more we filed the motion to strike the aggravator that was withdrawn, but we do have a motion to declare 921-1416B, the prior capital or violent felony, the constitutionality of that. And we'd rely on that motion if you have it. That one was filed. Some of these were filed at different times, which would be, that one was filed early January. The state did file a response to that as well.
Okay, do you rely upon your response?
Yes, Your Honor.
Okay, that motion will be denied.
I think that was it for the constitutional and those motions. We do have a motion in limine for general procedures.
Okay, what does it state?
The first one, I believe the state didn't have any objection. Section A of that motion was reference to non-statutory mitigating circumstances and use of words such as catch-all.
Yeah, we have no objections.
Okay, granted.
The next one was Section B, the presence of media, family members, and uniformed officers and shackling of the defendant.
Okay.
I know this, go ahead.
No, it's okay. Your Honor, I spoke to counsel about this last week. We agree, obviously, to any kind of shackling in the presence of the jury during the guilt phase. It's my recollection from Kuzchok, and I believe Ritchie possibly, that during penalty phase, we maintained that. The defense still insisted on the clothing, and the shackling is outside. It's covered up for the jury.
Yes.
Okay. As far as the other matters in that ground, we would defer to the court as far as the media, anything like that.
Okay. And tell me, I feel like I've seen the motion, but I can't find it right now on my desk, so.
Your Honor, essentially, we are asking that the court instruct the members of the media to not interview witnesses, family members, courtroom personnel, people involved in a place in the courthouse that could be subject to the jurors observing, seeing.
Okay.
I believe there's also a ground about use of cameras in the courtroom. If I'm just kind of looking at this from last week, there's an administrative order that deals with that. as far
Right,
as-
there's only one camera that's permitted in the courtroom, and it's got to be out of the way. And I do have a whole discussion with the jurors that they understand that their faces will not be shown, their identities will not be disclosed. So I guess the motion will be granted in that they've got to, the media knows, and they've got to follow a certain procedure established by the courts, and I assume they will.
Perfect. The next section, we were asking C, names and addresses of potential jurors summoned to try the case and do individual questionnaires. I don't believe that's your Honor's practice, but we were seeking to do individual questionnaires for the jurors.
Okay. That will be denied. And then as far as the names and addresses, we get those the day the jury is pulled. So, and I think I told you all we're going to do 3 days of 150 back to back. So you'll get the 150 on the Wednesday, the next 150 on Thursday, the next 150 on Friday, the morning of.
Okay.
Okay? So you'll get them, but not before that.
Not now,
So I guess
okay.
it's granted, but you'll get it the day of.
And we were also asking for individual and sequestered voir dire. My understanding is that the court does the individual or smaller groups as to hardship or media exposure.
Yeah, so individual voir dire will be done on anybody that thinks they know anything about this case. With regards to hardship, that will be done as a group for those that are claiming a hardship. And then on death penalty voir dire, that will be done again in small groups. That's not my traditional practice, but because of just the number of people that will be coming through for jury selection, I am going to break it down, the death penalty qualification questions into smaller groups. So probably the 30 to 40 range, we'll see whatever we think we can get through in a day. So, and I think I did mention this before, that normally I have a whole speech that I do before phase 2, which is death qualification. And I know the state has Mr. Harmon has a speech that I've seen him do before he begins. And normally I give the speech when we actually move on to phase 2. But in this case, what I'm going to do is I'm going to give my speech first thing Wednesday, Thursday, and Friday to the group of 150 as a whole. Just because it is can be time consuming, and by the time I get done talking, and by the time Mr. Harmon gets done talking, and then if the defendants wish to make a statement regarding penalty phase questions, it's, we're now into an hour and a half and we haven't even started talking to any of the jurors. So my plan is that Wednesday, Thursday, and Friday, the first week of picking the jury, I will give my speech to everyone there, but I will remind them that we're not going to be asking them any questions related to the death penalty in phase 1. And then if those that come back to go into phase 2, which are the death penalty questions, I will then just give them a brief reminder of what I said to them, and then I'll give Mr. Harmon a chance and the defense counsel a chance to give a brief reminder before we actually begin the questioning of the jurors.
Okay.
So if you all want to make a succinct speech regarding death penalty voir dire,
Okay.
you're welcome to do so, okay? But you'll do it Wednesday, Thursday, Friday morning
Once
of
we
the
pare
group.
down a little bit.
Well, you do it initially to the whole group,
Okay.
and then those that make it to phase 2, like I said, we'll do just a quick reminder of the points that were made when they first came in, but we're not going to do another wholesale intro for each of those small groups because it'll take forever. Okay?
Okay.
Okay.
Let's see, next was section E, objections being made contemporaneously with the occurrence of error to avoid procedural default. Did we discuss that, Scott? I don't remember if you had an agreement to that or not.
No, I don't believe we did.
Okay.
Actually.
So is there any objection?
Judge, I would just, so if I could ask counsel for clarification about contemporaneous objections. Objections made at the bench, objections made from counsel's table.
Just so there's not speaking objections from the
Right.
council table?
Oh, okay.
Granted,
Thank
I
you.
don't like speaking objections.
No, I don't think anybody does.
Some people like them, or at least some people like
That's
to
true.
make them. They
Yes.
do, but,
Or some judges, when you say, can we approach, and they say no, and then you have to do it, so.
right.
And the last one, I believe, is section F, which was miscellaneous matters. And I believe that the state is in agreement with that section.
Yeah,
Correct me
Your
if
Honor,
I'm
I
wrong.
do. It's the court's, in the past, being in front of Your Honor, when the state asked for the record to reflect that a witness has identified the defendant, the record will so reflect. There's
Right.
something to that.
That's all I ever say.
Perfect.
So I guess it's granted with the understanding that that's what I will say.
Okay. And I believe that is it. We handled the state's motion to eliminate. Is that all you have?
Yes.
Okay.
Yeah.
Okay,
That's all on
right.
behalf of Mr. Gathright. Thank you, Your Honor.
Okay, thank you. Okay, and Mr. Davion Murphy. All right, you want to start off with defendant's motion to strike aggravating factor, section 921.1416N as unconstitutional, and that's the criminal gang member aggravator, correct?
Judge, are you talking about my motion to strike? I apologize.
Yes.
Okay, so my motion to strike the aggravating factor 921.141BN.
Oh, we're switching to a different, I was
Oh.
looking at 6N.
Okay.
But that's fine, we can start wherever you want to
No,
start.
I was going to start at the general procedures and work from there, but whatever Your Honor wants.
Okay, it really doesn't matter.
I think it's probably the easier. Not that anyone would be hard.
That's fine, so where do you want to start?
The motion in limine regarding general procedures, I spoke with the state. I think we're pretty much in agreement.
Yeah, the motion is very similar to Mr. Gaffrey's motion.
In that it appears the state agrees with paragraph A,
I do, the state does agree with that.
and that
Okay.
is in regarding the non-statutory mitigating circumstances. Paragraph B, if I recall, you left that up to the court's discretion, and that will be the presence of media, family members, and uniformed officers, and shackling of the defendant.
I don't think we address family members. As far as that goes, I don't think there's any limits to family members being in the courtroom. We always instruct them not to wear anything that's provocative to the jury, such as photographs or any kind of remembrances.
Right. And the defendants are shackled, but not obviously to the jury.
Yes, Your Honor.
And so I guess the motion is that paragraph B technically is granted with the understanding that there's an administrative order that deals with the media. Family
Yes.
members can be present, they just can't wear anything that might be considered inflammatory or sending a message to the jury. And uniformed officers obviously can be present in the courtroom, you have to have security, and the defendant shall be restrained, but not so that the jury can see.
Yes, Your Honor.
So it's granted to that extent.
And then as it relates to paragraph C, names and addresses of potential jurors summoned to try the case, I heard the court in addressing this motion previously. I guess we obtain or are provided the names and the addresses, I think, the morning of.
Yep.
Okay.
So no questionnaire, and then you'll get the names the morning of. So deny the motion as to a questionnaire, grant it as to the names and addresses, and again, that will be provided the morning of jury selection.
And then D, individualized and sequestered voir dire. I also heard, Your Honor, as well. I have done it both ways. I feel as if it's more effective, at least to do the penalty phase portion of it individually as opposed to like in sections of 10 or, 15 or what have you, but
Yeah, I'm not doing individual, no, we're not doing that. So we're doing, as I said, small groups, anywhere 30 to 45. We're going to see what's workable with the number of attorneys we have. But
Understood.
it's not going to be done individually. So as to paragraph D, that's denied.
And then E would be very similar to what the court has previously ordered with regards to objections. Obviously, there should be no speaking objections.
Right, that's granted.
And then F has to do with miscellaneous procedures, one of those being where the state wishes to identify a defendant for the quote record. I would ask that that be done at the bench as opposed to the court commenting that the record has reflected that so-and-so, whatever witness has identified the defendant. If that's what the state is requesting, that that be done at the bench.
I'm going to deny that request, so the state can ask it just if the record reflects, and I will indicate if the record so reflects. Okay?
There's no longer the issue with the
Okay?
expert. Okay, so then the next one, if Your Honor may, motion to declare section 921.141B1, which is CCP, which I believe the state filed a response to. And I would just stand on my motion.
Okay.
That was on CCP, counsel?
Yes.
Do you know what?
6I.
It's 6.
What I mean,
6I,
maybe I
yep.
said.
Okay, that motion will be denied.
And then the next one would be motion to declare 921.141.6B unconstitutional as written at, and as applied, and that relates to the prior violent felony aggravator. I believe the state also filed a response.
Does this defendant have an actual prior?
I looked, I thought that it was in the,
Does he, or are you
In the
just alleging the
notice.
contemporaneous conviction?
Judge, I can't speak to whether he does or not. I know all the defendants were relying upon contemporaneous convictions for violent felonies. I believe this is Mr. Murphy, Davion Murphy.
Yes. I think it said or. I'm almost positive.
You believe he does, counsel?
I believe that the notice said or.
Or, okay.
Yeah.
Well,
I believe that's the wording in the statute, so we utilize that wording. So.
okay. Well, as to it being unconstitutional, I'll deny the motion. But obviously, before we head into a penalty phase, if the state is going to rely upon a prior violent felony conviction, you've got to make sure you've given them the defense. So you need to let them know before the start of trial, okay?
And then the next one will be motion to declare 921.141.8 unconstitutional and for a pretrial determination on the admissibility of all victim impact evidence.
Okay. So as to it being unconstitutional, I'll deny the motion, but I will grant it with regards to a pretrial determination of admissibility.
Yes, Judge. And Zong, obviously, that would receive those letters
Yes.
in advance. Then
Yeah,
that should-
same ruling, at least 24 hours before anyone should offer the victim impact evidence in court before the jury. Has to be disclosed.
And then I would also adopt, I did not file, although I did tell Mr. Harmon that I was going to be adopting the motions that have been filed on behalf of the other defendants regarding the constitutionality of the new death penalty scheme applying to Mr. Murphy, not based on ex facto or anything of that nature, but based upon just general 8th and 14th Amendment rights. So I would adopt all of those motions and incorporate those
Okay.
in his argument.
Same ruling, be denied.
Okay, and then finally, we have motion to strike the aggravating factor. I think is that what you started with?
I have, yep, defendant's motion to strike aggravating factor, Florida statute section 921.1416N, which is the criminal gang member aggravator. You're relying upon your motion?
I'm relying upon my motion, yes, Judge. Yes, I am.
Okay. State, you're relying upon your response?
Yes, Your Honor.
Okay, the motion will be denied as to the unconstitutionality of that aggravator. All right, Ms. Toomey, any other penalty phase motions?
The only other thing that I might add for the record with regard to this specific aggravating factor, specifically for criminal gang members or associates, that has already been enhanced, I guess, if you will, in the indictment. So it's almost like a doubling up of that sort of kind of enhancement. So I would just make a general constitutional argument against the doubling up.
Okay, same ruling, be denied.
I think that's it.
I believe so. The
Yes.
list I have.
Okay.
Your Honor, if I could readdress my motion to compel, so I could kind of let the court know where we're at as far as documents and records. Ms. Toomey has provided me with voluminous records, and I appreciate that. All types
Of what kind of records?
School records, I believe DCF records, other records, medical records possibly, in relation.
Social Security records.
Social Security records dealing with Mr. Davion Murphy.
Yes.
I know, Mr. Petridis, have you listed more than one expert? Is it multiple?
Yes.
I thought you had, okay. So I haven't received any records from any other penalty counsel. And it's my understanding if there is any that will be provided, I just wanted to bring that to the court's attention.
Okay,
I've reached out to my experts. I don't have anything to say, but I told them to check if they don't have anything. Obviously, I'll send it to Mr. Harmon immediately.
okay.
That jogged my memory, Your Honor. We have a small number of school records for Mr. Gafford. I did a notice of intent to rely, but now that I think about it, I don't think I actually sent the records to the state, so I'll do that today.
Okay.
It's a very 10-page email.
Okay,
And then I think that's it that we'd have for records.
okay. And have you received any records from Mr. Hernandez for Rashad Murphy?
I have not, Your Honor.
Judge, I'm going to text Mr. Hernandez now, and I'm going to also make a note to speak with him after the proceedings.
Okay.
And judges, is there a deadline on those records?
Well, yes, the deadline is come and
Rapido,
gone.
I heard the court say Rapido.
Pursuant to my scheduling order, those dates have come and gone. But anywho, I tell you what, let's do this. We're reconvening Friday, correct?
We are, Judge.
So I want you all to just make sure you've checked to make sure you have disclosed or are disclosing any records that you're going to rely upon in penalty phase. And then let me know Friday what your status is. And then if they've not been produced, then I'll give you an absolute, like, I'm not kidding deadline. I know my scheduling order should have been an absolute, I'm not kidding deadline, but things happen, so. Okay, and Miss Toomey, I know you were busy, but have you heard back from your neurologist by any chance?
I emailed him.
Okay.
And I can.
That's fine. So we're reconvening Friday, so I just need to know by Friday when he's going to be able to get his evaluation done, so that you can determine whether or not you're going to list him.
And that's exactly what I sent, but I had not read.
Okay, that's fine. That's fine. Okay. Okay, anything else we can get done today? Any suggestions?
Judge, I did have a motion in limine to all defense attorneys to requesting that they provide us with any sort of drill rap videos that they intended to use, to list them and provide them in discovery. I don't think we addressed that.
Judge, if the court will allow, I have a brief response on that.
Sure.
Somewhere.
Judge, if I may, while we're waiting.
Sure.
I did file a motion, I'm assuming that this is probably going to be heard on Friday with all the other gang stuff?
Yeah, unless it's something we get done today, relatively simply. No? Okay.
Not because of me.
No, I'm not. It's okay.
Judge, if they would prefer it be heard with the other gang motions, that's
Yeah, I think
fine.
it would be better.
I just thought that that was something, because I was just asking that it be provided in discovery and listed.
Right, that's what she's asking at this point, not the admissibility, but just that if you've got any other drill rap videos other than what the state is intending, and have you disclosed to the defense the ones you actually intend to admit at trial?
Judge, we will. I know we've listed probably more than we intend to use, but we will specifically list the ones that we intend to use.
Okay, yeah, by the time we reconvene Friday,
Yes.
you need to specifically identify the drill rap videos that you want to show the jury. And then if there are any drill rap videos that the defendants wish to show to the jury, they need to be identified and given to the state by Friday.
And Judge, certainly, the evidence view, we on Friday are going to talk about getting together. It'll be, as the court can imagine, monstrous.
Yes.
There may be some non-testimonial issues that come out of that evidence view that may be, need to be addressed by the court.
Sure.
But we can advise you of that. My only additional concern in this state's motion in limine is that it doesn't limit itself just to videos. It suggests that the defendants refrain from making any direct or indirect mention or introducing into evidence any non-disclosed evidence of the victim's prior gang activity or videos. And I would object, and I don't think it's appropriate to suggest at this stage of the game that we should not be allowed to either question or seek admission of evidence or mention or have argument to what is described as the victim's prior gang activity. Now, granted, the court hasn't ruled on any of these things
Right.
yet, and I don't want to predispose or predetermine what that may or may not be. I agree wholeheartedly that we should be providing the state any rap videos we intend. But as it relates to argument or mention or questioning, I don't think that we can blanketly, as the motion is written, at least Rashad Murphy, agree to that.
Okay, and I'm not ruling on that motion yet. The sole issue that I hear Ms. Doherty raising is she just wants to know if there are any other in the universe of drill rap videos. Are there any other drill rap videos that any of the defendants are going to attempt to introduce at trial?
Understood, Judge.
Guilt phase. So you just need to tell her by Friday if there are. So once I've ruled on the other gang evidence and whether what's coming in or isn't coming in, then once I determine that, then we can start working on the motions in limine. So we'll kick off with the motion for me to determine how much of the gang evidence is going to come in, and then we'll go from there as to the remaining motions. Okay?
Judge, there is one mention I would make. I've been working on, when I can, and because of the late nature of the deposition of state witness Robert Howard,
Sure.
I've been working on what will be a non-testimonial motion in limine as to certain portions of what I anticipate Mr. Howard's testimony will be. and I just wanted to make everybody aware. I had spoken to the state some time ago. We just did get back last week the expedited transcript of Mr. Howard's deposition, although there was a previous proffer that we've been able to rely a little bit on. So I anticipate filing that motion as well, Judge, without significant argument other than those portions that we would seek in limine.
Okay.
And Judge, I just wanted to comment on my motion limiting, because I did include gang activity. Obviously, I know that the court has not made any rulings about what will be coming in, but the state's concern obviously is bad character on part of the victim being inappropriately admissible by defense and last minute without us having the opportunity to fully vet and make any sort of arguments. So it does include not just the drill rap videos, but any gang activity that they're aware of that they intend to get into that's not been previously disclosed.
Okay. Okay. We'll start with the drill rap videos, and I don't know what that other evidence might be. I'm not really sure. So anyway, we'll see where we are on Friday. Okay, anything else for today?
Mr. Gather had a couple of other motions that don't fit in any category. We can
Sure.
address those.
Just tell me what they are.
At least one of them, maybe we should have done last week, but he has a motion to sever count 6.
Yes.
I think we laid out our position in our memo, and I know the state filed a response.
I
Our
did.
position is it's a separate transaction. I know that the state's position is there's a causal link. But we believe it's sufficiently separated that the jury should be considering count 6 separately from the other counts.
Okay, and remind me, what is count 6?
Judge, that's the tampering with physical evidence that is when Mr. Gathright goes back to his grandmother's house after the offense on the same day and wipes down the car and removes the car from Tampa and leaves it in Auburndale.
Okay. Oh, sorry.
And Judge, we did file a written response to that, again saying that that is properly joined and requesting that it not be severed, as it specifically is connected and joined in an episodic manner, which I think is the case law, which says that that is properly joined.
Okay. Any response, Mr. Wise?
Only, Your Honor, it's a separate incident that's allegedly taking place. It's happening in Polk County. It doesn't involve anyone else in the room. I recognize the state's position, but it's completely separated time, separated space. We think it's two separate acts that should be tried separately.
Okay. I'm going to deny the motion to sever count 6. Okay. Anything else?
We had filed a motion to compel the location of all license plate readers along this path that's
Right.
traveled. We have hits from, we know where license plate readers hit. I don't know, and I know the state mentioned discovery, and maybe we missed it. I don't think we have locations of any license plate readers that didn't hit. I know I addressed this in other, at least one other case, and I think there are some law enforcement concerns about disclosing it, but I think it's relevant if we're seeing evidence of where it hit. There could be license plate readers along these alleged paths that didn't hit. I think that's.
So you want the state to give you the universe of license plate readers along a
Yes.
travel?
Between here, Orlando, Jacksonville, yeah, along these routes of travel, which I know there's more travel in this case than a lot of cases where, we're talking about just someone traveling in Tampa. But I think it is relevant Brady material.
Huh, I don't know that it's Brady. Okay, state, what's your response?
Judge, we have complied and given them all of the license plate readers where they hit. Judge, we don't know the specific path of travel, and I did specifically talk to the detective. If it is not captured on a license plate reader, it's not something that we can use in the particular case. It's a matter of timing and how the car passes. Some of these license plate readers are mobile, and so Judge, there's no way for us to know. And there are different companies for different license plate readers. There just isn't any kind of, it's not exculpatory by any means And without knowing the specific type of travel, when they got on, when they got off, if they took a break, there was just no way
Right.
for us to be able to provide that.
But you have provided for the license plate readers that are going to come into evidence, the location of those has been disclosed.
Yes, they are disclosed by address, Judge.
Okay. All right, so I'm going to deny the motion as to any license plate readers that were not triggered during the course of travel of the defendants. Okay, I don't find that it's Brady. Okay, anything else?
Yes, Judge, there were just, I think there was a couple additional matters. You asked us with regards to that Richardson case that occurred in Jacksonville.
Right.
What was the reason that there were two juries, and that was a Bruton issue.
Okay.
And I believe Ms. Ismore has a copy of the actual order that lays that out, if you want us to forward a copy to you as well as defense counsel.
That's fine. I take you at your word that it was a Bruton problem. I just was curious.
And then I did want to know if the court wanted to do a formal colloquy on the record. I know that Mr. Petratus had to step out for a moment. I think it was the last time we met for motions.
Yes.
For a small period of time. We did go ahead and order the transcripts for what happened during that time period. If Mr. Petratus wanted to take a look at that or had any sort of additional argument to make. I know that there was additional counsel that was tasked with kind of asking questions, or was tasked with asking questions during that time period on his behalf.
Yeah, and I just want to thank you for reminding me about that. So I think the last two witnesses, and I think it was Drayback and was it Trey McCullough? Were
Yes,
those the last
those
two?
were the last two witnesses.
And I'm sure you were advised of this, Mr. Petratus, but Detective McCullough had no information related to your client at all. And then Detective Drayback, this was done as a proffer to establish these detectives as gang experts?
Yes, Your Honor.
Okay, and I don't see Detective Drayback being declared an expert in this case, just because the gangs that he is tasked with, and I don't have my notes right in front of me, but there's a different gang or set of gangs in Jacksonville that he's focused on.
Yes, Judge, I believe we just listed him because he's not involved in a specific gang, but was the liaison and handled most of the matters as a general gang expert for Jacksonville gang activity.
Yeah, but you've got 3 other people to choose from.
Yes, Your Honor.
Right?
Yes.
So at this point, it'd be cumulative anyway. So, yeah, here are my notes, actually. His gang of interest is the 21st Street gang, and he testified he doesn't have any specific familiarity with 6 Block, and he's assisted other members of the gang unit with regards to ATK and 1200, but the 21st Street gang is his specific one that he focuses in on. So Detective Drayback is not going to be testifying as a gang expert against Mr. Chance or against any of the defendants in this particular case for that reason. The state's got 3 other people to choose from, and Detective Drayback's gang is not a gang at issue in this trial. Okay? So I did indicate that the state's ordered a copy of the transcript, and if for some reason you wish to ask any further questions of either Detective Drayback or Detective Trey McCullough, then we'll set up a Zoom hearing. So.
Judge, Ms. Ismer was kind enough to provide me with a copy. I read them over. I have no further questions. Mr. Wise asked questions on my behalf, and I thank him.
Yeah.
I was present for the depositions of those witnesses in Jacksonville, so I anticipated that would be the outcome.
Yes.
So I appreciate the court.
Yeah. So just wanted to make sure. Just making sure. Okay. And anything else?
No, Your Honor, I think that's all from behalf of the state.
Okay, anything else quickly we can do today? Nope. Okay, all right, I will see you all Friday morning at 9 a.m. and we will get through all of the remainder of the motions. Oh, also, I did take the motion to sever under advisement. Once I've ruled on the parameters of the other gang evidence that's going to come in Then I'm going to ask each of you to, with specificity, tell me what evidence is admissible in this trial that would not be admissible if your client was being tried alone. Okay? So just be prepared to answer that question. All right? Okay, see you guys Friday morning. Do you need my notes?
All right, so that ends the one from March of this year. That was March 4th. But we have another one from March. We have one from March 9th. And I got a new poll for you guys. How familiar are you with this trial? I know it like my favorite song. I'm pretty familiar. I know the headlines. I know nothing. So take a moment to answer our poll and also hit the like button. You know, we've got 1,300 people watching. We got 349 likes. Take a moment, and if you hear my voice, go ahead and hit the like button. Show us that you're not a bot. And I kind of want to go back to here. Let's just take a brief moment. Let's go back to this timeline, right? For a lot of people coming in, you may know the trial, you may not know the trial. So what the state is going to do is they're going to introduce 6 points in this in the timeline. So I have it marked off, and we'll get to that in a second. So we've got. Aaron and I chose 6 points in this feud, this ongoing war, from what we thought, from what we heard, the research we did, the people we've talked to, the videos that we've watched. To us, and I know we're missing probably hundreds of other people, right? So this is by no means a comprehensive timeline, not at all. But at least for us, it kind of highlights where we think things happen, where you take out somebody that I know and love, I take out somebody you know and love, whether it's a family member or a friend. So I know there was a Kodak Black concert, that things kind of started there with one group not shaking hands with another group. And then for me, it was Aiden McClendon that kind of, and again, things I'm sure happened before then, but this is what was kind of like that starting point. So Aiden, he was shot, unfortunately, January 29th of 2016. And I think it was the shooters were targeting some other, another person or people. So it wasn't like they were going after Aiden, but unfortunately he was in the car. Now Aiden was the cousin of Reginald and Noah Williams. And Reginald is Wappa with the Choppa, and of course Noah is Spinabens. So those two obviously took it to heart, right? Took it to heart. And then the following year, May 27th of 2017, Zion Brown, who was the cousin of Charles Jones or Julio Foolio, he was only 18. So he gets shot by DeAndre Thomas, who's Trey Shorty. Now Trey is with a ATK. So you can kind of see it starting to develop. And again, there were moments that happened in between all of these, but these were the big moments that I thought that I wanted to highlight, only because the state is going to bring in 6. They decided, they landed on 6, and I wanted to flesh this out. So then 2018, we have the Wasabi restaurant ambush, and that one obviously is huge. This was June 5th of 2018. This is where Yungeen Ace goes out to dinner with his brother Quan Quan. Kobe's there, 23 is there. They're out celebrating Royale Smith's birthday, that's 23, and they're all good friends. And as I said, Keontae and Trayvon are brothers, and they leave the restaurant, and they're pulled up by a car, and shots are fired. A lot of shots are fired, and 4 shot, 3 dead, 3 killed, and that is that's the background to. When I See You, that Julio goes on to record that song. Then a couple weeks later in July, Corbin Johnson, he goes missing, and his remains are found the following year. Then we go to, so here's where the state is going to start. The state's going to start their timeline in 2019 with Adrian Gaynor or Bibby. And Bibby, Tiki, and Lil 9 all appear in the Who I Smoke video with Ace that we're all familiar with, right? So those 3 are with KTA, they're with 6 Block, they're with Julio, and they're all three taken out 2019, then 2020. So we got Adrian Gaynor, Bibby. He's a close friend of Charles Jones. His shooter was Hakeem Robinson, or Queso, and he was shot at the Hilltop apartment complex, and he was only 16. Then we got Tiki. Tiki was 19, close friend of Charles Jones, Julio Foolio. Shooter is unknown. We don't know who the shooter was. Then we go to 2019, and we got Gerard Adams, or Spaz. He's at a football game, and afterwards, he shot. I think two other people were injured, but he shot, and that was August 25th of 2019. Now, Robert Howard proffers, which basically means he told law enforcement that it was Bibby. Bibby was the shooter, but he took the rap for it, and he went to jail. He only spent, I think, 5 years. I think it was involuntary manslaughter. So he only spent 5 years. I think it was five or 7 years in prison. So pretty short amount of time. But he's the one that proffered that it was Bibby that shot Gerard. Then we go to Dimitri Mixon, or Lil Nine. He also appears in the Who I Smoke video along with Tiki and Bibby. Shooter was unknown. He was only 18, and he's a close friend of Charles Jones, Julio Foolio. And then here's where the state's really bringing in all their evidence. So they started at 2019, and then now they're going to 2023. So Jaquan Pickens, Jake Jitt, he was 19, August 16th, 2023. He's driving down I-95. He's driving down I-95, car pulls up, shoots him. He slams into a semi-truck. I wish I could get some news on that. I couldn't find any news clips on that. But so he's part of Bully Gang, right? Which is, that's like the younger group coming up with 6 Block. You got Julio. Julio's like in his 20s, you know, early to mid 20s. Then you got the younger guys coming up. So they're calling themselves the Bully Gang. Then you've got, okay, so that was August 16th. Then the following day, you got Jacoby Beals, or Lil Kobe, sorry, and he's shot August 17th. Now, he's cousins with Darius and Maliki Beals, and that is in, law enforcement believes that's in retaliation for the Jake hit. Shooter is unknown. Then we got Antonio Tilly, October 6th. He's 19 years old. Now, law enforcement alleges that it was a $20,000 contract hit for him dissing Adrian McKenzie, or BGYBZ. BGYBZ. And this is when he took an Uber to a house, and he was jumped by Jaquan Mills. And he shot, the Uber driver shot, total innocent bystander, right? So he's taken out. Then you got Charles Jones. He's been shot multiple times, but the one time that the state is bringing in was literally hours after Tilly got shot. It's like 5 to 6 hours, according to Detective Nieder, but we have it as the next day. So Charles was 25 at the time, and he shot in the foot while he's leaving his residence, and he survived, and the shooter is unknown. So I just wanted you guys to know that the state is going to bring in certain shootings and certain incidences, and we kind of expanded upon that a little bit. So, all right, let's get back here. Yep, Abdul Robinson is Akeem's or Queso's father. Blue, he also goes by Blue. That is correct. So, one other thing, you guys are doing really great, but I do see just a lot of new people in our chat. Just remember that we want you to just be respectful, be courteous to each other. Also, to the people in the courtroom, we have interests that are representing the defense, Davion Murphy. So they will be in and out of our chat, and we just ask that you be respectful to all the defendants, all the lawyers, all the bailiffs, all the witnesses, the judge. I know there's a lot of new people in our chat, and you don't know our guidelines, so I'm just letting you know that. So, all right, let's continue on. We've got another pretrial hearing, and again, trial starts on Wednesday. It's a death penalty case, so they've pre-qualified all of those jurors. Now they're dealing with now Monday and Tuesday. They're going through. I think there's about 150 jurors that they picked. And now they're going through them and they're whittling it down. So, All right, so this next pretrial hearing. So again, it starts on Wednesday. So until it starts, we're just we're swimming in, and we're getting our fingers pruny in this, so that we can answer. So we know going into this, we will have a lot of knowledge under our belt once we start. All right, and I also want to play Alicia's. We did an Ego Takes the Stand episode, if you guys aren't familiar with that.
All right, good morning, everybody.
We do, for defendants that take the stand, we did a specific one on Alicia. But Wednesday, I'm going to go ahead and I'm going to play her. I'm going to play her testimony again, because I'm really interested in her testimony. All right. So here we go. We are going to play. This is from March 9th. Let me just pin this here. So this is a hearing from March 9th. March 9th, 2026 hearing. All right, let's get to it.
Good morning, everybody. Good morning. All right, good morning. All four of the defendants are present. Their counsel are all present. State's present. Good morning. Good morning. All right, let me set up here. See. I couldn't locate the physical copies, so I just wanted to make sure that we're all on the same page regarding the fact that all of the motions have been ruled upon, all right?
Yes, Your Honor, the only one, and I saw it was on the list, it was sent out last night, the only one that hasn't been is really the firearm motion.
Okay.
The state and I discussed, I mean, I think it might make most sense to kind of proffer it and address it with the expert.
Okay. Well, I do have that one. So there were three motions that I located in my stack of pleadings, and I just wanted to make sure that I had addressed all of them really for the clerk as well as for Mr. Gathright. And I believe that they were, the first one was a motion to declare section 921.1416I unconstitutional as written and as applied, and I think that was the CCP aggravator, which I denied, so that has been denied. Do you need it?
I'll just check it, Judge, to make sure I got it.
Okay.
I think I got it.
Okay, I think you do too, but just to make sure. And then the other one, the second one was motion to declare section 921.1416B Florida statutes unconstitutional as written and as applied, and that's the prior capital or violent felony, which would be contemporaneous in this case. And I believe I ruled that it was denied. Just want to make sure. And then finally was a motion in limine as regards to general procedures, and there were paragraphs. I think A was granted, B was granted, and C was granted as to the names, but denied as to questionnaires. So granted in part, denied in part. Individualized and sequestered voir dire was denied, and contemporaneous objections, paragraph E, was granted. All right. So, Madam Clerk, that was granted in part and denied in part as articulated. And, okay. So, I think those are the three motions that I located my copies of. Also, I had taken under advisement Rashad Murphy's motion to allow testimony of the impact of defendant's execution on family members, and specifically, Mr. Rashad Murphy had cited to Lugo versus State at 8:45, 7 74. I did take a look at that opinion, and in that case, the defendant had one of his proffered mitigating circumstances was that his execution will have a tremendous negative impact upon the lives of his elderly mother, siblings, and 6 children. In this case, Mr. Lugo contended that his sister passed away, he adopted her 4 children, and assisted in raising them. So, in that case, what the real issue was what the issue on appeal was, Mr. Lugo, he argued that mitigating circumstance outweighed the aggravating circumstances, and the court said no, and that was affirmed. But it does appear that this mitigating circumstance was offered, which was his execution will have a tremendous negative impact upon the lives of his elderly mother and siblings. So for that reason, as the motion is drafted, I'll grant the motion. All right?
I will pass that on to Mr. Hernandez, Judge.
Yeah, just let him know. And really, and this applies to Mr. Rashad Murphy and all of the defendants in this case, obviously, if we get to a penalty phase, you and your counsel can and should tell the jury every great thing about you, every redeeming characteristic about the totality of your life, okay? So, all right, very good. All right, so let's move on to which would be Mr. Gathwright's defendant's motion in limine to preclude the state from presenting firearms identification evidence, and then the state filed a motion to strike Daubert hearing request in defendant's motion. So how are you all suggesting that we handle this?
Your Honor, my position in the motion, and I know the state certainly disputes this, is that this firearms identification evidence is not product of reliable principles and methods and should not be
I'm sorry,
submitted.
excuse me.
Should I?
Yes.
I can't hear either.
No.
This is better than courtroom 1, but it's not, it's still a big courtroom.
Understood. So, Your Honor, my position is that this body of alleged science, the firearms identification, is not reliable. It's not the product of reliable principles and methods. It should not be admitted at all. I recognize that has been addressed by many courts across the country, and the courts in Florida have not been particularly receptive to the argument. So, unless Your Honor is inclined to agree with me, I think that what Ms. Doherty and I talked about is that the best way to address this might be to proffer the expert's testimony when that time comes and rule on it at that point. So.
Okay. All right, very good. So in light of that, I'm going to grant the state's motion to strike the Daubert hearing request, but I will allow defense to proffer before the witness testifies just for appellate purposes.
Thank you.
Okay, so just remind me that we need to do that before the firearms expert testifies. All right? So I'm going to grant the motion to strike. All right.
Judge, one more housekeeping matter.
Sure.
Judge, I hope the court has now seen that I erred yesterday when I filed my supplemental memo on severance, one addressing the court's question to me last week. When I filed a draft instead of the final memorandum. I realized that very early this morning, immediately contact Ms. Ismer, and this morning at about 8:30 or maybe before, I filed it amended. Now, I will tell the court that the amended is in fact very similar to the supplemental. There's not anything of grave change to it, but I wanted the court to be aware that that was my mistake, and I apologize to the state for not catching it this morning. We filed a draft instead of the final of what we wanted to file.
Okay, very good.
Okay, and then the other thing, judges, I know I asked the court about this earlier in the week, believing that this would conclude any motions. I did have, and I will reiterate again, a motion in limine as it relates to the state's witness, Robert Howard.
Okay.
It is not yet complete, but it will not require testimony and probably very brief argument.
Okay, that's fine. We're going to pick another date in the future to hopefully resolve any outstanding evidentiary disputes. And I know you all still need to get together to do your evidence view, correct? Has that
Yes,
been
sir.
scheduled yet?
I was gonna talk about that today. I know
Okay.
because of the voluminous nature of it, I wasn't even sure the state was ready to do
Judge,
that.
we do have to, we've gotten some items out of evidence, but I think there are some additional physical items that we need to get out of evidence that were put in trial.
Right.
So we will get that done. I think the photos, for the most part, we're just gonna reprint, but they are a lot of photos, so I do need some time, but we will schedule that.
Okay, so on the lunch break today, I need you guys to figure out a prospective date for that, and then I will set a motion hearing date after that, but we need to have at least an idea of when that's gonna be, because I know your calendars are busy, and I don't want you all to get jammed up, and then we can't get together at least one last time to go over any and all outstanding motions or issues.
Yes.
Okay? All right, and I know we discussed this on the state's motion in limine regarding victims' gang activity and drill rap videos not disclosed in reciprocal discovery. Did I give you all an absolute deadline? Did I pick a date?
Judge, I think they were supposed to provide it to us today, by today.
Okay,
And Judge, that would be any videos that we intended to enter.
Correct.
Any of us.
Yes.
And yes, Judge, you did give us until today to do so. On behalf of Mr. Murphy, I will not be providing the state with any additional videos.
okay. All right, and so state, you're going to take a look at those and then let me know if you have an objection.
Yes, Judge, I believe the attorney for Mr. Chance provided us with a list of videos.
I
So we
did
will
see,
let-
yeah, I did see that. Okay, so I'm going to actually reserve ruling on that motion pending the state taking a look at what's been proffered. And if I need to resolve a dispute, then I will do so whatever our next hearing date will be. Okay? So that one I will reserve ruling on. Yes, Mr. Wise?
Your Honor, while we're talking housekeeping matters, there is, at some point today, I'd like to briefly readdress a question Your Honor asked during my traffic stop motion after having done a little bit of research on it.
Sure.
I can do that now.
Sure.
Okay. So, when we were having argument on that motion at the last hearing date, Your Honor had asked if I would agree that finding the firearm in the car that Mr. Gathright was in would give a basis for, I guess, arrest. I don't know if it was an arrest or a search of the car because he's under 21. And I didn't agree with that for a lot of reasons. But having done a little more research, I don't see a basis, I don't see a reason why his possession of a firearm being under 21 and over 18 was unlawful. I know that's what the officers apparently believed, but I don't see a reason why that was unlawful. And if the state, has a reason that I'm missing, I'm sure they would bring it up. But to go back and readdress that question after having done some other research, it would, if he was under 18, it would have been unlawful, but I don't believe possessing a handgun
Under
between 18 and
21.
21 is unlawful.
Okay, state what's your argument.
Judge, Judge, it is securely encased, I think that he is correct, but there is a law for that. But what he was arrested for was the possession of drugs and drug paraphernalia.
No, I understand, but I think the argument was made, I think law enforcement took the position that that was also,
They did, Judge. They believed that, and correctly so, that there is a law that if you are under the age of 21, you're not allowed to possess a handgun. But there is also additional part of that statute that says as long as it is securely encased, it's our understanding that that was in the console of the car.
so do you agree that that would have been securely encased in the console of the car within the meaning of that statute?
Yes, Your Honor.
Okay, all right, thank you. Okay, all right. So, next, we will move on to argument regarding the various motions as it relates to the gang evidence and whether or not it's going to come in. So the state has filed a motion for pretrial ruling regarding admissibility of evidence. And who's going to argue that motion for the state?
May I be heard, Judge?
Yeah?
Maybe, Your Honor, and again, strictly up to the court, having the defense argue their motions as it relates to limine of all of those things might subsume the state's actual motion when they argue against the same.
Well, no, and I agree. I agree. Really, the point of hearing the state first is for the state to articulate exactly what it is that they're intending to admit. So that's my motivation in asking the state at this point to proceed, is for them to identify on the record exactly which incidents they are intending to introduce, and then I will have the defendants argue their various motions.
Thank you, Your Honor.
Okay?
Judge, can I have 1 moment?
Sure. So if I'm looking at the state's motion, it looks like you're going back as far as 2018.
Yes, Judge, I was just looking, I have so many documents, just trying to find that one.
Yes, I understand. So it looks like pursuant to the motion itself, August 18th of 2018, Joe Rod Adams, also known as Spaz, was murdered at a Rains High School football game. Adams, it's alleged, was a 1200 associate. Robert Howard and Adrian Bibby Gaynor were suspects in the homicide of Adams. Howard and Gaynor are six block members, and Robert Howard was convicted and served a 5-year prison sentence for manslaughter and aggravated battery on that case. I believe Robert Howard was also a victim in this case, and he did testify in the Andrews case. The state also alleges or discussed in February of 2019, Adrian Bibby Gaynor was shot and killed in Jacksonville, Florida. Adrian Bibby Gaynor is known to be close with the victim, Charles Jones, and is associated with 6 Block. Hakeem Cusso Robinson and Leroy Scotty Whitaker, gang members of ATK, are currently charged with murder for the death of Gaynor. Then the state identifies August 16, 2023. Jaquan Pickens, bully gang member, was shot multiple times and killed. Bully gang is associated with and allied with 6 Block. And then August 17th of 2023, there's an attempted murder of Jacoby Beals, a 1200 gang member. This shooting was believed to have been committed in retaliation for the murder of Jake Pickens that occurred the day before on August 18th. On October 7th, 2023, Antonio Tilley, ATK gang member, was murdered. Members from 6 Block claimed credit for the murder on social media. On the same day that Tilley was murdered, immediately after, there was an attempted murder committed against the victim, in our case, Charles Jones. So I'm assuming, are those all of the prior incidents of gang violence that you are seeking to introduce?
Yes, Your Honor. That's what was outlined in my motion that we responded to, the motion for severance for Rashad Murphy. It's also what we have listed previously in all the defendants' case as under notice of inextricably intertwined evidence, Judge. Along with, there are some drill rap videos that also mention some additional gang members that we also intend to introduce. And Judge, it is the state's position that those 6 incidents, as well as the drill rap videos that we have listed in discovery as inextricably intertwined and evidence of motive, is relevant to this case against all of the defendants. First of all, the 3 defendants, Isaiah Chance, Rashad Murphy, and Davian Murphy, are gang members, and as part of our requirement for proof for that particular gang enhancement, we have to prove that they were gang members and that this crime was committed for the purpose of enhancing or benefiting the gang in some way. And Judge, we are prepared to do that. As far as Sean Gathright, we believe that it is also admissible in his case. He is closely tied to Isaiah Chance, who is a known gang member. There is evidence that he is the supplier of the gun, as well as there is evidence that directly links him to the attempted murder of Charles Jones that occurred in October of 2023. We have listed the case law for this argument for inextricably intertwined that is directly relevant to gangs. In particular, I will again cite to that Richardson case what was very clear, that there were 6 prior shootings that was introduced in that trial. That was a gang case that occurred again up in Jacksonville, where a child was shot and killed, and his grandmother and another woman in the car along with him were shot at but unharmed. And what the court went through is this whole argument about inextricably intertwined, and the state in that case was able to show to the jury through the documentation by the gang itself, that's how it qualified these drill rap videos, was the fact that this gang war was documented by the gang members themselves on social media, by not only drill rap videos, by social media postings. All of that was evidence of motive, and the court acknowledged that that was highly prejudicial, especially the prior shootings, but it was not substantially outweighed by the probative value of motive. And that is what this is in this particular case. It is motive. It tells why, in Richardson, why that baby was shot, because there were gang members that were standing on the street where that baby and his family were. And it provided the explanation why that shooting happened, the motive. And it is the motive in this case, that historical gang war actually will show the jury all of the reasons and give context to why this shooting happened. And so it is highly probative. Motive evidence in any case has a very significant probative value. And the court went through that analysis and said that that background, even the collateral crime evidence of the prior shootings, was not outweighed, that prejudicial effect was not outweighed by the probative value. And it is necessary for us to be able to actually explain to the jury what led up to this shooting, what was the motive, why they all came down to Tampa in one day for the specific purpose of shooting Charles Jones. And it all has to do with this back and forth gang war that is going on. 3 of the people of the 4 that are left are part of the gang that are allied together that dislike Charles Jones. Those drill rap videos, the evidence on social media that shows the back and forth, all of those are connected to these 6 incidences that we have alleged. In particular, Adrian Bibby Gaynor has a relationship the first one is the Rains High School where we start. Joe Rod Adams, I apologize, starting with that one, in 2018, he had the nickname Spaz, was a Gang 1200 associate, and is related to the Murphy. So obviously, going back to that specific case, especially since Robert Howard, who is also a person that was with the victim when he shot and is a witness in this case, is relevant and gives history to the significance of the motive in this particular case.
Okay, and I'm not meaning to cut you off, and just so everyone knows, the first thing I really want to discuss and what I'm going to rule on today initially is regarding the introduction of the evidence related to the 6 specified incidents in the state's motion, all right? Because then, once I rule on that, then we can have a discussion regarding what drill rap videos and what other evidence is going to come in once I've ruled on the admissibility of the 6 previous incidents.
And Judge,
okay?
I may ask for the assistance of Ms. Ismer. She has kind of taken over this area for us and covering with the state, and to some particulars, I may require her assistance in responding to the particular specific reasons why they're relevant to the case.
Okay, and that's, you mean as far as the drill rap videos or the actual previous incidents?
Both, Judge.
Okay, so, yeah, so what I'm trying to say is that the Any objections to any specific videos, I will address that after I've ruled on just the general nature of the gang evidence coming in. Once you all know the parameters of what's going to be admissible, then we can visit if there's objections to certain drill rap videos, whether or not they come in. Okay?
Okay.
Okay, very good. All right, anything further before I turn it over to the defense, just with regards to the 6 previous incidents?
And Judge, I know that we probably will go through one by one, but some of the defense motion and limines that have to do with gang, there are several paragraphs that list different items. And so at some point, when we go through those items, I would like the opportunity to address those items.
Sure.
Okay, thank you.
Absolutely. And, one question. There was testimony that Joe Rod Adams is actually the brother of Davion Murphy. Is that correct?
Judge, there was testimony, I believe, by one of the detectives. They knew that there was a relationship. They had him referred to as a brother, but they were not absolutely certain as to whether it was a brother or a cousin. But they are sure that there is a relationship between both of the Murphys and Joe Rod Adams.
Okay.
But he did at one point believe that he was a brother to, I want to make sure, Rashad Murphy and cousin to Davion. I now believe that is the reverse. Is that correct, Mrs. Smith?
The only evidence that we have to support the relationship is that there's a familial relationship, that they are cousins. There was some discussion, but proof as far as setting that forward at trial of a brother relationship, other than referring to them as their brother, is...
So I was going to ask you, what is the state's proof? Unless the defense is conceding that they're related. Mr. Gonzalez? Excuse me. Well, it'd be Mr. Gonzalez and then also Mr. Sonardi.
I'm sorry.
Well, Judge, I think it's the state's burden
I agree.
to provide testimony and evidence that they are in fact related in some way, shape, or form. So I would ask the court to defer to their proof in answering that question.
Okay. Same, Mr. Sonardi?
Same for
Okay.
Davion Murphy.
I'm just asking the question. Okay. So what's your proof?
Statements are calling Mr. Joe Rod Adams their brother.
Whose statements?
Mr. Murphy and, Mr. Davion Murphy and Mr. Rashad Murphy refer to Joe Rod Adams as their brother.
And was that in text messages or?
In their interviews.
In their interviews?
Correct. More recently, there are phone calls which Davion Murphy has made with his mother, which indicate that the relationship is cousins. The detectives' evidence as far as following the gangs that they provided to us in preparing for the case were that the relationship established that they believed it to be was a cousin relationship. But the reference that we have is that they are brothers. I cannot tell the court whether that means that they are blood related or they just refer to each other as a brother.
Okay. Okay, very good. Okay, so who wants to go first?
I'll go, Your Honor.
All right.
Brian Gonzalez on behalf of Rashad Murphy. Judge, how the state of Florida gets to the point where they can elicit this type of evidence is the issue here. The second motion in limine, in addition to the Daubert challenge, requests that the court prohibit the admission of law enforcement opinion testimony and related evidence concerning A, alleged prior gang war history, hearsay-based gang intelligence, and purported uncharged gang-related incidents. It's our belief that the state is going to attempt to present to the jury a large and sweeping narrative that goes back 6 years, at least as referenced in the state's motion for pretrial ruling on admissibility, of a gang war in Jacksonville that includes multiple groups, dozens, if not more, of individuals, a series of shootings and homicides going back to, based on their motion, 2018. This murder being in June of 2024. The state argues that this evidence is inextricably intertwined and that it establishes an underlying motive for this particular offense, the murder of Charles Jones. And it's our belief that that is not supported by admissible evidence. Through what now appears to be 3 detectives, Detectives Nieder, Griffith, and McCullough, the state's going to attempt to introduce opinion testimony, which I submit to the court lacks or labeling historical violence as retaliatory conduct, and also utilizing a plethora and what is the primary basis of their testimony being hearsay-based intelligence derived from reports from other officers, confidential informants that are undocumented, lyrical interpretation of by opinion testimony of rap videos, evidence of uncharged and unsolved shootings, wholly, by the way, unconnected with Mr. Murphy. And collectively, I believe it invites the jury to decide somebody's guilt, in this case, Mr. Murphy's guilt, based on association and propensity rather than admissible evidence. The relief I'm requesting in detail is on page 2 of my motion, and the court will read that in her ruling.
And I'm sorry, we on your second motion in limine or third?
It's number 2, Judge.
Okay.
To that extent, the state is going to have detectives outline a history of this conflict going back to 2018, most of which are unsolved, and none of which are alleged to have been committed by Mr. Murphy. There will be testimony from detectives about gang affiliation as it relates to Mr. Murphy, as it relates to Rashad Murphy, as it relates to Mr. Chance, and there won't be any, I believe, as it relates to Mr. Gathright. The testimony is also going to outline the gangs themselves, the nature of the gangs, inclusive of their background and their history, sometimes going back to their inception, long before any of these detectives were involved in their particular investigation of those individual gangs, collectively or individually, and also how these gangs are not traditional gangs, they're hybrid gangs. They have no hierarchy, they have no rules, they have no consequences, they have no punishments, and that is an important aspect when we talk about how they differ from a traditional gang where one member does things only at the behest of other gang members or at the behest of the gang as a whole. There are individual motivations in these hybrid gangs that may not have any involvement other than an individual grudge or a particular issue between one person and another that doesn't trickle down to any type of group gang type decision or plan, and that is the nature of it being a hybrid gang that mostly is derived historically based on neighborhoods or where you grew up. As it relates to testimony last week, Judge, and I'm going to run through this very quickly, Detective Nieder has 7 years on the job at the Sheriff's Department. He was assigned as late as 2022 to the gang unit, and at that particular time he started working exclusively with ATK. He has taken 3 yearly courses at the beginner and intermediate level through HIDTA, H-I-D-T-A, and these are 3-day organizational crime conferences where general gang intelligence is discussed, and they also do not provide any comprehensive instruction. And this is based on testimony from Detective Nieder, whether it be at the hearing or sworn testimony from his deposition, and that's set forth in the motion with particularity as to where the court can find that. He essentially admits during his deposition that the majority of his training and experience comes from on-the-job training and based on what other detectives had told him prior to him coming on board. Although he alleges that he speaks with a number in a group and on a regular basis community members, they don't openly discuss gang details to where they are documented, to where there are reports, to where there can be testimony as to who they are, and certainly those witnesses will not be testifying in court. As it relates to Detective Drabeck, I'm going to pass him, as I understand by the court's ruling, that he's going to be testifying to this particular investigation in and of itself and will not be testifying to any historical information. As it relates to Detective...
Correct, not as a gang expert.
Correct.
He's a fact witness.
Yes, Judge. As it relates to Detective Griffith, he has been with the department for 16 years, but he didn't join the gang squad until 2021. And for him, he's been through that same HIDA training for 21 through 24, 4 weeks total. And he has never been qualified as an expert or given testimony as an expert. And essentially, he pretty much says the same thing as Detective Nieder says, acknowledging that his knowledge of 1200's activities prior to 2023 is very limited, and he does not have any witness with firsthand knowledge of any group dynamics. All of his testimony, again, is contextual inferences by unknown individuals that he cannot document, he can't tell us when, he can't tell us who, and he can't tell us with particularity what they say. As it relates to Detective McCullough, he began in 2022, and essentially he is in charge, and that's after a long standing history with the department itself, but again, in 2022, January, and he became assigned to 6 Block. He also went through the HIDA training. He also went through and did a couple of other trainings of general types, and talks about how social media downloads, rap videos, interaction, again, with community members would be his source of information, again, with no particularized documentation of any kind in any way, and would not be able to testify to that if given an opportunity to testify to these historical issues. He also had some he was unsure exactly if he'd ever testified before as an expert. He does recall testifying a couple of times. He thinks just in front of a judge and the state attorney, which might lead me to believe it was either a motion or a sentencing. Doesn't appear that he's testified as an expert as it relates to any type of trial testimony.
Well, let me just ask the state something. Who are you intending to call as your gang expert?
Judge, 3 witnesses, Detective Nieder, Griffin, and McCullough. They each are specialized in a particular gang that is involved in this case, and all of them have years of experience in that gang unit monitoring these gangs.
So, but we can't have cumulative testimony.
Correct, Judge, and we will not, it will not be cumulative. There may be 1 or 2 that we cover it all with 1 or 2 and not call the 3rd, but we have just listed them under the abundance of caution if there's something that one of them cannot speak to.
Okay. Okay. Okay, we'll cross that bridge when we get there, so.
And Judge, it's my expectation that we will rely on one of them mostly for the expert testimony, but as far as the documentation, there is documentation. Each one of those gang members have been documented with field incident reports that are maintained by the specific person assigned to that gang, so there is fact-related evidence as well. So we are not intending on offering cumulative evidence.
Okay.
And Judge, what I anticipate Ms. Doherty is talking about is a particular report where a person is documented as a gang member pursuant to statutory criteria. That we're not talking about testimony from people as to their gang history and what they do and what they did and what they might be accused of doing and how they relate potentially to a particular murder or a particular shooting. None of that. What Ms. Doherty, I believe, is talking about is the singular report where a particular person is documented as a gang member and under these criteria. And certainly you look at those criteria, and in and of that criteria is are unknown interviews with unknown people.
Sure, so, but there's two separate issues here, right? Okay, so what we're discussing right now is the historical
Agreed.
evidence.
I
That's all
agree.
we're
I
discussing.
just wanted to respond to.
Yeah, no, that's fine, because and that's what I'm focused on right now.
Understood.
What's the parameters of the historical evidence that's going to be permitted to come in? And three of the defendants, the state has identified for aggravators as being gang members or associates.
Correct.
And so that's a separate issue as far as the state's proof and who they're going to call to establish that, okay? So I just want to make sure that we're clear what I'm focused in on at this particular moment is the history and how much of that's going to come in.
So I'm mistaken, because I thought Mr. Gonzalez said he was on to his second motion in limine, which he's challenging expertise.
We are.
We are, and we'll get there.
Okay.
We'll
All
get
right.
there,
I
but
apologize, Judge.
I'm going to first deal with the issue of the admissibility of the history of the gangs in Jacksonville.
Yes,
okay?
Judge. So in my motion, and I'm not going to go into it because I want to get to other things, I give the court what I believe, based on testimony of detectives at deposition, the backgrounds as to each one of the gangs themselves, 1200, ATK, 6 Block.
Because there are a lot of incidents, it looks like in your motion, Mr. Gonzalez, that the state's not seeking to introduce evidence.
They are, Judge, but they were testified to at deposition, and we did not know until we got this
Yes.
motion
Okay,
for
that's fine.
admissibility.
So, because at this point, the state has identified 6 instances, 6 historical events, and that's the universe at this point of what the state is seeking to introduce. So,
And I'm going to just touch on each one of those.
Okay.
Only those 6, not all the ones that are in the motion, because when the time I wrote the motion,
Right.
we weren't there.
Okay,
So I
very
will
good.
touch on those very briefly because they are in much more specificity and particularity in the motion, but I'm not going to just track the motion. I'm just going to try to give
Sure.
some bullet points on each one of those circumstances.
Okay, thank you.
The gang war narrative, Judge, they are all listed, inclusive of the 6, in the table that I have in the motion. And I just would ask the court to look at that table. Now, you can cut it down to those 6. Just gives an overview of each one of those circumstances. As it's reflected in each one of these detectives' testimony, many of those incidents remain unsolved. Certainly, in trying to determine who might be associated with what, there's not enough evidence to charge anybody with anything. None of these defendants, no one else that might be associated with any kind of gang, and therein lies, even at its root, a problem with what they would like to testify to as it relates to opinion that can't be buttressed by what I believe is admissible evidence, especially as it relates to Mr. Murphy. The state's going to introduce law enforcement testimony that establishes a victim, that talks about a perpetrator's gang affiliation, but no testimony about any one of these individuals specifically involved in any one of those circumstances, except for maybe some testimony as it relates to Mr. Jones's attempted murder on October 7th, because they're going to take a leap and they're going to talk about Mr. Chance and potentially Mr. Gathright, but mostly Mr. Chance. Without establishing this gang association, and I don't mean criteria under 874, I'm talking about evidence from witnesses. I think the state's intent here is to try to fill this evidentiary gap with testimony from one or more of those detectives, and they're going to cloak it as expert testimony or opinion, but regardless of whether it is, it's based on hearsay, it's based on speculation, it's based on contextualized inference, none of which is admissible under 702. So I asked the court to make that correlation as you determine these issues. Of the 6 incidents that we're talking about, take a quick glance.
Sure. So just, again, to recap, August of 2018, the murder of Joe Rod Adams.
Mr. Howard was convicted of manslaughter in that case.
Yes, he was, and will be a witness in this case, correct?
Oh, he will be a witness, and certainly we'll have an emotion limine on that. And I would, based on his deposition and based on his proffer, waiting to hear what he might say on the stand under oath about gangs.
Okay, well,
and about gang association.
And again, the only reason I raise that is because that's actually someone who will be testifying with direct knowledge of these incidents, right?
Direct knowledge of what, Judge?
Of the, he was convicted and served a 5-year prison sentence for the manslaughter and aggravated battery.
Yes, I believe he will testify under oath that, in fact, that's the case.
Which means he can be cross-examined.
Correct.
Which is my point.
Yes, Judge. Okay. And now what other contextual knowledge he may have about anybody here or gangs in general,
No, I
that's
know,
another
I
story.
know. I'm just trying to draw the distinction between at least that incident. The state will have some direct evidence with a witness who then can be cross-examined, right?
Yes, Judge.
Okay, all right.
Now, I don't believe it will be as it relates to evidence that I'm suggesting in this motion is inadmissible or not inextricably intertwined. But nonetheless, we get there when we get there.
Right.
Judge Adrian Bibi Gaynor, Hakeem Kesu Robinson was charged in that case.
Right, and that was from February of 2019.
Yes, Judge.
Okay, then we move on to August 16th of 2023.
Yes, that's Jake Jit Pickens. That case is unsolved. Jacoby Beals is unsolved.
And that's from August 17th of 2023, correct?
That's correct, Judge.
Okay.
Then October 7th, Antonio Tilley, Jawan Mills was convicted on that case, but I don't believe there's any gang association based on testimony from detectives, and I'll get to that when I get to that individual case. And then we have October 7th, which is Charles Jones attempted murder.
Right.
That is unsolved as well.
Okay.
So, Judge, while it might be reasonable to attribute some level of reliability to law enforcement intelligence that's derived from social media, in this instance, the basis for opining that groups, either in rap videos or in social media that no one's going to be able to testify to, right, other than there was some. When, who was on it, what date, who said what, none of that the detectives are capable of testifying to. They can't testify to a rap video and their own speculation and their own opinion as to what that rap video might say, but when we talk about taking credit for something, because that appears to be a big issue, taking credit. The court might remember that Detective Nieder testified that taking credit is actually trolling. You're trolling the other side. You're disrespecting the fact that murder occurred. You might even be lauding that murder occurred or that shooting occurred. And certainly the state would like you to take the leap or allow a jury to hear or allow somebody to testify to. That's an admission of committing a crime. And I would ask the court to look very closely as to whether or not that inference is admissible. Essentially, just briefly, Detective McCullough, when asked, are you saying they're claiming credit for some of these shootings? What do you mean by that? Well, they'll get on social media, Instagram or Spaces or Clubhouse, which is like a social media platform, and they'll just start talking about it. He got what he deserved, stuff like that, just claiming, basically taking responsibility for it. None of that insinuates anyone is taking responsibility for anything. They are rapping about it. And he says that in one part of his response, but then would like to suggest that basically they're taking responsibility, which again is an inadmissible opinion on his part that's not buttressed by any evidence. No one is specifically saying I did this. Well, of course, as we talked about, nobody gets on a video and says, I killed this guy. And I guess that's not what I was asking, but his answer is correct. People are not saying they're just taking credit for it. So what's happening in these social media posts and sometimes in these rap videos, are the same thing that's happening at the same time out in the community. Somebody gets killed, there are thousands of people talking about it. People hate it, people like it, people laud it, people think it was deserved, people know what happened, so-and-so got shot, so-and-so was walking down the street. This is a community whereby social media, the ability to have knowledge and information is quick. And detectives testify to that. This is not relegated to one single group or one single person that knows about what happened to somebody. It's what they say about it. And therefore, we have to be careful. I believe the court has to be careful not to suggest to the jury and not to allow evidence that would lead a jury to believe that somebody had something to do with something when that's not what they're saying.
Right, I agree.
Judge, talking specifically about the 6 instances, I'm trying to talk as fast as I can. Joe Wright Adams.
Right.
The state is going to suggest that there's evidence to believe that Joe Wright Adams is a cousin of Rashad Murphy and Davion Murphy. This occurred in August of 2018, 6 years prior to this particular case. Detective Dishman was the lead detective in that case. In her deposition, she actually said that in investigating this case, that the argument developed over a girl. And it escalated, and at one point in time, Mr. Howard, a state witness, told a person, somebody's going to die on my 8. And then Dishman testified that she believed that Howard was talking about his friend, Lawrence Davis, who's called 8. That's the evidence of this gang affiliation in my mind. What ends up happening subsequently is that Bibby Gaynor is alleged to be a second shooter. He's not charged. Mr. Howard ends up either taking the rap or pleading guilty to a manslaughter on what was an alleged first-degree murder. And essentially along the way, the whole case falls apart because people recant what they were saying. They say they weren't telling the truth.
Right.
And they say they got threats. None law enforcement can't corroborate any of these claims.
Well, let me see this, Mr. Gonzalez. Let's just assume the state has evidence, enough evidence to go before a jury to make the argument that Joe Rod Adams was in fact had some close relationship. They even whether or not they were actual family members, maybe referred to themselves as family members, whatever that may be. Wouldn't that be direct evidence potentially of a motive involving Davion and Rashad Murphy?
No, Judge. I think we have a significant remoteness involved. I don't believe that the jury should be led down a path that simply because one person was related to another, right, that would provide the modus to kill somebody 6 years later.
And remind me, and I may be because I may be misremembering, but was there not a video that Mr. Jones is performing in, or someone affiliated with Mr. Jones, where the gravesite of someone's being desecrated? Am I remembering that correctly?
You are, Judge. It's another incident, though. That's the town center shooting.
Okay.
But there are references. I'm sorry.
Yes, Your Honor, that is correct. And it is of Mr. Joe Rod Adams'
Right.
gravesite.
Right, so Joe Rod Adams, and again, I'm just assuming for the sake of argument that there is evidence that there is some close relationship between the Murphys and Joe Rod Adams. He's murdered, and then Charles Jones actually makes a video where I think that they're pouring alcohol or something on the gravesite.
That's correct, Your Honor. So there was an initial video where it's believed that someone was urinating on the gravesite.
Right.
And Mr. Jones is alleged to have taken that a bit further and made an actual video with beverages or something that
Yeah.
poured on the same.
Yeah, I mean, okay. I just want to make sure I'm getting my facts correct.
And Judge, that's addressed in the motion when you get to it. As it relates to Bibby Gaynor, February 15, 2019, 5.5 years prior to this murder, essentially, Mr. Gaynor is allegedly, well, not allegedly, he's killed by Hakeem Robinson, and essentially Detective Oliver was the lead detective in that case. He was deposed. That was unsolved for about 18 months. Only at such time as a jailhouse snitch came forward and gave information that connected that murder to some type of retaliation, that law enforcement was able to make that connection and attempt to run with that particular theory of prosecution or theory of the murder. At this particular time, I don't believe that person is going to be testifying. It's hearsay. I don't believe that anybody is going to hear from a person who had direct knowledge of what happened or why it happened or under what circumstances it happened. I think that Detective Drabeck, in his deposition, stated that as it relates to Gaynor's murder, that although he was a suspect in Adams' murder that he wasn't charged with because everybody recanted, that he opined that Adams' murder was not the nexus for Bibby Gaynor's murder. That's what he says on page 29 and 30. Instead, he believes that the murder happened out of pure opportunity, not revenge, not retribution. And that's his sworn testimony.
State, just real quick, what's your response to that in regards to?
Your Honor, since the depositions have been taken of those detectives, Queso or Hakeem Robinson, very prominent ATK member, has since been convicted of that crime. And so understanding the defense's argument that the weight of that evidence could be that there's some other reason why that killing occurred, it is yet another act of violence which occurs months after Mr. Howard is arrested for the murder of Joe Rod Adams and killing the other person suspected to have been involved. So the two 6 Block members that are allegedly involved in the homicide of Joe Rod Adams in 2018, one of whom is arrested for that murder, the other of whom is killed in February of 2019, and then obviously now subsequently convicted of that murder.
Okay, thank you.
Judge, next briefly is Antonio Tilley, October 7th of 2023. Tilley, there'll be testimony from detectives again, and I'm not going to go over each time when I talk about testimony from detectives. The court already knows my feeling on how this testimony is going to be elicited from detectives and where they get the information. And I think at the root of the problem, it all is the same. So I'm not going to say that every single time, but every time I mention a detective and every time I mention what that detective is going to testify to, it's really under the same circumstances and same ability that he's going to be testifying to. Somebody else told him that we don't know who it is. Some social media post said it. Some Instagram Live said it. It's not documented. There's no report. There's no witness that's going to testify to it.
But can't gang experts testify to that?
No, Judge, I don't believe they can.
Okay.
Tilley was supposed to be an ATK member. Detective Anderson was the lead detective. Essentially, this was a contract killing. That's what the detective said who investigated the murder. And essentially, it was done by Jaquan Mills. Jaquan Mills is not a gang member. To my knowledge, and based on testimony from detectives, Jaquan Mills is not affiliated with any gang. Essentially, as I understand it, Detective Anderson testified that the suspected contractor is a guy named Paul Anderson, who is now doing a 25-year sentence for drug-related activity. I don't believe there's any indication that Copeland or Anderson are related to 1200 or 6 Block, at least on any basis I know, unless somebody's going to testify to it now, and probably under the same premises that they're going to testify to everything else that they testify to. Anderson then did defer to Detective Nieder in his deposition, and essentially he said, my understanding is that Detective Nieder suggests that Tilley had something to do with Cedarian Copeland's son being shot. So that's potentially the reason all this occurred. We now get to October 7th, 2023, which is Charles Foolio Jones. Obviously, that case is unsolved as well. Now we start dovetailing into evidence I believe is, in fact, potentially admissible against one defendant and shouldn't be admissible against others.
Which is what?
which is NIBIN matches between the shell casings recovered on October 7th at the scene and casings found in Sean Gathwright's vehicle. And essentially, Detective Nieder, based on the same analysis, is going to say that Jones was shot in retaliation for Tilly. And he believes that Isaiah Chance was involved, and his opinion is that Chance and Gathwright were close friends, spent a lot of time together.
Well,
and,
the state's not going to be able to get into that.
well,
It's unsolved, and Detective Nieder is not going to be able to opine that he thinks Isaiah Chance was involved in the attempted murder of Charles Jones.
well, that's been what's been suggested up to now. And
No.
am I mistaken? I'm mistaken.
Judge, we wouldn't go into that sort of opinion testimony. We do plan on presenting the physical evidence that ties him to that,
Yeah.
as well as any statements he made through other, but not through the opinion of
Right.
an officer. They have not charged it.
Not relevant to Mr. Murphy and not admissible to Mr. Murphy.
Well, it's a conspiracy charge.
Judge, again, we'll get to that because that's what the supplemental, that's what the supplemental.
Well, that's a separate issue. So
Right,
let's just
supplemental issue.
let's just
Yeah,
stay
Judge,
focused, so. Listen,
detect-
no gang, if the state calls a gang expert, whoever it may be, they're not going to be able to opine about culpability of anybody who hasn't actually been charged or arrested or proven guilty. So that's not going to happen.
Okay, because certainly Detective Nieder was very clear when he said that Chance was upset with ATK.
Well, I understand. Law
Got it.
enforcement says lots of things in depositions that never come before a jury.
Understood. And that's why we want to make sure that that's
Yeah,
covered in a
it's
motion
not.
like this. Judge, in an incident-by-incident review, in addition to the other incidents that are set forth in the motion, but they don't matter anymore, let's take these 6. We believe that it establishes that the state doesn't possess witnesses with first-hand knowledge capable of establishing gang membership, internal group dynamics of the gang, retaliatory decision-making, or coordinated action amongst these groups, part of the reason being that they're hybrid groups, and nobody is accountable for anybody else. And that is clear by the nature of the detective's definition of this type of association.
Sure, and I indicated in my email yesterday that you all would be given 20 minutes each, so I haven't been timing you, Mr. Gonzalez, but
I hope
I'm
you're
sure-
not, Judge. Don't start now.
I am not, but I'm sure the other counsel would like a chance to weigh in, so I'm going to give you 5 more minutes.
Yes, Judge. Your Honor, when we talk about Hayes and Richardson as it relates to,
The admissibility,
yes, Judge, which is part of a large part of the severance issue as well as the intertwined evidence. I think that, Hayes and Richardson are co-defendants.
correct?
They were tried together, but with separate juries, notably, and essentially.
Because of a Bruton problem.
Judge, there's no Bruton problem here. There's no antagonistic.
No, I know,
defenses
not in
here.
our case. In Richardson Hayes, there was a Bruton problem, which is why they had 2 separate juries, but the case was tried together.
And Judge, although the evidence is similar as to both of them, I think Hayes is a little more illustrative in its opinion. And essentially, in that case, what I want to make sure the court understands, my position, that this is a feud between PCE and 187. You've already heard, things about that, so you can understand the interrelationship. And essentially, these 2 gangs got sideways at a Kodak Black concert in November of 2015. And essentially, that spawned a street war between them that lasted approximately 76 days. And those are the intertwined evidence that the state admitted over objection in that particular case, which is a far cry from the level of alleged inextricably intertwined evidence in this case.
Well, in the Hayes case in particular, and for the record, we're referring to 338 7 3rd 1123. In that case, the specific time frame as far as the historical gang evidence that was admitted was November 25 through January of 2016. That was the specific time frame. And I would just note for the record that in the Andrews case, I did allow Detective Nieder to discuss, I believe, the incidents of violence which kicked off in 2023. Like, you had the two incidents in the 2018, 2019 timeframe, and then there really appeared to be relatively quiet. And then in 2023, the violence cropped up again. So with regards to Ms. Andrews, I did permit Detective Nieder to testify to the history from the 2023. And I do believe, because Mr. Howard testified, that some evidence regarding the killing of Joe Rod Adams came in because he was actually a witness. So,
Fact evidence as to his involvement in that murder.
right.
Judge, the big difference here is that in Hayes and Richardson, first-hand knowledge, there were multiple witnesses that testified that the defendants were members of gangs, they were members of the same gangs, they interacted with the defendants in this case, Hayes and Richardson. In fact, Mr. Bradford testified to what their street names were. He testified they were both known as shooters in the gang and had participated in shootings in the past. That he, on many of the photographs that were entered, was able to say, I know that photograph.
Well, I agree. In that case, I don't see, and I'm not sure if the state called a gang expert or not, but in the reported opinion, the history of the gangs came in through gang members, correct?
Yes,
State?
Judge.
Yeah.
Which is the way it should be.
Well, that's why I asked you if gang experts could testify to that, and you said you didn't believe so.
No, Judge, I don't.
Okay, so I'll hear from the state on why gang experts can testify to that.
And so, Judge, if your court's read the opinion, you're not going to give me much more time. You're glaring at me. I get it.
I'm not, for the record, that's not a glare, Mr. Gonzalez.
I didn't want the record to reflect that.
It's just a mindful look.
Yeah, Judge, and I didn't want the record to reflect that actually as it was said. If you go through those two cases, with Hayes being a little more illustrative, you can see the 180-degree difference between those cases and these. And one of the major arguments of Mr. Murphy is that in circumstances like this, that's what the state needs. They need a first-hand witness to corroborate. They corroborated the videos that were admitted, the witnesses, the first-hand witnesses. They corroborated the photographs that were entered. They went so far as to be able to corroborate the car that was stolen and used in the murder because Mr. Bradford, the witness, supplied it. They were to the defendants. They were able to corroborate the gun that was used.
And I don't disagree. It's a separate issue. So
Judge, at the end of the day, again, I would rely on the motion and the particularity it sets forth, and essentially tell the court that the state can only establish the connection between the charged act and the prior act by relying on the detectives, in my estimation, I believe buttressed by the case law, improper testimony of lyrical interpretations. We skipped through that part, but it's in the motion. And what somebody thinks something says, without it being coded language, without it being a circumstance where this language is used over and over and over and over again, which would allow an expert to testify to it. I do not believe that any of these detectives should be allowed to testify as experts based on the arguments that I've made and also those that are in the motion. I've included their depositions, Judge, which I think are really instructive when they're talking at length about their jobs and what they do and how they do it and how they get their information. I don't think the court has to rely on me. I think it's very clear in the depositions under oath. And finally, Judge, that they are drawing these clues from songs that are released by artists that are commercially viable. They can't establish gang affiliation other than maybe by 874 criteria, which I think is different than testimony that would allow this evidence to be relevant and admissible, and especially to show that there's a motive for these killings. It should be done with competent, non-hearsay evidence, and those prior acts are rendered irrelevant when they're not done that way.
Okay, very good. Okay, let's see. Mr. Sonardi, do you have a motion as it relates to Davion Murphy on this topic? Or have you adopted Mr. Gonzalez's?
Correct. As to the 6 prior acts that the state intends to introduce, both as to Mr. Rashad Murphy and Davion Murphy, we will adopt the arguments of Mr. Gonzalez on behalf of Rashad Murphy, and also add that we can establish that Mr. Davion Murphy was basically incarcerated either in the Jacksonville County Jail and Florida State Prison from 1916 until almost to January 2023.
Do you mean 2016? You
Yes.
said 1916.
I apologize, Judge.
2016.
2016 until January 2023. The same argument as provided by Mr. Gonzalez on behalf of Rashad Murphy. Mr. Davion Murphy is not alleged to be a suspect or anything in either of the 6 prior acts that the state intends to introduce. I concur also in the evidence that's available to even establish that Mr. Davion Murphy is in fact even a gang member of 1200. Again, he was incarcerated the 5-year window under the statute that expired. He is at most an associate. So again, we submit that contrary to the state's position, that introduction of those 6 prior acts as it applies to Davion Murphy would be so highly prejudicial as to not to overcome its probative value. We would ask the court, as to Davion Murphy, to exclude that testimony.
Okay. And Sean Gathright, defendant's motion in limine to exclude collateral evidence. Mr. Wise.
Your Honor, I guess before I begin, maybe for a point of clarification, there are, as you've heard, casings found in Mr. Gathwright's home that not even matches to 2 prior incidents. I think the only one that's of the 6 we've discussed is the prior Charles Jones shooting. So
Correct.
I don't know if the state is, it sounds like the state may not be seeking to admit evidence regarding these other 2 alleged incidents, one of which I don't even think they know what or who the target of was. But could I just ask if do I need to address the Byron Walker incident and this unknown shooting from 2022?
We can speak to that. All the NIBIN correlations to the other shootings from the traffic stop as well as from the safe of Mr. Gathwright's house, we are not going into. The only ones that we are going into were the ones that were actually confirmed, not just NIBIN, but FDLE matches
For
to,
Mr. Jones.
Correct,
Okay.
the attempted murder, and then to our case here.
Okay, so that streamlines it a little bit.
Okay.
So, Your Honor, Mr. Gathwright's a little bit differently situated because he's clearly not a gang member. No one's even alleged that he was a gang member. As you heard from all of the alleged experts who testified, I guess it was last week, none of them had even heard of his name prior to being contacted by Detective Ramos. The only connection that the state has as to Mr. Gathwright is this allegation that he was friends with Isaiah Chance. And even that, I think, is pretty speculative. There clearly were communications between Mr. Gathwright and Chance, but I believe there's some thought that they must have been best friends, and I don't even think there's evidence to support that. The only thing connecting Mr. Gathwright to these gangs is his communication with Chance, and quite frankly, I think that the connection between Mr. Chance and the gangs is pretty speculative as it is, but that's the only connection. So he's clearly not a gang member, and I don't believe he can even really qualify as a gang associate just based on the fact that he's communicating with Chance. But that...
Well, the state has not identified.
No.
And as far as I can tell, they're not seeking to prove that Mr. Gathwright is a criminal gang member or associate, just a member of a conspiracy involving other gang members.
Judge, we're not approving an enhancement against him, but he certainly qualifies as an associate by the meaning of the statute with his association with Isaiah Chance. And Judge, we believe it's the jury's decision to ultimately find who is an associate and who is a member.
Okay. All right.
And again, Judge, if that's the case, then basically everyone Mr. Chance has ever talked to is a gang associate. I know that's probably a separate motion, but when we talk about relevance of all these other prior gang activities, the only connection, again, to Mr. Gathright is the fact that he's communicated with Isaiah Chance. Talking about each one specifically, the Gerard Adams incident, Mr. Gathright would have been 13 years old, I believe, when that took place. The Bibby Gaynor incident, he would have been, I believe, 14 years old. There's nothing connecting him in any way whatsoever to the Jaquan Pickens incident. Same with the Jacoby Beals. And the Antonio Tilley. The only connection, again, with the Charles Jones incident that takes place on the same date is the casings that are found in the Nibin matches. But as you heard from the detectives last week, Mr. Gathright was not even on their radar in that case until the casings came back. So it's really just the mere fact that these casings are in the house. There's no explanation as to how they got there or whatnot. And there are, by the way, as you heard, there's a substantial amount of firearms and firearms evidence within the house that's searched. So that, Your Honor, I believe the relevance, whatever relevance would have all these incidences, and really the only one as to Mr. Gathright that could have any relevance whatsoever is the Charles Jones shooting. But the undue prejudice would far outweigh whatever relevance that evidence might have. I cite two cases in my memorandum that I think are remarkably similar to what we're dealing with here. And looking back now, I probably should have referenced them with regards to the severance issue too, but it's Thomas and Gilly, and it doesn't appear that these were cases that involved gang issues, but it was very similar in that there are prior shooting incidents involving allegedly rival drug dealers and then their associates. Maybe they were connected with gangs, but it's taking the gang word out of it. I think it's really the same exact situation we're dealing with here. There were prior shootings, and then someone is killed in one of these prior shootings, and then there's a shooting that takes place of this prior victim's associates, and then a bystander is killed. So when the defendants were being charged with the shooting of the bystander, and Gilly, and it's not clear why he was severed, but he's severed and tried separately, the state brings in evidence of all these prior shootings, and that goes up on appeal after everyone's convicted. And in both cases, the second DCA says these instances were not necessary to describe the shooting. It was a pretty straightforward, the allegations of the crime they were actually being tried for were pretty straightforward. The courts found they did not need to get into these prior shootings to describe what took place, and it became, as I fear will happen here, a feature of the trial. And for those reasons, both of those defendants' convictions were reversed. And again, I'm not sure why they were severed, but it would appear that Gilly may not have had involvement in these prior shootings. I don't know if that's the case or not, but for whatever reason, he was severed, and it appears, based on my reading of those two cases, it may have been for that reason. But all this prior evidence comes in both cases it becomes a feature, and in both cases the convictions are reversed. And I think it's really the same exact situation we're dealing with here, especially as to Mr. Gathright, because he really has no legitimate connection to any of these gangs.
Okay, very good, thank you.
Judge, we would adopt that argument on behalf of Mr. Rashad Murphy as we would all other defendants' arguments.
Sure.
Same here on behalf of Davian Murphy, Your Honor.
All right, very good. Mr. Petratus.
We filed our own motion, but we would adopt the motions of Mr. Gonzalez and Mr. Wise and their arguments, and I'll try not to be too repetitive.
Okay, and this is Isaiah Chance's. It's titled Defendant's Motion to Exclude Inextricably Intertwined Evidence at Trial.
Yes, Your Honor.
Okay,
And just to go over the murders, again, very briefly, we have one from 6 years ago, the Spaz shooting, which is a alleged 1200, not ATK, of which Mr. Chance is purportedly a member of. And I think it's important to know that Robert Howard, who's, as the court is aware, is going to testify, at his deposition denied being a gang member of 6 Block. So I understand that they're going to try to get it a different way, but they're going to get someone here, like Mr. Gonzalez stated in the Richardson-Hayes case, but this time this person's going to say, no, I wasn't a member of 6 Block. Then we have a 6-month gap. We have the Gaynor shooting. that is alleged, well, it's not alleged, it's a charge of ATK. The next 4 that all occurred in 2023 are all unsolved. And no one is going to testify as that was involved in any of those shootings. You're going to have no gang members to come here and testify to that. In the Pickens, in the state's motion, it says ATK is believed to be involved, Again, it needs to go back to Detective Nieder. And the court asked, the court said you can't opine on someone who committed a crime, that we don't have a conviction. And I would argue that you can't opine the gang affiliation of a person who we don't know committed the crime. You can't, it's another step that requires Detective Nieder to opine. Detective Nieder, in his deposition, stated he gets his info mainly from social media. He does talk to gang members, but he gets general information, not specific information for them. They are not confessing to crimes for him. That's not what's happening. He's just getting general background information from them. And I would argue that's not enough to come in and tell us who committed these crimes and say it's ATK, it's 1200. The Beale shooting is alleged to involve 1200, not ATK, and as Mr. Gonzalez stated, the last Charles Jones shooting has not involved a gang at all. They're going to say that Mr. Gathright is an associate, but again, that involves being friends with one gang member at the most. In Richardson, again, it was 76 days, and the court said this was a continuation and consequence of preceding events. And I'm going to argue that 6 years and 5 years ago, there's not preceding events to this crime. I would argue even, we have an 8-month gap between the last event in this historical gang war and this shooting. The court mentioned Griffin in the Richardson case. It said, to prove its case, the state is entitled to present evidence which paints an accurate picture of the events surrounding these crimes charged, surrounding these crimes. In the Richardson case, again, 76 days, that happened one after another in a 2.5-month period. That is not what we have here. Richardson, one of the reasons they allowed it in, from my reading, was that they wanted to get the state why these victims were in fact the victims. We had a toddler, and we had 2 elderly, or maybe not 2, but an elderly grandmother and a middle-aged lady, and they wanted to explain how they could be the victims in that. But that's not the case here. We have someone, Charles Jones, who is not a random civilian. There's going to be gang evidence presented about Mr. Jones. There's going to be gang evidence presented about all the co-defendants. There's going to be evidence of their involvement in the gang, testimony of a rivalry between ATK 1200 and 6 Block, all without the need to mention any of these prior shootings. The motive can be clear through the state's evidence without having to mention any of these shootings, and I think that's what the court should require. One other thing that hasn't been mentioned is these cases mentioned it cannot be a feature of the trial.
Correct.
And I find it hard to believe that if the state puts on 3 gang experts and then all the witnesses, and I'm going to use witnesses in quotes, to come in here and testify to show the other murders 6 times, that's days. It's days of testimony.
No, and I do just have a little experience because of the Andrews case. That's not what happened. Detective Nieder testified in his capacity as a gang expert, just historically, as far as the history of the gang violence. The state did not bring in, my recollection, any witnesses other than Mr. Howard, who was a victim in this case. So.
Well, we're talking, and I understand that, but I think that's going to be different in this case because I think they're going to try to bring in more.
Well, we'll see. You're right. It cannot become a feature of the trial.
And I find it, I understand, but I just find it hard to believe it will not end up being a feature of the trial if we're talking about 6 other murders. I don't know if that's exactly what happened in the other case, but everything else that I would get to is either in my motion or has been stated by the co-counsel, so that's all I have now.
Okay, very good. All right, state any quick rebuttal just as to the 6 previous incidents that the state wishes to introduce into evidence.
Judge, we are certainly not going to make it a feature of the trial. We do plan on calling one detective to really go over the historical gang war, so it will not be a feature. However, we are going to add
And
some...
who's that going to be? Do you know?
Judge, we believe it's going to be Detective Nieders. The other two are listed because we still have to show gang enhancements and stuff of that nature, and I do believe their expertise adds to...
Sure, that's a separate issue.
That's a separate issue.
In the indictment, the state did specifically allege that Isaiah Chance, Rashad Murphy, and Davion Murphy were either criminal gang members or associates.
That is correct, Judge.
Okay, but not Mr. Gathright.
We did not, Judge. But Judge, there are going to be, I know that Mr. Gonzalez has kept saying, like, this is all based on hearsay. That is not true. There were some additional witnesses that were listed that were involved in those 6 other cases. And again, it's not going to be a feature. What I plan to do, Judge, is to have either a first responder just testify briefly within 2 to 5 minutes that they responded to that homicide, who the victim was, and then the gang expert is later going to connect up that that victim was actually a member of one of these gangs. And then the next day, these are real things, real facts, real deaths that did happen, and the victim of one gang is killed, and then the next day, a victim of the opposite opposing gang is killed. And so, Judge, this jury should have a real, true, accurate picture of the very gang war that is going on. And these incidents also, even though they exceed the time frame, I understand what they're saying about Richardson and Hayes, the particular of that gang war, the escalation of violence, but it was 6 shootings that occurred back and forth, happened in a very short period of time. It's different in this case, but the incidences that we have selected are relevant to this case, and some of the relevance doesn't even have to do with any of them. It has to do with the victim and as a consequence with all of them, because the victim in this case, the motive for, and obviously one of the rap videos that we're going to introduce, and the motive for why they did not like him and were very upset and angry enough to kill him is his drill rap videos. And certainly that also goes to our gang experts' testimony. They do have specialized knowledge. This is something that they all have years of experience in this gang unit where they are monitoring this activity on social media, and it's not hearsay. They are visually monitoring it, and they see a death happen, and then within 2 or 3 days, sometimes within the very next day, there is a video that is posted detailing and ditching the person who was just killed.
Well,
all of that.
Desecrating someone's gravesite is pretty provocative behavior.
Yes, Judge. All of that is part of this gang war back and forth, and the jury needs to have an accurate view, and some of this is highly prejudicial towards the victim because the victim is out there doing the same thing, which makes him a target, and he is dishing and disrespecting the close members, people that we can connect to them, either through their wearing necklaces. They have posted their own videos, Judge. All of that is relevant to this case and is inextricably intertwined and shows why he was targeted and why he was killed. And Judge, when you talk about the hearsay, that is why we have listed either a first responder or the detective. Detective Nieder actually responded to some of those incidents. So we are not going to call 6 witnesses, but certainly the ones that he did not respond to, we have just listed a first responder, or we have listed the detective who actually went on scene and can say, on this day I responded, this person was killed, and his name. And then we will go to our detective to say that that is a confirmed member of 1200, or that is a confirmed member of 6 Block or Bully Gang, which is a subset of 6 Block. So this by no means is going to be a feature of the case. And all of these detectives, even within the depositions, were honest and said they didn't know that that was an unsolved case. But certainly after a case where a victim is identified as a gang member and the opposing group then posts a video claiming credit, making fun of that victim's death the very next week or within a short time period, certainly that is a specialized knowledge, and it goes to the very heart of this case and the very motive why our victim was killed, and the probative value of motive, wanting to kill the victim, has a high value, and it is not going to ever be outweighed by the prejudicial nature. And that is what Harris and Richardson really explain when it let in 6 other shootings into a case, because it gave the jury an accurate depiction of the war, the escalation of this gang war, which led to those 3 people being shot and a child being killed. And so, Judge, that is what we have here. The prejudicial nature is not so significant. Some of these deaths are from our victim side killing the other side. The ones that are targeted, they are not charged with, and none of the detectives said, with the exception of the attempted murder, and we know we're not going to elicit what their personal opinion may be, but certainly there is going to be physical evidence that ties this as part of the conspiracy, that they tried to kill him before and they weren't able to do it. So certainly all of those incidents, even though we go outside of that time period in Richardson and Hayes, are still relevant. They're inextricably intertwined, and those specific cases are tied to our victim and the defendants in this case as being relevant, and again highlight the animosity between these 2 groups. They're making fun of people that are killed back and forth. Some of these shootings within the very next day, including the attempted murder of Charles Jones, was done the very next day after members of the opposing side, one of their members, was shot. And so that is the state's argument, that this is all relevant. It is not going to be a feature of the case, but it goes to the very heart of all of this group's motive to kill Charles Jones, the victim in this case.
Okay, so in the Hayes case, the court stated as follows, and get the page number, at page 1130 of that opinion. In establishing its case, the state is entitled to present evidence which paints an accurate picture of the events surrounding the crime charged, but cannot make the evidence of other crimes the feature of the trial or introduce evidence solely for the purpose of showing bad character or propensity. Collateral crime evidence, regardless of its status as similar or dissimilar fact evidence, is admissible if it is inextricably intertwined with the charged crime. Collateral crime evidence is inextricably intertwined if it is necessary to 1, adequately describe the deed, 2, provide an intelligent account of the crimes charged, 3, establish the entire context out of which the charged crimes arose, or 4, adequately describe the events leading up to the charged crimes. Additionally, evidence is admissible if the prior incidents are relevant to several material issues, including motive, intent, and identity. So based upon the facts and the motions and the arguments of counsel, I am going to find that the 6 identified incidents in the state's motion in limine are inextricably intertwined, and they are relevant to motive, intent, and identity. Okay? So those, just as a threshold, those 6 incidents are admissible in this case. All right, I'm going to take a recess, and so, actually, before I do that, so as it relates to the state's motion in limine regarding those 6 incidents, I'm going to grant it. Let me just take a look here. I'm going to grant the motion, but I'm going to reserve ruling regarding the introduction of any videos, any rap videos that the state seeks to introduce. And once the state does their evidence list, as far as what they're actually going to attempt to introduce, then if there are further objections as to any individual videos, defense can renew their objection and I'll rule. Okay? All right. So as to Isaiah Chance's motion to exclude inextricably intertwined evidence at trial, that motion is denied. However, defense, as I indicated, can raise contemporaneous objections to any individual items of evidence. And with regards to Sean Gathwright's motion in limine to exclude collateral evidence, that is denied. However, again, defense has the ability.
Well, and can I add, because I actually specifically addressed those other two instances, the state is not seeking to evict, so could that be?
Yes,
ruled
it's
granted in part, denied in part?
denied as to the 6 incidents that are in the state's motion that I've articulated here today. It would be granted to any other incidents that are not part of the 6, and that goes as to all defendants. Okay? So we're just talking, so it's denied in part and granted in part. Thank you for that clarification, Mr. Wise. And then as to Rashad Murphy's second motion in limine, there were a number of items, Mr. Gonzalez, that you raised. At this point, it's denied in part only as to the 6 previous incidents that I articulated here today. Okay? All right, we'll take a break, and I'll be back at 10:50.
Court's in recess.
All right, so we just they just went over what we were talking about, our timeline here. So they literally just went over this right as we were talking about it. So it's going to be Adrian Gaynor or Bibby. It's going to be Gerard Adams or Spaz. Then it's going to be Jaquan Pickens, Jacoby Beals, Antonio Tilley, and then, of course, Charles Jones, who was shot in the foot. This was obviously not the time that he was shot in Tampa. So those are literally the things that they just went over. All right, let's continue on here. I can fast forward.
You all able to agree on a date?
Yes, Judge, 3/26 at 9 a.m.
Okay. So I am currently available on the 30th of March and the 31st. Also Monday the 6th, but we pick our jury the 8th, so you guys, I'm sure will be busy getting ready. So you tell me what works best as far as the last round of motion hearings.
Probably the 31st, I would think.
All right, how does that work for everybody? Okay, so can I say 10 a.m.?
Is that March 30th, the court said?
March 31st.
First.
Yes, Judge.
Okay. Mr. Sonardi, Mr. Wise, Mr. Petratus, at work?
Yes, sir.
Okay. All right, March 31st at 10 a.m. We'll call it a status and final motion hearings. And I think my JA is working on the seating chart for jury selection for the 150 where they will be. So I will give that to you all when I see you on the 31st. Okay. All right, okay. Moving on to Defendant Rashad Murphy's 4th motion in limine, opinion identification testimony, and I think Mr. Sonardi filed a similar motion for Davion Murphy, defendant's motion in limine to exclude law enforcement from interpreting or narrating video surveillance.
We did that, Judge.
Pardon me?
We did that, didn't we?
No.
I don't think so.
No.
Your Honor, Mr. Murphy's 4th motion in limine relates to opinion identification testimony. Again, we've been, having a lot of discussion, a lot of argument with these types of areas of evidence. The state intends to introduce a large volume of digital media during the trial, surveillance videos of the shooting at various locations, music videos, as the court's aware, some Airbnb footage, surveillance footage from different businesses, surveillance footage from different jurisdictions, Jacksonville, Polk County, Hillsborough County, and again, the state is going to rely on law enforcement, on the detectives to identify Mr. Murphy in any of those recordings in which they believe he's located. In general, Judge, and pursuant to Bentley versus State, a witness can only testify to the identification of someone depicted on social media when the witness is in a better position than the jury to do so. And obviously, an age-old proposition, and I cite Bentley at 286 Southern 3rd 912, Second District case, and it would suggest that when evidence is such that the witness is in no better position than the jurors to make an identification, then that witness's opinion is inadmissible because it invades the province of the jury. Moreover, in particular in this case, is that law enforcement officers are not permitted to offer an opinion identifying a defendant in digital media unless that witness, that officer was an eyewitness, had a special familiarity with the defendant, or is otherwise qualified as an expert in identification. And that's citing Proctor and Charles, which are cited in the motion. It's my belief, Judge, that no member of law enforcement in this particular case, based on depositions that have been taken and evidence that's been elicited in motions, is in any better position than a juror to make an identification in this particular case. In Mr. Murphy's circumstance, I anticipate that, number one, there will be rap videos that the state has still shots of where they will attempt to identify Mr. Murphy in them. And my position would be the jury can look at Mr. Murphy and look at the still shot and determine whether or not that is Mr. Murphy or not. Certainly, law enforcement, all of them, have had a relatively minimal amount of time over even the time that they've been in the gang units, based on testimony, to have interaction with Mr. Murphy and to see Mr. Murphy on multiple occasions. And so with that in mind, as it relates to that particular identification, I believe the only other thing that, other than people testifying, I've seen Mr. Murphy, but I can't tell you where, and I can't tell you when, and I can't tell you with who, would be that there is Jacksonville footage where it is alleged that Mr. Murphy is getting out of a vehicle, an Uber vehicle, and there is surveillance video from that house that would be admitted for the purposes of identifying Mr. Murphy. In that same circumstance, and that based on that same premise and the law surrounding it, my suggestion to the court is that a police officer can't say, look, there's Mr. Gathright, he's getting out of that car, there's Mr. Murphy, he's getting out of that side, there's Miss Andrews. Court, I believe it was probably introduced in the Andrews case. There's Miss Andrews, she's getting out of that car. I believe that the jury can make that determination. It's their province, and no law enforcement detective is in any better situation to provide and authenticate that evidence. So with that in mind, Judge, I'm asking that you prohibit identifications from detectives as it relates to Mr. Murphy and any digital media that is alleged that he is in.
Okay, very good. So, who's arguing this motion for the state?
Judge, I am.
Well, don't, and do you concede that Bentley versus State at 286 7th 3rd 912, which is a second DCA opinion from 2019, that's basically what the law says, right? That in
Judge,
general, a witness may testify as to the identification of persons depicted in photographs or on video when the witness is in a better position than the jurors to make that identification.
Judge, I do agree with that. Judge, generally, I also am going to provide the court with some case law as well, and that's Johnson v. Florida, as well as Cop v. Florida. And in Johnson v. Florida, there was an officer who was allowed to identify a video and still photographs extracted from a video because they were in a better position than the jury. In particular, it was not from prior, but for instance, if the officer is aware of the defendant's appearance, that how they look at the time of the offense, and if it has changed. So for instance, Mr. Chance, the defendant over there, his hairstyle is much different and shorter than it was at the time when this offense was committed, where he is being viewed on a Ring camera. And so if you look at Johnson v. Florida, it's a 4th District court case where in this particular case, an officer is in a better position to be able to identify the defendant based on that scenario, how they looked at the time of, and it is not prejudicial because it was limited to that officer's familiarity with the defendant at the time of the crime. So it doesn't go to any sort of prejudicial nature of any sort of prior contact that they had with the defendant. And again, I also provided the court with Cop v. Florida, and this is where a security guard who never identified himself as a security guard, who had a bunch of numerous contacts with the defendant in that case, and he had watched the video several times and was very familiar, but in that case it was a grainy video, and he was able to testify and identify but not say that he was a law enforcement officer. So Judge, the 2 cases I've presented to you, and in this case, when we're talking about the video of the scene, there are 3 individuals that are masked and armed. I do not and will not be presenting any sort of evidence from any of the officers in this case as to who those individuals are. However, the main case detective in this case, Detective Ramos, when he is questioned as to or cross-examined by defense if any door is open as to how many people are involved in this crime and if certain builds and stuff of that nature go to how he put this case together. Certainly that isn't a statement of identification, but that goes towards his investigation and him looking at builds and stuff of that nature to circumstantially be able to put forth that case. But as it goes to the Ring videos, and again, defense attorney, Mr. Rashad Murphy, he is not captured on that Ring video. Some of the other defendants are, and some of their appearances have changed. I believe that Johnson v. Florida, as well as Cop v. Florida, give us the right to be able to have law enforcement. For instance, Mr. Isaiah Chance, the case detective, met with him on 3 occasions. One of those meetings that he met with him was for several hours. And because his appearance has changed, and if his appearance is changed from when the crime occurred, that would be appropriate for us to do.
Okay.
And Judge, as far as the videos and the wrap, again, we do plan on, based on expert testimony, I think, which is separate and different based on their part of their job to identify known gang members and studying of videos. And in those videos, there is significant change in appearance as to weight, as to hairstyle. The one that particularly that Mr. Gonzalez is talking about, it was a much older video, so we would want to lay the foundation of exactly when that video was first presented. The defendant had much longer hair and was much thinner at the time of. So we do, again, plan to present expert testimony in that area based on what they were supposed to do and monitor videos, and were tasked with identifying all the individuals within that video based on their expertise. Obviously, it would go to the jury, the ultimate question, whether or not they truly believe that person is in the video.
Okay.
Sure, although I haven't.
Hold on, wait. What?
I'm sorry. I'll take it either misspelling or... Yes, I apologize. When I said Johnson v. Florida, 93 Southern 3rd, 1066, and common spelling John, and then Cop v. Florida, KOPP 314, Southern 3rd, 451.
Okay, hold on, any, just,
Judge, although I haven't had a chance to read Johnson very closely at this particular time, I would note that I don't believe expert testimony changes the foundation of this case law when they're talking about detectives versus gang detectives, and it's not distinguishing as to whether or not a jury is in as equally as a good position to make an identification. As it relates to cop, just looking at it very quickly, I would suggest to the court that it is distinguishable because, as Ms. Doherty said, the videotape is very grainy. It did not provide clear images, and zooming it only worsened it, and therefore, because of that, the witness in that case was allowed to make that identification. And based on what I certainly have seen, I can only tell the court that that is not the circumstance, either in the still photographs that I'm aware of or the video when it's run in real time. So to the extent that I believe cop is distinguishable, I believe the court still should rule in the same manner.
okay? Mr. Sonardi, any further argument?
On behalf of Davion Murphy, Judge, yeah, we have filed a similar motion, preclude, obviously, any of the state's witnesses, be it experts or anyone else, from in any way narrating the videos, that is, includes surveillance videos and any of the rap videos. We would indicate that that is the province of the jury to determine what, if anything, those videos depict or identify. And again, we dovetailing on the motions of Mr. Rashad Murphy.
Okay. Okay, so the state.
I'm sorry,
Yeah.
I didn't know that we were talking about the motion to narrate. Can I just briefly respond to that?
That's fine. That's fine. I'm going to reserve ruling on that part anyway. But yeah, go ahead.
Judge, with regards to, we're obviously not going to put up any of the witnesses to narrate. However, the surveillance videos, I do have the right to question on direct examination any sort of areas that are important the detective can assist in explaining that, like where the cameras are set up.
Sure.
And any sort of questions that go towards his investigation. As far as the rap videos, we're not going to narrate the rap videos either, but again, questions are going to be put towards the gang expert as to some of the significance of what is happening in that video and how it is pertinent and relevant to this case.
Okay.
Judge, and one other thing, since I read Johnson, and I apologize, one of the main reasons the court allowed the identification in that video is that the defendant, after the commission of the crime, had bleached his skin. And certainly that turned out to be a very significant change in his appearance that would have given rise to the fact that the detective had spent hours and hours and hours with him prior to the commission, post-commission of crime, that he could make that distinguishing identification.
Okay. Okay, so as to Defendant Rashad Murphy's fourth motion in limine regarding opinion identification testimony, it is granted, as that is the controlling law pursuant to Bentley v. State, unless there is an exception, and specifically as noted, exceptions would be if the quality of the video is poor, or if in some respect the defendant had changed their appearance after the offense was committed. Those would be the types of exceptions. So the state just needs to be prepared to articulate what would be the exception to Bentley that would allow the law enforcement officer to identify anyone in the video.
Yes, Your Honor.
Okay? And then with regards to Defendant Davion Murphy's motion in limine to exclude law enforcement from interpreting or narrating video surveillance, as far as identity, it's granted, which would be subparagraph A. That's granted. Again, unless there's an exception, and if the state's going to seek to have the witness, the law enforcement witness, issue an opinion as to identity, you just need to be prepared in advance to tell me what the exception is. As to the narration, subparagraphs B and C, I'm going to reserve ruling on those, I just need to hear the evidence as it comes in, and you just need to make a contemporaneous objection.
And Judge, that would relate to all defendants?
Correct. That applies to all defendants. Okay? All right. Thank you. Oh, do me a favor. Attach these two to the back. Okay, thank you. Okay, all right, let's see here. I have Defendant Rashad Murphy's fifth motion in limine regarding irrelevant evidence. And okay, go ahead.
Judge, understanding the court has made some rulings already this morning, whether they be reservations of rulings or rulings, again, there's some dovetail in this motion. It's several different categories of motions, and without being overbearing, I just want to make sure that, A, the ones that have been reserved on or ruled on, the court will identify it for me one more time, and of course, those that need to be ruled on, you do so. The first category, Judge, is NIBIN evidence. There are TPD analyst Sarah Price conducted NIBIN analysis of 9mm casings found at the homicide scene. She reported that those...
I can speed this up a little bit, because
Okay.
I'm agreeing to the NIBINs, as previously stated, and I think all A through E are ones that I've already stated that we are not going to go through,
Okay.
because that's not the attempted murder of Charles Jones.
Got it.
All right, let me just take a look. When you say A through E, are you referring to what?
So on page 1 of his motion, he lists, I think this is what he's talking about.
Okay, yeah,
There's A through E.
okay, and you're agreeing those are not coming in?
Yes.
Okay, so it's granted as to paragraph 1, items A through E on defendant's fifth motion in limine. Okay?
Judge, next items, and before I go off the rails, casings seized from Gathrights vehicle. I believe we've discussed those already earlier this morning, did we not?
We did, except one of the casings goes to the attempted murder of Charles Jones, so I'm not agreeing to that one.
And which
Judge-
one is that one? Is that A or B?
Judge, I'm trying to look at,
I think B is the one you're referring to.
yes.
It is.
It is, it's B.
So you agree to A and C, correct?
Yes.
Okay, so it's granted under paragraph 5, A and C of defendant's Rashad Murphy's fifth motion in limine. Those are granted pursuant to stipulation of the state. And then is there any further argument as to item B?
Only, Judge, that it has been the fodder of argument in other motions as it relates to A, inextricably intertwined evidence, which the court has ruled upon, but also as it would relate to the court's inquiry, which we'll probably get to at the end, as to evidence that is admissible potentially to a defendant or one defendant and not admissible to another. And my argument later will be that the casings found and the identification to the Charles Jones attempt on October 7 would not be admissible as it relates to Mr. Murphy.
Okay,
And I assume we're going to talk about that later.
okay. All right, well, as to that specific item of evidence, the motion in limine will be denied. Okay.
Third, Judge, would be firearm-related evidence. The first would be Mr. Gathwright's vehicle search. I believe the state indicated that, and please correct me, I'm wrong, that those items found in Mr. Gathwright's vehicle you're not going to seek to admit those? Okay. Judge, as the court can see in paragraph 10, on June 26th, as a result of Mr. Gathwright's vehicle, this is another circumstance where we would ultimately later be arguing, pursuant to the court's request, that these items that are found in Mr. Gathwright's vehicle, all of which do not have any direct correlation to the instant murder, first and foremost, and secondly, certainly don't have any relationship or relevance as it relates to Mr. Murphy should not be admitted. And again, would dovetail into one of the reasons for severance, that this evidence is not relevant to Mr. Murphy. It occurs on June 26th. Obviously, one of the tenets is what happens outside of the conspiratorial temporal time frame, and dovetails into the question that the court asked about co-conspirator statements versus evidence that that is found, let's say, in the possession of a co-conspirator. And that's dealt with in my supplemental filing that the court, I'm sure, has read already, but I'll take a short amount of time when it's appropriate to argue that. So that is the next category of evidence that I believe should not be admitted and is irrelevant.
Okay, state what's your response. Are you seeking to admit all of these items, 10A through R?
Judge, yes, we are.
And they're not connected to the charged offense in any respect.
Yes, they are, Judge.
Okay, well, okay, Mr. Gonzalez, are you done?
I am.
Okay, so, Ms. Doherty, why is this relevant?
Judge, first of all, he is a principal, and if you look at the box of the new Straight Talk prepaid phone that is in Gathwaite's vehicle, as well as the prepaid car, and there is a receipt saying that he purchased it on June 6th, we also have evidence showing that he also changed his iCloud account and opened a new iCloud account on that day. Also, within the same vehicle is a piece of paper with several phone numbers. So immediately 2 days after this crime, Mr. Gathwait gets a new phone. His phone that was utilized in the crime, where he's communicating with the second vehicle, is never located. We can show that he purchased it 2 days afterwards. The note that is found with all the phone numbers so that he can program his new phone include the defendant, Rashad Murphy's phone number. The shared phone number that he has with Charmaine Steiger is specifically written out, and it doesn't say Rashad Murphy as the person belonging to that number. It says GH. Again, his nickname is Ghost, so there's a direct link to the co-defendant. Another number on there is G. The nickname for Isaiah Chance is Gutta-Zay or Gutta-Man. That number matches his number specifically. So these are physical items of evidence, and he is a principal. All of the defendants are principals, and so these relevant items of evidence that pertain to the guilt of one defendant certainly is admissible if we prove the other defendants, all of the co-defendants, are principals to the crime, and we certainly will prove that they are all principals to the first-degree murder, as well as some of them are principals to the attempted murder of the 3 other individuals. Judge, if we go back to all of these other items, they are relevant to what we know about the shooting. We have video evidence of how this crime occurred, which 2 AR-style rifles were used, and 1 9mm Glock that had a switch on it. And so all of these items that they have listed on there are relevant because they are either fireable in the AR rifles or attachments that could go to the AR rifles that were shown to be used in this crime that was captured on video. And in particular, the Max Tech 9mm ammunition. They say 2 boxes of unused 9mm Lugo. That actually there was a brand, and that was a Max Tech brand of ammunition, which was the exact brand of ammunition of the shell casings left at our scene. So certainly those are very relevant to the crime. And again, principals, they are responsible and are put in the same shoes of each person that we have proven committed and participated in this crime if they did something to assist. So all of these evidence that are listed, that we did not put in everything that was found in the car, but just the items that we believe are relevant to the actual firearms that were used in this particular case. And Your Honor, may I have one moment?
Yes.
And Judge, just again, the other connection to this particular all of these items being relevant to this case. Again, it's 2 days after our crime was committed. We know and we have evidence that Mr. Gathright was in the suspect vehicle, the Chevy Impala, which he drove and left purposely at his grandmother's house in Polk County. And he was seen by his grandmother moving several items from the Impala into this vehicle, and that is why that vehicle was targeted. So obviously, again, another connection to this crime. We have items of evidence that are significant and relevant to how this homicide and attempted homicide occurred here in Tampa.
All right.
Judge, I would only respond that, again, I don't believe the fact that because the state is setting forth a theory of principles, and because they're setting forth that it's their theory of a prosecution, that this particular phone is a phone that was purchased by Mr. Gathright, not by Mr. Murphy, in order to replace, potentially, as a theory of prosecution, a phone that he no longer wanted anybody to have, doesn't get it any closer to being admissible against Mr. Murphy, nor do I believe, and again, reserving argument for the court's question as to evidence as opposed to statements as it relates to co-conspirators, the fact that none of these items have a direct relationship to the crime at hand certainly is extremely prejudicial, and not the kind of prejudicial evidence I would suggest to the court that happens just in cases in general. It far is outweighed by its prejudicial value, and that is especially not as much to Mr. Gathright, but as it relates to Mr. Murphy and, quite frankly, any other defendant.
Okay.
Next, Judge. Oh, I'm sorry.
Okay, so I'm going to deny the motion as to paragraph 10, items A through R. All right, next up would be the paragraph 12, the items from the residential search of Mr. Gathwright's residence.
Yes, Judge. On the 27th, a day later, Mr. Gathwright's home was searched. There are 2 AR rifles equipped with black mesh brass catchers and 2 spent 9mm. The 9mm were recovered. Oh, they matched casings recovered from the homicide scene, but in a kind of a unique situation, the court might remember, they could not have been fired at the homicide scene because there were the requisite amount of casings found on the 9mm that would have filled the firearm. I'm not a firearm expert or even eloquent as it relates to firearms, but the point being is that Detective Ramos subsequently testified, look, we now know that what was found in Mr. Gathwright's home could not have been fired that night, but certainly that doesn't preclude the fact that there is a match between those casings and this casing. So maybe it was fired from the same firearm at another time. So my argument essentially is the same as it relates to the admissibility of this evidence and its relevance and relationship to Mr. Murphy, and albeit something that may be considered relevant or admissible as to Mr. Gathwright, not so as it relates to Mr. Murphy. Number one, again, far outside the conspiratorial time frame, and secondly, doesn't have any direct relationship to Mr. Murphy.
Okay. All right, State, why are you seeking to admit these from Mr. Gathwright's home? Items A and B.
Judge, I'll speak, if I could, Your Honor. May I have a podium, counsel?
Sure.
I'll speak to the relevance of the firearm evidence, and maybe Ms. Doherty can speak to the relevance to Mr. Murphy specifically. So the 2 shell casings are 9mm shell casings. Just like the ammunition found in Mr. Gathwright's vehicle, they are Max Tech brand 9mm shell casings. 31 shell casings were found at the scene, 9mm shell casings. All Max Tech brand ammunition.
So this is the same brand ammunition. If you recall, in the Andrews case, Bernard De Jesus, who was on scene post-fact and did some interviews, testified, and a predicate was laid to his knowledge and expertise in firearms. And he testified, based on his knowledge of Glock firearms, that the, quote, stick magazine, which is an extended magazine that is utilized in Glock firearms, holds 33 rounds. 31 rounds were found at the scene. These are the other two, it is the state's theory, additional rounds that, in his opinion, during the trial must have fell into the brass catchers as they were being ejected from the pistol, or may have fallen into the brass catcher on one of the other shooter's rifles that was nearby, because the brass was ejecting in the videos towards the direction of the rifle shooters. So that is the relevance, physical relevance of the evidence. And I can let Ms. Doherty speak to the relevance to Mr. Murphy, Rashad Murphy.
And Judge, again, he is a principal to the crime, and all of the physical evidence that are related to the crime would be admissible in his trial as well, even though it's found in another co-defendant's house. It is a part that has ballistically been connected to the homicide. The two AR rifles both match the appearance that are the two AR rifles that are used in this case. There isn't a ballistic or forensic link because none of those shell casings were left at the scene. So we could not do a comparison based on that. But we know that they had brass mesh brass catchers, which we can definitely see that in the video. So it is definitely very relevant, very probative, and the defendant is charged as a principal, and that evidence certainly would be admissible in his case as well.
Okay. All right. Anything further?
Before I go on, just two particular statements with regard to that. Number one, the brand there's nothing unique about this brand of ammunition. It is a common brand of ammunition that it's sold regularly in virtually every gun shop in America, and has no direct relationship to this homicide other than the fact that the brands are similar. Secondly, the appearance alone of those AKs should not be the basis for admission simply without any type of forensic connection whatsoever. It certainly, its prejudicial value outweighs its probative effect. And that's what I would say with regard to those items in Mr. Gathwright's residential search of 627.
Okay. I'm going to deny the motion as to items 12A and B. Their probative value outweighs any prejudicial effect. Okay, moving on to the items recovered from the search of Isaiah Chance's home.
Judge, on the 27th, the same day, soon thereafter or simultaneous with Mr. Gathwright's residential search, Mr. Chance's residence was searched. There was a Glock 9mm with an extended magazine, some ammunition, Generation 5 Glock ammunition, notes that detail how to utilize, I guess, a Glock switch. None of the evidence seized from Mr. Chance's residence, to my knowledge, had any evidentiary connection to the charged offense or to Mr. Murphy. And for those reasons, Judge, and essentially with regard to the same argument, except for the fact in this particular case, I think it's one step removed from items found in Mr. Gathwright's possession, home, or car, and that is that these items have no direct evidentiary connection.
Okay, State, why are these admissible as being relevant?
Judge, I'm agreeing to the Glock 9mm pistol with extended magazine and the box that it belongs to, because we did compare it to our shell casings, and it was determined not to be the Glock that we're looking for or that was used or licensed in this case. I am going to object to the notes detailing the Glock switches in the notebook, because in this particular case, one of the assailants was using a Glock that had a switch on it, so I do think that that is relevant to this case. In another video, a ring video where They are loading up right before they come to Tampa on June 22nd of 2024. Isaiah Chance can be seen to have in his possession what appears to be a firearm with a switch on it. So it is relevant to the case, especially when we have video footage at the scene, and based on the scene as well as the projectiles that were left behind, we know that we are dealing with a Glock switch firearm.
And when it says notes detailing Glock switches in a notebook, what is it?
Judge, there's so much evidence of this case. I would like the opportunity, I don't want to mislead you.
Okay, you just don't know.
Judge, I don't know. I can't remember specifically, but I can't. It's been a while since the last trial.
Okay.
It seems like it may have been something printed off the internet that showed the dimensions of the block switch and how to install it. That's my memory, but I would like to check.
Okay, I'm going to reserve ruling on that one, which is C. And what about a box to a Generation 5?
Granted, Judge, state stipulated that.
You stipulate?
Yeah, Judge, we know that the Glock
Okay.
and the particular one that was located is not the
Okay.
gun. Yes.
So paragraph 14, items A and B, the motion's granted. Item 14C, I'm going to reserve ruling just to give the state a chance to clarify what exactly it is, and then we'll go from there, what the notes are. Okay, moving on to the bully down poster.
Yes, Judge. During the course of the search of Mr. Chance's room or a house, in his room there was a homemade poster that signified the phrase bully down. Bully down, according to testimony by the detectives, is again, gaining that knowledge through the same manner in which they gain the majority, if not all, of their information in their day-to-day activities, is allegedly a subset. Bully down is a subset group of the gang. And whether they're suggesting that Mr. Chance is
Subset of 6 block.
So, bully gang is a subset of 6 block, potentially, allegedly adversary to Mr. Chance, and these are bully down. And the suggestion, and I assume the testimony is going to be, that signifies a diss, or that signifies that bully goes down, something of that nature. Again, they're saying it's in direct disrespect aimed at Foolio or at Charles Jones. Again, under most of the same theories I've been arguing, that Mr. Murphy has no connection. There's been nothing to suggest that Mr. Murphy had anything to do with making that poster, with aligning with that particular mentality or statement, if it's just a creative statement based on the word bully down, and that although the state alleges a conspiracy, again, we're back to the same conspiratorial window, and whether or not items and acts are different than conspiratorial statements. And so all of those circumstances combined would suggest, and of course I don't need to tell the court as I go along through all these things, the admission of those things are part and parcel of the reason that I believe that severances should be granted. But I don't believe that they are relevant and admissible as to Mr. Murphy.
Okay, State, what's your response? Why is this admissible?
Judge, it is a poster that they find, which the expertise from the gang will show that this particular, it's kind of a thumbs down poster in reference to the bully gang, the subset of 6 block. Not only do we have the expert testimony as to what that means, we also have the interview with Isaiah Chance where Detective Ramos specifically asked him about that sign, And there is some acknowledgement on his part, because he starts kind of laughing, acknowledging that they had that. As well as particularly with Rashad Murphy and those videos, we had taken still shots from the videos that certify him as a gang member. He is making that same bully down symbol, the thumbs down kind of symbol in reference to that particular gang. So there is all kinds of connection, Judge, as to the relevance of that located again in a co-defendant and principal to this case.
And is it your position that the evidence of this poster would be admissible against all of the defendants?
Yes, Your Honor.
Okay. All right, I'm gonna deny the motion. Next step would be the Walmart cell phone purchase.
Yes, Judge. In the 24 hours before Mr. Jones's murder, the defendant purchases several items on video from a Jacksonville Walmart, including a prepaid cell phone. Initially, Detective Ramos testified that he believed that this defendant purchased that phone in order to use it during the course of the homicide. Later, however, he confirmed and testified that the purchase of that phone was entirely unrelated to what he originally thought. The phone itself and the purchase of the phone has no relevance to the charged offense, especially as it relates to Detective Ramos's testimony. And the admission of the phone would create a risk that would invite the jury to draw some type of unproven and unsupported evidentiary link between Mr. Murphy and Mr. Gathright, simply because of the nature of two straight talk phones being purchased by two individuals who are alleged to be principals to this particular crime. And it would infer a propensity unrelated to any materiality that this phone has, especially after further explained by Detective Ramos under oath.
Okay, State.
Judge, I'm in agreement with that. Although we are still going to present evidence of Walmart and what the defendant was wearing. And
Right.
There is a photograph that shows the phone that we do not intend to introduce based on or mention the reason of the phone, but the reason that it is necessary is because there is a black boot that is definitely identifiable in that photograph, as well as the rest of his clothing is pertinent to this case and what he's wearing. But we're not going to go into the specifics of purchasing the cell phone or what it was used for. I think that based on their investigation, they did discern and learn that it was going to be smuggled into a jail, and we're not going to go there.
Okay, so it's granted.
Judge, lastly, there are still images on Mr. Murphy's phone. The court is going to do a written order with regard to the motion to suppress the cell phone. Certainly if that were to happen, this would be moot. To the extent that the court denies that motion, a full extraction of Mr. Murphy's phone was not possible because law enforcement damaged the phone without intent, but nonetheless damaged the phone while it was in their custody. And they were only able to get a manual review and extraction from that phone. The screenshots, there were screenshots that were extracted from that phone, 4 of them. Number one, on June 19th, at 1:29 p.m. Eastern, there was a screenshot of a homicide scene that a Yungeen Ace song was tagged. Again, without getting into the many number of different ways in which that image in of itself and then the song in and of itself could have gotten on that phone, that's a story for potentially another day. But it's that image, number one. Number two, a day later on the 20th at 11:02 p.m., there's a photo of 2 rifles that were documented. They are similar to those used in the homicide, but they are not tied to the homicide in any way, shape, or form other than their appearance. June 22nd at 3:09 a.m., there's a photo of a bag, and I assume, again, this is a bag showing a Straight Talk wireless phone, the phone charger, the packs of cigarettes. These are things that were purchased at Walmart. If the state is on the same vein, I suspect they may say, okay, we're not going to use that, but the photo itself, because of the boots that are being worn in the black pants, certainly is relevant. I'll let them argue as to that. On the 22nd, also at 7:26 p.m., there's a screenshot of a text message conveying instructions on how to enter the prison and retrieve a Walmart bag. I would suggest, for the same legal basis that I have argued previously, that these photos, screenshots, pictures are inadmissible. There's no evidence to establish the identity of the people who originally posted those images to social media. And even if authenticity could be determined, the images that are unrelated to this particular homicide have no relevance. I go into a little bit further argument as it relates to the tagging aspect, and essentially the tagging of that song, although we can't suggest that Mr. Murphy had anything to do with that. In addition to Yungeen Ace being a gang member pursuant to testimony from gang detectives, he also is a labeled artist that gets millions and millions and millions of views with regard to all of his different songs. And they are not all drill videos, and they are not all videos that troll or disrespect other people. It is an entire litany of a music catalog. Again, Judge, the state cannot link those firearms to Mr. Murphy in any respect, other than the fact that that picture was sent to him and was on his phone. And in that light, Judge, I would ask the court to prohibit their admission.
Okay, State, are you seeking to admit paragraph 26, items A through D, and if so, why?
Yes, Judge. 26A, the screenshot, it was posted, this is a shared phone to Rashad Murphy and Charmaine Steiger. This is a phone that Ms. Steiger originally said shared, and they equally used, and was found in the defendant's possession. Later, she has recanted and said that it was her phone solely. So obviously, proving attribution is also going to be the state's burden as to who actually uses this phone. We would be willing, there is a Jacksonville homicide scene that is part of it. We would be willing to redact that out. What we are interested in here and what is relevant to this particular case is that on that day he is tagging Yungeen Ace's song. And that was captured in a screenshot. And obviously Yungeen Ace is the member of ATK, he's one of the founding members, and predominantly in some of these videos that are directly relevant to this case, including videos that were posted after the victim was dead, detailing his death, that were posted a few days after the homicide. As to B, as to the photos of the two rifles, they are sent June 20th of 2024 is the timestamp that is in the defendant's shared phone. Again, these two phones match the appearance of the rifles that are used in this case. And there is another connection to Sean Gathright. That same photo is found in Sean Gathright's phone. So that is very relevant, highly probative, and outweighs any prejudice significantly. On June 22nd, that photo, again, we're not interested in the phones and anything else in it, but that is the one photo that we have. It's not really discernible in the video footage from the Walmart of the type of boots that he's wearing, and he's wearing black combat boots. That and everything else that he's wearing matches one of the armed mass shooters in our case, and this is a day before the homicide occurs. And D, June 22nd, the screenshot of text messages with instructions to prison security gates, we are agreeing not to go in there, into that.
Okay.
Judge, I only have one short
Sure.
2-second rebuttal, and that would be, as it relates to item A, Judge,
What was the Yungeen Ace's song that was tagged?
I do not recall, I don't believe it's one of the ones that the
It's not,
state's going to be
Judge.
entering. That would be number one, it is not one of those songs. And second of all, Judge, they said the defendant tagged this song. They don't know that, and I could be wrong. My understanding is anyone could have done that. That's the way it came. And to suggest that there's a link because Mr. Murphy tagged that song, I don't think that's exactly the circumstance. Anyone could have tagged that song. It's on the phone, but I don't believe there's any evidence that would suggest it's Mr. Murphy that did so.
Okay, so just so I'm trying to understand exactly what this is, it's a screenshot on Mr. Rashad Murphy's phone that depicts a homicide scene with the Yungeen Ace's song tagged as part of the depiction of the homicide scene? Is that correct?
And it's kind of a faraway
Judge,
shot, Judge.
we can show you on our computer if you want to see it.
Yeah, let me just... And remind me, what is this relevant to, state, in your opinion?
Judge, it's relevant because Yungeen Ace, who is a member of ATK, this again is going to be corroboration of the gang expert's testimony that 1200 and ATK are allied, and they're allied against 6 Block. And again, this is on Rashad Murphy, a documented member of 1200, and it is relevant because he has on his phone a screenshot, and just like Mr. Gonzalez says, it's going to be at issue attribution, who this phone is being utilized for. We have it with Mr. Rashad Murphy when he's at the Walmart. We have it in the vehicle, the suspect vehicle, when he is arrested. And of course, it never comes to Tampa. So this is a shared phone between him and his girlfriend, Charmaine Steiger. But obviously, with the additional other information that is located on that phone that is relevant to this crime, any sort of connection to the gang is important and probative. But again, this is I know we are not suggesting this Jacksonville murder. We have been explained that it is a Jacksonville youth that is depicted in that picture. We would redact that out. We're not going to go there. I am more interested in the fact and that Yungeen Ace's song is specifically tagged and is screenshotted on his phone.
Okay.
By someone and could have gone to tens, if not hundreds of thousands of people as well.
All right, I understand. That kind of goes more towards, again, weight. So I will, on 26A, the state stipulates it's not going to introduce the photo of the Jacksonville homicide, so it's granted as to that and denied as to the remainder of 26A. 26B is denied, 26C is denied, 26D is granted. Okay, I think that's it from that motion, correct, Mr.?
Judge, 26C granted in part.
Well, it's a photo, the photograph itself does have relevance because it does show the person in the photo with the, according to the state's theory, the similar black combat boots and black pants. So that, for that purpose, it is more probative than prejudicial. So I denied it. Denied the motion in limine to keep it out. So I think that's it for that motion, correct?
Yes, Judge, it is.
Okay. Okay, Davion Murphy, defendant's motion in limine.
Correct, Judge, we've obviously, Nixon argued again for Davion Murphy. We've argued the certification of Mr. Davion Murphy as an associate of gang 1200, so we're not going to reiterate that. That's already before the court. We're arguing paragraph number 2, and that is that the state may intend to introduce the fact that there was a gap of about 6 months from the time that the warrants were issued for Mr. Davion Murphy's arrest until the time that he was in fact taken into custody as consciousness of guilt. I submit all that they have, basically, as I understand it, is the time frame itself, and not that I'm aware of. In fact, as we speak, I'm still not absolutely certain how it was that Mr. Davion Murphy was even identified to be arrested. That I don't have that information. But we would allege that there is no consciousness of guilt simply because of the time frame from the issuance of the warrant for his arrest and the time that he was actually arrested.
Okay,
Just, I'm sorry, what motion are we on? Because I'm kind
it's
of-
Davion Murphy, it's titled Defendant's Motion in Limine. And in that motion, Mr. Sonardi is asking, 1, that the defendant's prior certification of being a gang member of the 1200 gang be excluded. 2, the approximate 6-month lapse in time of the defendant's arrest following the issuance of defendant's arrest warrant. And 3, photos of the deceased victims. What are you referring to when you say the photos of the deceased victims?
I'm sorry?
When you say photos of the deceased victims,
Right, the autopsy photo, oh, I'm sorry, it should be victim.
yes, that confused me a bit.
I'm going to ask the court to reserve on that, and we wait to see which photos exactly the
Okay.
state intends to introduce, we can address it at that time.
okay? So are you now with me on what motion this is?
No, Judge, I don't think I have that one, actually. But I can, if we go one by one, I'll be able to respond.
So the first one is the defendant's prior certification of being a gang member of the 1200 gang. And are you talking about a gang expert testifying as to Mr. Davion Murphy being previously certified before he went to prison? Is that what you're referring to?
That certification expired because of there's a 5-year lapse, so now he's been designated in some manner, allegedly as an associate of the 1200 gang.
Okay, so State, do you agree as far as the prior certification?
Judge,
Sure. No, Your Honor. I think that Mr. Sonardi's argument is regarding the earlier certification from Jacksonville
Right.
and Mr. Murphy's affiliation there. He still meets the statutory criteria, so it changes nothing about the state's argument because he went to prison and then in prison still met the criteria just under the cutthroat gang instead of a 1200 designation. So he still met the criteria. If the argument is that Jacksonville would be permitted or not to testify that he was in fact documented in Jacksonville before he went to prison, then the state has no objection. That's accurate.
That's what I'm hearing, is that you're talking about the previous certification
Correct.
before he went to prison.
Correct. And my understanding is under 874 that previous certification expires after
Right.
5 years, and that he would have to be recertified, which he was not. He was designated as an associate.
Right, which is what the state's seeking to prove, that he's an associate, not a member, correct?
That Mr. Davion Murphy
Yeah.
is a gang member.
I thought you told me associate.
That we,
Judge, I believe he is.
He meets all of the criteria for gang member before and after.
I thought I read somewhere that Isaiah Chance, member of ATK, Rashad Murphy, member of 1200, Davion Murphy, associate of 1200.
Member of 1200, the only associate label that has been lodged against any defendant is for Sean Gathright because of the criteria of association. Davion Murphy, both before and after his release from prison, met more than one criteria.
Yeah, the yes.
In the indictment?
well, I'm not clear exactly as to what it is, the criteria that the state is relying on to certify Mr. Davion Murphy as a gang member of 1200.
Yeah, I don't know, I can't recall now where I read that, because I had made a note a while ago. that the state was seeking to prove that Rashad Murphy and Isaiah Chance were members and Davion Murphy was an associate.
Correct.
So since there appears to be some confusion, I would suggest a,
Judge, I can speak to that.
Okay.
Early on, when we went to the grand jury, he was qualifying as an associate based on the prior certification and the fact that after he went to prison, Mr. Sonardi is correct that they were purging their records. However, based on the fact that he still had that tattoos, he still met the criteria of associate. Mr. Harmon has uncovered some Department of Corrections that we are working to get the STAR report, which shows that he still, even when he went in prison, was connected to a gang. It was a prison gang. And so factually, we believe that we would be able to present enough evidence to the jury to show that the defendant was a gang member and met the criteria when the offense occurred.
Well, correct. We don't have that evidence. I understand what the state's intentions are at this juncture, but
Right.
we do not have that.
We do in fact have multiple
Okay,
factors
it's supposed to
from the
be
gang.
one attorney per motion, just so you all know. So for the state, I need one person to argue this motion.
Judge, we apologize.
Okay, it's fine. So, this needs to be sussed out a little bit more, it sounds like, because I was under the impression the state was going to attempt to establish he was an associate, but it sounds like Mr. Sonardi, now they're going to attempt to establish he was in fact a member. So, regardless, it would be at the time of the offense, and his prior certification would have lapsed, expired, right?
Judge, the prior certification was based, or should be based, if there is nothing within the 5 years, Judge. That is not accurate.
Okay, so
Because-
tell you what, okay, I'm going to reserve ruling, Mr. Sonardi. We just
Okay.
need to see how this,
How we can sort it out, Judge.
yeah, how we can sort this out, and state, if you've got additional evidence, you need to get it turned over ASAP.
And Judge, the majority of the evidence has already been provided. There is just an additional STAR report that we're waiting on.
Okay. And then with regard, are you going to argue consciousness of guilt for the lapse, the 6-month lapse between when the offense occurred until Mr.?
Yes, Your Honor.
Okay, based upon what?
Judge, there was a high-profile media press release that was done both by the Tampa Police Department as well as the Jacksonville Sheriff's Office when the first three, when the arrest warrants went out for all of the defendants. There was a press conference that was done, and 3 of the defendants immediately were arrested, and there was a various attempts by Jacksonville Sheriff's Office to locate Davion Murphy in Jacksonville, and he was able to evade law enforcement for several months, for
So-
6.
So you've got witnesses who are going to testify what they did in an attempt to locate Mr. Murphy and take him
Yes,
into
Your Honor.
custody?
As well as the video footage of the defendant, the day that he was taken into custody, there are several statements that he himself makes when he's waiting for law enforcement to come into the room, where he is talking about how the best place for a person to hide is in plain sight. So there are statements that are made by himself on that video that shows a nexus that he was purposely hiding from law enforcement in this case.
Okay. All right, as to item 2, I'm going to deny the motion. That sounds like a weight versus admissibility. So reserve ruling on paragraphs 1 and 3, and then deny as to paragraph 2.
Thank you.
That's it for that motion, right?
Yes.
Okay, very good, thank you. All right, Isaiah Chance, motion in limine. I think we may have covered a fair amount of this
We have,
already.
Justin Petridis, on behalf of Mr. Chance. For number 1, Judge, prior crimes, I'm really talking about 3 things. The October 7th attempted murder of Charles Jones, but I don't think the state's going to think they've stated they're not intending to.
They're not gonna, no witness is gonna take the stand. If it's an unsolved homicide, no witness, including law enforcement, is gonna take the stand and say, well, I think it was.
Sure.
No one's gonna opine.
And that goes to my other issue was during some detective,
As far as who the perpetrator was.
Correct.
Right, okay. Right, so
some
that's,
detectives mentioned that they believe Mr. Chance is involved in other unsolved homicides, but
Right.
it's the same issue.
yeah, so that's granted.
And then he was arrested for resisting without violence during this case. And I'm asking for that not to come up in this case,
Okay, he
He was in
wasn't charged.
Jacksonville.
He was not charged with that, right?
not in this indictment.
Okay. Okay, granted.
And I think number 2, you've previously ruled on, that's the,
Yes. So, same ruling. Paragraph 3. Well, I've already, I guess, in the context of Mr. Murphy's motion, I've already ruled, so that would be denied. Okay. And paragraph 4. Again, at this point in time, I'm reserving ruling on the introduction of the rap videos until I know what the universe of proffered evidence is. So I'll reserve ruling as to paragraph 4.
I think you've ruled on.
So then we've got the issue of Davion Murphy's alleged statement after the death of Charles Jones. That kind of goes into our severance issue, so I'm going to reserve ruling on that one. Whether that would in fact be admissible against any of the other co-defendants if they were tried separately. Item number 6 has to do with the items found in Sean Gathwright's car. That will be denied. 7 would be the search of Sean Gathwright's home. That will be denied. Paragraph 8 would be the items found in Mr. Chance's residence. I think the state agreed to some,
Yes, Your Honor.
correct? So it would be as previously ruled.
And then I think you wanted to see the picture of the Glock switch. And
Yeah, the notes.
Yes.
Yeah, I need to see that. So I think I can't even remember now. I think I granted some, reserve ruling on some. The clerk has my notes, so I can't remember. So as I previously ruled in the motion for, that Mr. Gonzalez argued on behalf of Rashad Murphy. Okay, and then we've got, the Glock 9mm and the firearm. I think the state agreed to that one, right? With regards to Mr. Chance?
Yes.
Okay, so that one's, paragraph 9 is granted. Paragraph 10, the bully down poster, that's denied. 11, the notes, that's the one I've reserved ruling on.
That's an error, Judge. I put that twice.
That's fine.
Okay.
12,
So this goes to the history. This is,
okay, that one is denied. 13 has to do with the social media post on November 19, 2023.
goes to allowing an expert to interpret the social media posts.
Okay, and I'm assuming, State, you're going to seek to introduce this?
Yes, Your Honor.
Okay, so that one's denied. 14, the Cash App transaction.
This is both the transaction and describing what an expert believes the basis behind the transaction is. It's simply a transaction of Jacory Rivers paying.
Right, this is for the Airbnb though, right?
Yes.
Okay, right, so,
Jacory Rivers is not going to testify.
right. But I mean, the fact that the transaction occurred is admissible, you're just saying no one can opine what the reason was,
Correct, Your Honor.
right? State, you agree?
Judge, I agree, but it's certainly up to closing argument.
Sure,
as
that's
to the
different.
amount. Yes,
We're just talking
Judge.
about the evidence. So the
Yes.
evidence, so 14 is granted as far as the evidence itself is admissible. I'm sorry, it's denied as to the evidence, it's granted as to any, the admissibility of the evidence is denied, but it's granted as to any opinion for why the transaction occurred. So denied in part, granted in part. Okay, 15,
You may have already ruled on this in general,
yeah.
just opining on phrases.
Unless it's being offered, unless the opinion is part of expert opinion, right?
Yes, Your Honor.
Okay. So I guess it's technically denied, but it only comes in through potentially expert opinion,
Yes, Your Honor.
okay? Let me just make a note. All right, 16.
I don't think the state's intending to introduce these, but I don't want to speak for them.
Communications between Andrews and Chance.
Judge, we'd agree to 16.
Okay, granted. And I think 17, same, no one's
Same.
going to opine as to Mr. Chance's purported involvement in the October 7, 2023 shooting of Charles Jones. 18,
It's about from a conversation in spaces.
okay. State, what's your response to this one? Are you saying these are, what are these?
Judge, those are relevant, Judge, and we would object. That is the conversation that happens a couple of weeks right before a homicide where he is, and that actually not only are the public watching this, but law enforcement is actually watching it and recording it, and that is when Charles Jones is having a conversation with our victim asking about his foot. The October 7th of 2023 attempted murder that is also tied ballistically to this case. The victim was indeed shot in his foot. So that is relevant, as well as, again, the co-defendants in this case. When that is happening, Sean Gathright is receiving a message from Rashad Murphy where there is dialogue concerned about this happening on X because they have bigger plans. So certainly that is relevant and probative to this homicide.
Okay, 18 is denied. 19,
Did I understand Mr. Howard's going to testify, and obviously he could testify,
Judge, I
but
think that was 18. I'm
yeah,
sorry.
18 denied. We're moving on to 19.
we're just asking that he not be allowed to opine on what Mr. Chance meant by something Mr. Chance said to him, allegedly.
Okay, state what's your response?
Judge, we know that he could not comment on the defendant's state of mind, but certainly he can give his opinion as to their conversation that they were having.
Sure. So it's granted as to, and Mr. Howard opining as to Mr. Chance's state of mind. Okay, 20, again, this would seek to exclude Mr. Howard giving opinion testimony regarding social media posts allegedly made by Mr. Chance after the murder. State what's your response?
Hold on 1 second, Judge. Judge, we, again, are not going to ask him what Mr. Chance or the defendant, what he may have meant, but certainly he can testify as to seeing the post and the relevance and the effect on the listener, how it was pertinent to him.
Okay. So it's granted as to opinion testimony. Okay. You can't, again, opine as to Mr. Chance's, what he was in, what it meant when Mr. Chance posted what he did. He can testify to the facts. Okay, and then 21, any allegation, mention, inference, or indication, whether through witness testimony, picture, or attorney statements to the jury regarding Mr. Chance being the mastermind. Is the state going to argue he's the mastermind?
Judge, I do think based on the evidence as well as, Judge, I do believe that is appropriate for closing argument as long as it's based on the evidence that we produced during the trial. as far as eliciting that from a detective
Sure.
or anything of that nature,
No.
we certainly would not be doing
Okay,
that.
because the reason I asked, because it did, in the motion, it specifically said attorney statements. So to me, that seems that you would want to prevent the state from even arguing that.
Yes, Judge, but I would agree that I'm more interested in not having the detectives or
Okay.
witnesses.
All right, it's granted as to any witnesses, and it's denied as to the state's closing, assuming they've got evidence to back up their argument.
Yes, Your Honor.
Okay, that's it for Mr. Chance's motion and limine. Okay, are there any other motions? I don't have a pile of anything left.
I think that is it.
Okay, all right, very good. I think we had 59 motions, so we made pretty good progress. Okay, so I think the last thing we need to do is wrap up, and I asked you all, I've taken the motion to sever under advisement, and so my kind of last thing I want to hear from you is, now that we at least have an idea as to the universe of evidence, what specific evidence you're going to argue on behalf of your client would be inadmissible if they were tried individually, sufficient to warrant a severance? Does anybody want to kick off?
I will, Judge.
Okay?
Judge, also, and I don't know the court's position on this. As you know, I filed a supplemental memorandum of law as it relates to severance issues, as I told the court that I would like to do last week when we finished with the severance argument. The state, in turn, responded to that. Is this court going to allow us to argue that as well?
You can. You can.
Okay.
So, but
We can do this now, Judge, what the court asked.
Yeah, it's 2:37 in the afternoon, so if you wish to have further legal argument regarding the severance issue, that's fine. I would like you to first answer my question.
Certainly.
And then I'll give each of you 20 minutes to, in total. So it's 2:37. Mr. Gonzalez, you have the floor.
Judge, I did a filing, and essentially the items that I believe would be admissible, not admissible against Mr. Murphy and potentially is admissible to other defendants. Number one, messages sent by Isaiah Chance to co-defendant Andrews, telling her that he needed to stay low and asked her to remain loyal. That was October 7th, 2023, the same day as the attempted murder of Charles Jones. And I expect Detective Nieder to testify that Mr. Chance and Mr. Gathright were suspects in that murder. I believe
Well,
that.
no, they're not going to testify to that. We've discussed that a couple of times now. No one's going to opine who the suspects are.
And whether or not it's admissible to Mr. Chance, I would suggest that if it is, it's not admissible to Mr. Murphy. Next would be, Judge, on...
Because why?
Because number one, it's outside the scope of the conspiratorial time frame. Number two, it's not relevant as it relates to Mr. Murphy. What Mr. Chance indicated to Ms. Andrews about that particular incident, well, even if it relates to that particular incident, we don't even know if that statement relates to that incident. That would be the state's theory of prosecution. But in any event, it certainly would be impactful, would be a minimizing word as it relates to what the jury could, the road they could go down considering what effect it may have on Mr. Murphy.
Okay.
So,
all right, very good.
As it relates to two, that would be the recorded social media video where Mr. Chance is addressing Mr. Jones on X, saying, "Hey, Foolio, your foot okay, cuh? I got bigger fish to fry." Again, this, referring, presumably, theory of prosecution, to the attempted murder on October 7th. It would be the same theory, the same reason for inadmissibility, may be admissible to Mr. Chance, and I believe not admissible to Mr. Murphy for the same reasons.
And was that date also October 7th?
That date was June 6th of 2024.
Okay. Okay.
Next, Judge, would be all items, but specifically, and the court's already ruled them to be admissible in general, and that is shell casings that are, and all items, for that matter, that are found in Mr. Gathwright's vehicle at the time of the search on June 26, 2024. And again, all of these incidents, Judge, are post-conspiratorial, and ballistic comparison suggests that those casings match the October 7th attempted murder of Charles Jones. May impact Mr. Gathwright, may impact Mr. Chance. Again, the same theory as it relates to the spillover, as to the thoughts that a jury may have as to Mr. Murphy's involvement, and I believe that would require severance. Same as it relates to all of the items on June 27th, post-conspiracy.
The items, the physical evidence found.
Yes, items of physical evidence in both circumstances. 26th and 27th as it relates to Gathwright's residence and Gathwright's vehicle. Next, Judge. Chance's Instagram posts that he had to switch it up, coming different, all 2024, love you, brother. Tagged music by Charles Jones.
What is the date of that?
That is November 23rd, 2023. Pre-conspiratorial time frame. And tagging Antonio Tilley and Ghost 187 _. Detective Nieder, I believe, will testify that in his opinion, Chance was upset with ATK because they didn't get a get back for Tilley's murder in October of 2023, and that he had a falling out with ATK and was now associating with 1200, and then Detective Nieder opining that Ghost 187 is Rashad Murphy. Certainly potentially relevant and admissible as it relates to Chance, and under the same theories, in my estimation, and I believe based on the law, inadmissible as to Mr. Murphy. Next, Judge, and the court made some statements. It was not a ruling, but the court made some statements, as I understood it last week, with regard to celebratory statements made by Davion Murphy. Post-conspiratory, I'm coming home, my thirst is quenched, pop a bottle of Don Julio today. And although I don't believe the court made a formal ruling, my argument would be under the same theories and under the same time frame that those statements are post-conspiratorial in terms of the time frame, and although they may be admissible against Mr. Murphy, Davion, they should not be admissible against Mr. Rashad Murphy. Next, Judge, is categorized gang affiliation evidence. These next 1, 2, 3, 4, 5 incidents are, and I don't have any police reports on these things. I don't have any social media posts on any of these things. I don't have any pictures of any of these things. I don't have any videos of any of these things because they appear in Isaiah Chance's gang documentation FIR. So it is in evidence, and to the extent that the state would seek to introduce all of these varying pieces of evidence that I believe may be relevant to Isaiah Chance, number one, to maybe segue into a gang certification or documentation, or as some type of inextricably intertwined evidence. I don't know under what theory, but the only thing I have, and it's very detailed as to its generalities, there are no actual documents that we have been provided because I don't know that they exist. This is the FIR regarding Mr. Chance. For all of those same theories, and the dates are March of 24, July of 23, February of 24, December of 23, March of 24, all in that same time frame, which certainly is all extensively pre-conspiracy. My arguments being the same, they may be relevant and admissible as it relates to Mr. Chance, not admissible in my view as to Mr. Murphy.
Does your supplemental or your amended identify these with specificity, this gang affiliation
No, Judge,
evidence?
these would be in my filing, a notice of filing. I did an itemized list of evidence admissible against co-defendants, but not the defendant. You asked Judge Firth to orally give it to you.
Yeah.
I just put it in written form.
Okay.
So it'd be a little bit more particularized.
Okay.
Finally, Judge, two more issues. Again, the bully down poster that the court has admitted or determined not to exclude in limine. My position again and that would be inclusive of all the other items. The court, declining to make it, a limited item and allowing it to be introduced, certainly it doesn't change the court's ruling, but it does change, in my mind, the ramifications as it relates to Mr. Murphy. And therefore, that bully down poster and the other items in Mr. Chance's residence, again, post-conspiracy, June 27th of 24. Although they are seized post-conspiracy, I assume the state's going to say they pertain to pre-conspiracy, not during conspiracy, but pre-conspiracy. And I would suggest again, potentially admissible as it relates to Mr. Chance, and I would tell the court not admissible as it relates to Mr. Murphy. Finally, Judge, there are Cash App records, and also Detective Ramos testified in his deposition about Mr. Chance. You heard about it a little bit earlier, that it's Mr. Chance's Cash App is rich on war. He's, he makes money killing people for the gang, and there are several entries to his Cash App. I don't recall whether they specifically reference transactions that the state is going to insinuate may be relevant to this or any other murder or shooting, but the records even in general, with his handle being Mr. Rich on War, again, these are pre-conspiratorial, and additionally, Detective Ramos suggesting he's the mastermind, he handles the gang war, and he is involved in ongoing violent gang activity. Again, I would suggest to the court under all of the same theories as it relates to relevance, as it relates to character, as it relates to pre- and post-conspiratorial timeframes, might be admissible against Mr. Chance, and I would suggest to the court they, for a number of reasons, not admissible as to Mr. Murphy, and certainly would be extremely, extremely prejudicial.
Okay. All right, thank you. Okay, Mr. Sonardi, on behalf of Davion Murphy, do you have any additional specific items of evidence that you contend would be inadmissible against Mr. Murphy if he were on trial alone?
In addition to those items that were already
Anything other than Mr. Gonzalez just identified?
No, Your Honor, other than any of the social media posts do not involve Mr. Davion Murphy, and none of the rap videos involve Mr. Davion Murphy. We just incorporate all the other items identified as to Rashad Murphy that would not be admissible if Mr. Davion Murphy were tried individually.
Okay, very good. All right, Mr. Wise, on behalf of Mr. Gathright, any additional items, specific items of evidence that we've not already discussed?
Sort of, Your Honor. Again, I think Mr. Gathright is a little different in that he's not alleged to have been one of the gang members. So I think 5 of the 6 collateral incidents, I think, would not be admissible against him. Again, for 2 of those, he was a child when they transpired. But I think the only one that would have any relevance to him would be the alleged prior shooting of Charles Jones, and that's only because of the shell casings being found in the car. Otherwise, there's no connection whatsoever to him and the gangs. So I don't think really, the bulk of the evidence that we've been hearing about, including the communications with Mr. Chance about switching gangs, things like that, I don't see any of that being admissible against Mr. Gathright if he were to be tried separately, because he's not alleged to have been really even an associate of these gangs. The same thing with the rap videos. Other than that, I think it's really the same individual pieces of evidence that Mr. Gonzalez pointed out. Again, I recognize a lot of what he pointed out are things that do relate to Mr. Gathright, being the things that are found in the car, but all of these collateral incidents and the discussions of the gangs and whatnot, I don't believe do. The one thing that I don't know if was brought up, but it was the subject of one of the motions limited just a moment ago, is the alleged consciousness of guilt of the other Mr. Murphy, which is something I don't think would be admissible against any of the other defendants if they were tried separately. And that being the allegation that he went to another jurisdiction or whatnot.
Okay. All right, very good. And, okay, finally, as to Mr. Chance, Mr. Petratus, any additional items of evidence that have not previously been discussed?
Judge, I think Mr. Gonzalez spoke about Davion Murphy's post-conspiracy statements. We would also add, we believe, Robert Howard's testimony when it comes specifically to Rashad Murphy, alleged threats he may have made in the history of Robert Howard being convicted of a crime involving a quote-unquote brother of Rashad Murphy. We haven't gotten into this yet, but the drill rap videos, none of which include Mr. Chance, we would argue, and then any historical gang information regarding 1200. Obviously, Mr. Chance has documented ATK, or that's the allegation. And we would argue anything involving 1200 would be prejudicial.
Okay. All right, State, Mrs. Murray, you gonna argue this?
I will try, Your Honor. If I can clarify, does the court wish for me to address the arguments now that were made by each of the defense counsels as it relates to the drill rap videos, or reserve that for when the court has the videos before it?
Yeah, just reserve for the time being on the drill rap videos, just until we know what actually is gonna come in, so.
Yes, Your Honor.
So I guess I just need to know from you, with regard to the identified items of evidence, what's the state's position as far as whether or not those would be admissible against all of these defendants if they were tried individually?
As stated by each of the defense counsels at this point, in its totality, the state's position is that as evidence of principle and as evidence in support of the conspiracy, all of the evidence would be admissible in trial against each of the defendants. Most specifically because in establishing that one defendant committed this crime, the state would in fact be proving up that each of the co-defendants were in some way related to the offense. If they were gang members, we would still present evidence of that as the co-defendant being a gang member. We would still present each of the articles of evidence that have been listed. I'll go specifically for the court, but the overall position is that the evidence would still be admissible in each of these defendants' cases. So if
let's start with the messages sent by Isaiah Chance to the co-defendant Alicia Andrews on or about October 7th of 2023. Would those be admissible against Mr. Davion Murphy, Rashad Murphy, or Sean Gathright if they went to trial individually?
Yes, Your Honor. So we would ask to submit those articles of evidence as evidence of motive in this case because we have the ballistics evidence that links that earlier shooting to the subsequent homicide of Mr. Jones. We would ask for a limiting instruction in presenting that evidence, but we would certainly ask to admit that evidence in each of their trials.
Okay. I'm not sure. All right, and what about the recorded video where Isaiah Chance responded? I think it was dated June 6th of 2024, where he's responding to, is it Julio Foolio? Who's he responding to? Charles Jones?
Yes, Your Honor. They're on Spaces. That's the one where verbally back and forth they are communicating with each other. Mr. Chance is posting on his social media accounts and is going back and forth with Mr. Jones. That, in addition to Sean Gathright and Rashad Murphy then discussing Sean Gathright's boy going crazy on the internet on his social media accounts and telling him to calm down because they have bigger things to deal with. Absolutely, the state would be seeking to admit the evidence against each and every defendant, including Davion Murphy, given we've charged conspiracy in this case.
Okay. And then obviously the physical evidence that was found at Sean Gathright's car, at his residence.
Same argument that was previously made and seeking the same ruling from the court.
Okay. What about Isaiah Chance's Instagram post from November 23rd of 23? Why is that? Why would that come in against all the other co-defendants?
So that post is made a month after the earlier attempt on Mr. Jones's life. For the same reason that Mr. Chance and Mr. Gathright were linked to that offense. This is the same offense that we're discussing when Mr. Chance sends the messages to Ms. Andrews in the same month about the earlier attempt on Mr. Jones's life. The law enforcement officers from Jacksonville will talk about how at the same time it's not just Mr. Jones's life that was attempted at the October 7th date, but in the hours before Mr. Jones's life was taken, Mr. Tilley's life was taken. So the posts from Isaiah Chance then subsequent to that are about how he is transitioning from one gang over to the other because he is upset with how his current gang has represented or come forward in support of the death or homicide that occurred with Antonio Tilley. So when he posts this, he actually tags Ghost 187. At the time of Charles Jones and Antonio Tilley's homicide, Chance was associated with ATK. This is the detective's discussion or describing some of the detective's discussion about how he transitions from ATK to 1200 and how. He tags Ghost 187, who we ultimately linked to Rashad Murphy, a 1200 member. So when law enforcement says we saw that he started posting with and he was in music videos with or whatever it was, that there was some relationship between ATK and 1200, this is just evidence of that. The defendant posts this to his social media account. It's actually a video with a
Isaiah
caption.
Chance does?
Yes.
Okay, and then what's your argument regarding the post-conspiracy celebratory post by Davion Murphy? How is that admissible against the other co-defendants?
As it relates to Sean Gathright, it comes from Sean Gathright's device. The timing of the post, or they're actually text messages that are immediately sent after the homicide itself. The argument from defense that it's definitely Davion Murphy is not one that the state also takes. Yes, investigators reached out to the recipients of those messages to try and ascertain whether it was Rashad Murphy, Davion Murphy, or Sean Gathright, because it comes from Mr. Gathright's device. But the messages themselves or the content of the messages are not being offered by the state for their truth. I have no idea if at the time Mr. Murphy or whomever sent the message was going home or had a thirst quenched. Instead, it goes to the identification of the suspects, it goes to the intent in this case, and it goes to knowledge. So we would have we would seek to introduce against each of the defendants in a trial these messages that come from Mr. Gathwright's device but were signed Murph. There is no direct evidence for us to establish whether it was Davion Murphy or Rashad Murphy. The only thing that we have is investigators attempting to follow up with the persons who received the messages.
And that was on Mr. Gathwright's phone?
Correct, Your Honor.
Okay. Okay. Some of this I've already basically ruled on. The gang affiliation evidence as to Isaiah Chance, I'm assuming you would argue that you would seek to introduce that if these gentlemen were tried individually, correct?
Yes, Your Honor.
And the same with the bully down poster, correct?
Yes, Your Honor, same argument.
And the Cash App records for the rental of the Airbnb, right?
Same argument, yes, Your Honor.
Okay. And what about Robert Howard's testimony of threats made by Isaiah Chance?
I think Mr. Howard's testimony were threats by Rashad Murphy, if I'm not mistaken. I think that was Mr. Pretrial argument. Is that what you're referring to?
I think that's what he was referring to, Mr. Pretrial was arguing.
I just want to make sure we're arguing the right thing. Okay, so yes, Mr. Howard did receive some phone calls or voicemails from Rashad Murphy leading up to the offense itself. Those are relevant to premeditation, motive, and intent in this case, and as it relates to all of the defendants. Mr. Chance is alleged by Robert Howard to have made similar calls, not threatening in any manner, but calls in advance of the offense itself in anticipation of the offense occurring or something occurring in Tampa, and that evidence again would be sought to be introduced given all of the defendants acted as a part of a conspiracy.
Okay, thank you. All right, so I'll start with you, Mr. Gonzalez. What is your response to the state's contention that Davion Murphy's celebratory post-homicide of Mr. Jones would be admissible against your client, and that it's not hearsay because they're not trying to prove the truth of the matter, they're trying to prove identity?
Identity as to
who the perpetrators were.
Well, Judge, I can tell you that, as I remember it, the two messages that went out went to two separate people. Although law enforcement was not able to talk to one of the two, they did speak to one of the two, and Detective Ramos says it was Davion Murphy. I spoke to that person, and that person indicated to me that it was Davion Murphy that sent her that post or sent her that message. I don't know details on that. I am referring to Detective Ramos's testimony, and in that light, and the fact that, as I believe it, Mr. Davion Murphy has been identified, and I think Detective Ramos will testify as such, at least to one of those two posts, that in and of itself it would not be relevant and it would not be admissible as to Rashad Murphy. And simply to identify, okay, if it's going to identify anybody, it's going to identify Davion Murphy because that's what the person on the other end of it told Detective Ramos. So that would be my position as to its relevance as it relates to Mr. Rashad Murphy.
Okay. Okay, so I'm not so sure, as I indicated, I'm not sure about the celebratory post-homicide, and I'm not sure about the message being sent by Isaiah Chance to Alicia Andrews after the October 7, 2023. I'm not sure. And I know I don't want to roll the dice in a death penalty case, so state, you just really need to think about this, because I'm not sure about those two. If they would be admissible against all of the defendants. I don't know.
Yes, Your Honor.
So,
Judge, I know that you said the Alicia Andrew and message to, from Charles, I'm sorry, Isaiah Chance, what was the second one? The post by Davey and
Yep.
Murphy afterwards?
Mhm.
Okay.
as I sit
And Your
here,
Honor, I just want to confirm, I understand that in the motion from the defense, they're referred to as celebratory posts, but in confirming with the defense, Mr. Gonzalez is actually referencing the text messages from Mr. Gathwright's device. 2 sets of text messages, not posts, because there are posts to be.
Again, my illiteracy when it comes to,
let me see them, please.
I've seen them, Judge, so. And Judge, I might take this one step further, is I believe that when Detective Ramos spoke to one of these ladies, she in fact knew Davion Murphy, but did not know Rashad Murphy, as I remember it. And I could be wrong, I don't think I am, but I think that inquiry was made of Detective Ramos in deposition.
Okay. As I indicated, I'm not sure. And I'm not really inclined to roll the dice in a death penalty case, okay? So, state, it seems to me you're going to have to pick.
And you're referring to the text messages and the postings as well, or no?
No,
Okay.
it's just the post that was found on Sean Gathwright's phone, post-homicide, and then the message from Isaiah Chance to Alicia Andrews on or about October 7th, telling her to stay low and be loyal. Okay?
Is the court making a ruling on the celebratory posts that we're discussing that from Gathwright's phone?
Yes. I'm saying that I'm not sure that those would come in against.
But you're not ruling.
Well, I basically am. I'm telling the state they're going to have to kind of pick. So I don't, as I sit here right now, unless something changes my mind, I'm not sure that those 2 items of evidence would come in against all of the defendants. So the first one would come in potentially against Isaiah Chance regarding his conversation with Miss Andrews. And the item found on Sean Gathwright's phone would conceivably come in against him. I'm not sure they would come in against the other co-defendants if they were tried individually. And even though it's not a brutal problem, does it become a other problem, meaning it somehow significantly impacts the defenses of the other co-defendants? And I don't know, but I'm being extremely cautious, okay? So basically what I'm telling the state is if they really want this evidence to come in, then I would be inclined to sever. If not, then I wouldn't be. Okay? So.
And Judge, can I ask one follow-up in respect, or in regards to that? If you are inclined to sever, would it be picking more than one jury at the same time or separate trials?
Well, that's a good question. Probably more than one jury. I gotta think about it. So it's kind of an open question mark at this point, but I'm not sure. Okay? So. State, you want some time to think about it and let me know?
Yes.
Okay. All right, so how much time do you need to respond? You want to file something?
Yes, Judge.
Okay.
Judge, can we have we need to talk about it and
Sure.
have till next week.
Okay, sure, that's fine. To next Friday?
Yes, Judge.
All right, so you guys have until next Friday, the 13th, just to file something. If there's additional case law or additional argument you want me to consider, but you know my concerns.
Yes, yes, Your Honor.
Okay? Okay. All right, I think that's it for today. We covered everything?
I want to put something on the record, Judge.
Sure.
Judge, I had previously asked the court whether or not I could argue the supplemental memorandum as it relates to severance, and that was mainly, I argued extensively last week with regard to the grounds for severance, and the court has my motion that's, whatever, 35 pages long. And that should be an amended. I hope the court has it amended.
Yes, yes, an amended, yes.
So, Judge, essentially, I just want to say that at the conclusion of the severance hearing, the court didn't issue a ruling, still hasn't, obviously, taken it under advisement, but indicated a concern or a question to me as to whether or not pre- and post-conspiratorial evidence may be admissible against all defendants if the court determines that it's inextricably intertwined. And also asking, is there some case law or is there a position in the law as it relates to co-conspirator statements versus co-conspirator evidence? And I'm not going to argue the supplemental filing. I think it speaks for itself.
Okay.
It identifies case law. I will tell you, in my opinion, there's not much Florida state court law on it because I think it's a settled issue. There is some federal court law that I've cited to the court, and I know the state differs from me, and she has made that plainly clear in her response. But to the extent that that an act or a declaration should be separated and should be considered under different theories, I think is not the case.
Okay.
And so I would suggest to the court that for as long as I think we all should remember, the law clearly establishes that acts or statements of a co-conspirator are only admissible against another co-defendant if those acts or statements are made within furtherance of the underlying conspiracy. And I think that all evidence attributable to a co-defendant, but not attributable to Mr. Murphy, that especially falls outside that conspiratorial range. Because every one of the things we talked about that the court has considered, we are still in this post and pre, and we're also outside of that temporal range, and also discussing an act or a statement. And I think the memorandum sets out, in my mind, what is required, what the case law says, and how it establishes that the spillover prejudice that will exist, and despite any instruction from the court, by the way, despite any limiting instruction, the damage would be so significant that I don't believe a jury could compartmentalize in that particular circumstance. And as it relates to the state's response, Judge, I'm just going to say, generally, the crux of this issue is that the state, when it applies a co-conspirator rule to only hearsay, the rule has existed for decades before the hearsay rule was created, and it was never limited to statements. The hearsay rule merely codifies the existing law as it applies to hearsay. And other acts committed by the defendant may be admissible in conspiracy cases to show the evolution of the conspiracy. The key is that those should be acts by the defendant. It has never been applied that I'm aware of to a non-participating co-defendant. And that's just my response to the state's response, if you will. Thank you, Judge.
Okay, thank you. And the clerk just asked me, Rashad Murphy's fourth motion in limine, did we discuss that? feel like we did, but maybe,
We did, Judge.
We did, Your Honor.
hold on, I'm looking for it. The 5th, I have the 3rd, where's the 4th?
It was a short motion concerning opinion evidence,
Oh, that's
and
it?
I cited the Bentley case.
Okay, I got that
Warning
one.
prior to the.
Yeah,
The second
yes.
one that I saw.
Yeah, there's the second, the defendant, Rashad Murphy's second motion in limine,
No, Judge, you see number 13 on the sheet that I gave you? Number 13?
yes?
That was a last minute, like one at the bottom, but we had already addressed the fourth one with the opinion. So I
Okay.
wasn't sure if we needed.
All I see is Rashad Murphy's fourth motion in limine. Have I not ruled on that
Yeah,
yet?
but that was a ruling on number, that was the same one. See, now I can see. It was the opinion one, I thought, but then that was number 11. You see
Yeah.
number 11,
Yes?
which is like the same motion, but. they
Yeah.
were- is it
I
just
think,
up there?
yes, I think that's just a typo from the state,
All right.
in the state's
was
master
granted.
list.
Okay,
Yeah,
Well,
yeah.
then I got it then. 'Cause
Yeah, yeah.
I wasn't sure about that one.
Okay, yeah, that's just a typo.
Okay.
So, and then I did, and if I didn't officially state it, Isaiah Chance's motion to adopt and conform applicable motions of all co-defendants, that's granted,
Okay, thank you.
okay?
I got them all.
Okay, all right, well, very good. I will take a look, again, at the updated case law that you've provided me, as well as the state's response, and then I will await clarification from the state regarding the items of evidence that I have a concern about, and then I will issue a ruling, okay? Okay, I think we're done for today. All right, very good. Thank you.
Court adjourned.
All right, so that is going to end our coverage for today. But tomorrow, join us because we have 2 more hearings from March. Hello, Super Bowl. 2 more hearings from March. And then I got one from April. But then we're going to do Alicia's testimony. We're going to check out Alicia's testimony. Here's my timeline again. We've been talking about our timeline. So, yeah, so we're going to play Alicia's testimony. We're going to have enough time to play Alicia's testimony, and then we'll go. Openings are scheduled for Wednesday. Openings are scheduled for Wednesday. So, appreciate you guys hanging with us. Hit the like button. If you haven't already, hit the like button. Answer the poll. Let me end our poll here. Let's see what we got going on here for our poll. All right, hold on. All right. So we got 962 votes. Appreciate that, you guys. And how familiar are you with this trial? Pretty familiar. 42% of you said pretty familiar. We got 20% saying I know nothing, 20% saying I know the headlines, and 18% say I know it like my favorite song. So that's good. We're going to learn together. We're trying to give you guys as much background info as we can, so that we're all ready for the trial when it starts on Wednesday. They've been in jury selection for a while now. They started on the 8th, so it's been 2 weeks of jury selection. So, all right. Tia, thank you. It was great chatting with you guys. Perfect timing before the trial. Appreciate that. Austin Gardner, thanks for a great chat. Very informative. Yeah, there was, let's see, we covered that. We talked about that. That was Spaz. That was Spaz that was shot before after. I think it was after the high school. It was after the football game. There was a couple shootings. There was one at a football practice, and then there was one at a football game. So that was Gerard Adams, or Spaz. And Alicia talks about that. Or I remember they talk about that in her trial. Reigns' football game was where the Murphy family members got hit by Bibby or Kenny Caps. Well, let's see. Well, Bibby was gone in February. So was it before? It must have been before. Was it 2018? Thank you, Kaylee. Appreciate that. All right, so Robert Howard is Kenny Capps, and he's the one that he gave conflicting testimony or conflicting statements to law enforcement for the night of. One time he said he was in Julio's car and Charles's car, and the other time he said he was in. There were two other cars. I'm not sure. Was he with? I forget which car did he say he was in. Oh, Armani. Okay, so he's saying he was in Armani, which is Julio's girlfriend. First he said he was in Julio's car, but then he was saying he was in Armani's car. So there's some conflicting testimony that he has. I'm sorry, statements, not testimony, statements. Hey, Grampy, how are you? Good to see you. Yeah, Raines is a high school. You guys know more about it than I do, but it was a high school football game. There was a practice, there was a shooting, and then there was a football game. Now, Spinabens is Noah. That's Noah. That's Noah Williams, is Spinabens. And then Reginald is Wappa with the choppa. No, I mean football, American football. Lazy boys, American football. Grampy, are you spamming us? Are you spamming us with Super Bowl? Yeah, Raines is a high school. Who they were? I forget who they were playing right now. I'll look that up. I just read that like earlier today who they were playing. Anyway, there's so much, you guys. There's so much information. I mean, you guys that are living this, know more than we do. We're just coming in peripherally, and we know as much as we can about it just to get you guys prepared. But you guys that are living in Jacksonville, definitely let us know. All right. I think we're going to call today here. We're going to call today here, and we're going to end our stream. And so this was day 3 of our pretrial prep. Join us tomorrow. We're going to go on at 9 o'clock tomorrow. We're going to show a couple more pretrial hearings. Then we're going to show Alicia Andrews her testimony when she takes the stand. And then Wednesdays are openings. I'm not quite sure when they start. If it's 8:30 or 9, we'll find out for sure. But either way, we'll go on a little bit before just to talk about it some more. So really appreciate you guys spending time with us. Thank you for spending your day with us here. Thank you to our mods. Thank you to Aaron. Appreciate you guys keeping chat courteous and respectful. That's what we do here. We don't attack each other. I know we have difference of opinions, but we do ask that you guys respect those opinions. And if you need to take a break, step away. But come back and just know that we do have guidelines, but seems like generally you guys were really good today. Really appreciate that. And that's all we ask, is just be respectful and courteous of each other. And as always, I will show Super Bowl. Grampy loves his Super Bowl. Yeah, it's a good girl. Yeah. As she bites me. You come say hello? All right, come say hello. Say hello to Grampy. All right. With tail in my face. All right, you guys. Thanks for joining us again. We will see you tomorrow. Let's see, 9 o'clock Eastern. We're going to start at 9 o'clock Eastern. So until then, have a great night. Take care of yourselves, and we will see you then. Thanks again. Bye.